Welcome to Looking at Legal Stuff. Today we have 12 hearings covering the high conflict divorce of a couple where dad was accused of having substance abuse issues, which he denied. But when he finally takes a hair follicle test, his results end up being positive. This leads to a back and forth battle with mom and dad's attorneys fighting over every aspect of dad's supervised visitation, until Atty McLean accuses mom and her lawyer of trying to keep the child from dad indefinitely. We also have the same judge for all 12 hearings this time, and she gets pretty frustrated over the constant arguments and makes sure to tell them so. Let's watch.
All right, good morning. If we could go on the record in the courtroom, please.
We are on the record.
Thank you very much. Good morning, everyone. We are here in 233-0017408, Wishard v. Wishard for temporary orders. Odyssey is back up and running, but I also received your emails and I reviewed everything and actually had pretty significant notes in Odyssey about this case, which is probably why I couldn't remember anything on Tuesday. So I feel ready to go this morning. I will start with you, Ms. McLean. Good morning.
Good morning. And again, thanks for accommodating us today off of your normal docket.
Sure.
As you can see from the documentation, this is a short-term marriage at 3.5 years. These parties have one child born as issue of their marriage, Addison, who's currently 3 years old. Obviously, the main concern for my client is that his relationship with his daughter is currently being disrupted by Ms. Wishard through her withholding of the child since their separation. As he told you in his reply declaration, he's now been allowed essentially 4 phone calls with his daughter. And it's undisputed, even in Ms. Wishard's reply documentation, that one, she did allow at least those 4 phone calls, and it's undisputed that it was emotionally difficult for Addison. Addison was asking to see her daddy. She was asking to go home with daddy right now. She's asking to go home to grandma's house right now, which speaks volumes of her relationship with her father and the fact that she misses her father. It's at this point our concern that Ms. Wishard continues to willfully withhold Addison, is clearly that's not in the child's best interest. And it is very damaging to interrupt a healthy parent-child relationship. Even the statute talks about having consistent contact with parents, and the fact that the child is asking for this is significant. You'll see, obviously, you've seen in the declarations that Ms. Wishard and her witnesses have gone to great lengths to try and villainize Mr. Wishard for his past drug use, which was years ago and before Addison was born. Mr. Wishard acknowledged that he was hooked on prescription oxycodone and that he did use Suboxone to come off of that. That was about a 7-month process in this man's entire life. He acknowledges being clean and sober from the oxycodone and Suboxone since Addison's birth. And Ms. Wishard attempts to suggest that my client's grandmother, for example, provided him marijuana in the hospital, which has clearly been denied. My client tells you he has never used heroin. He has never used fentanyl. He has not resumed his Oxycontin or oxycodone use or Suboxone use. And there's absolutely no evidence to support those claims. My client does tell you that both of these parties have used alcohol and marijuana socially and or recreationally. But clearly at this point, our position is that there is insufficient evidence to support a finding that my client is actively using drugs or has relapsed on the oxycodone and Suboxone. And we're asking that the court, again, grant residential time with my client. If anything, given the information from my client about both of these parties' recreational use, if you are inclined to impose restrictions on use, it should be mutual. Same with the concerns about my client raising the issues of corporal punishment. You'll see in Ms. Wishard's declaration and her proposed parenting plan that she's proposing that there be a corporal punishment restriction against my client, and yet there's no claim that he's ever used corporal punishment on Addison. However, Mr. Wishard tells you specifically about incidents with spoons, him having to intervene because Ms. Wishard had actually Addison's fingers, him coming home to find spoons upstairs, a wooden spoon and the like, which historically has been Ms. Wishard's method of punishing Addison. His position is obviously he's now not in the position to be able to intervene, and there should be a mutual restriction that there is no physical corporal punishment utilized by either of these parents or by any third party on behalf of these parents. And you see that specifically in my client's proposed parenting plan. Ms. Wishard attempts to paint Mr. Wishard as a domestically violent person. However, there have been no police reports, there have been no doctor reports, there have been no arrests, there have been no protection orders filed. Ms. Wishard attempts to dovetail an incident with my client's sister, Sierra Wishard, and her neighbor by falsely stating that Mr. Wishard threatened to shoot the neighbor and that he had slashed the neighbor's tractor tires when the tractor was left on his sister's property. Ms. Wishard was not present for that incident. She has no firsthand knowledge. Sierra Wishard was present for that incident. This involved her neighbor, involved her brother, Mr. Wishard, and she tells you specifically that the police were not called on Mr. Wishard. They were called on the drunk neighbor who was threatening to get his gun to come and assault them. She also tells you she knows nothing about tractor tires being slashed. So the concern is the level of false narratives being presented in this case in a desperate attempt to, again, remove this child from a loving, involved, and devoted father. Mr. Wishard has not helped himself in this case. He has not gone over to the home and demanded to see the child. He's come to court. He's asked this court for relief. He's not the ogre that they are attempting to portray him to be. And in fact, all of Mr. Wishard's witnesses, his grandmother, his cousin, and his sister, talk about the loving and bonded relationship that Addison has with her father. The social media posts by Ms. Wishard speak of the good father that Mr. Wishard is with Addison. The photos show his involvement with his child. He is an engaged father. He is not an absent father. Mr. Wishard and Ms. Wishard agreed for him to change his work schedule from a traditional work schedule of Monday through Friday to the 4-on, 4-off work schedule that would allow him to be home 50% of the year. That's because they wanted to have that more time for family, the more time that she was demanding of him, and to allow him to be more involved with Addison. You know, one of the claims is she says, well, he's not gone to the most recent doctor appointments. It is not uncommon to tag one parent for doing those types of parenting functions, particularly when you have one parent that's not currently working and one parent that is working. That does not equate to Mr. Wishard being an absent father or Mr. Wishard being reluctant to participate in those types of parenting decisions. What it means is that they as a family decided that it was a higher priority for him to continue to be a financially supporting parent, as he's currently the only financially supporting parent. But again, the twist from Ms. Wishard is that you should conclude from that he's an uninvolved father. And we would ask you to look beyond that and look to the realities of family circumstances and the decision for him to change his work schedule so that he would be home 50% of the time. again, I think that in and of itself also talks to his involvement as not only a father, but as a husband. He has now started that 4-on, 4-off work schedule at the beginning of this year. So he works 2 day shifts, and then he works 2 graveyard shifts, and then he's off for 4 days. So for example, his last graveyard shift was today, if you review through the work schedule that we attached to his declaration. He typically would sleep until noon following his graveyard shift, and he's asking to be able to pick Addison up at 2 p.m. following his graveyard shift and have her until, I believe it was 5 p.m. the day before he starts his first day shift. So today, he would like to be able to pick up Addison at 2 p.m. and have her for his 4 days off and return her the day before he starts his day shift. And I'm sorry, that's at 6 p.m. is what our proposed parenting plan provides for. We are asking for mutual provisions of no disparaging remarks by the parents or any third parties about the parents, no corporal punishment or allowing third parties to engage in corporal punishment. And we are asking that both parties participate in the Children in the Middle parenting class. In regards, also dovetailing into that and financials, we do believe it is appropriate to appoint a guardian ad litem. We anticipate that those fees should be split proportionately. And as we move into finances, we did provide the 2022 tax return as well as the current wage stub for my client. As my client tells you, of course, Ms. Wishart is attempting to inflate his income with his current wages. As a result of moving to this 4-on, 4-off schedule, he had a 60-day training period where he tells you that essentially he was working 60-hour shifts for the first 2 months. His normal shift is 4 10-hour shifts, so that would be 40 hours. But I'm sorry, I believe it's 4 12-hour shifts. So it's 48 hours and then 4 off and then 48 hours. So it depends on where the shifts land in the pay week as to how much overtime he may have. I believe typically that it rolls around as 1 week he would be paid 36 hours and the next week would be paid, I believe it would be 52 hours if my math is right. And that would be that would include overtime. So there's shift differential and overtimes. But the fact that they're attempting to use his current wage stub when he's working 60-hour shifts right now because of training, that is obviously artificially inflating his income. The reality is that the family decision for him to move to this schedule is actually a result of a $5 per hour pay decrease to him to go to this schedule. And so I have used his 2022 taxes as well as his current hourly rate in arriving at the figures that I used. And so at this point, his net income, I've calculated now that he's working his 48 and 48 is $5,698 per month. As it relates, these folks didn't separate until March of this year. So Ms. Wishart has already benefited from the boon of him working those 2 months of 60-hour shifts. She was there, they were in an intact marriage, they had those finances available to them. And in fact, when they separated, she removed essentially 2/3 of the liquid assets that were contained in the bank accounts. We provided documentation and verification that she removed $11,607 from the joint accounts, and she left my client with $6,000. So our position is that the court should consider those the finances that she has had, and when taking into consideration her request for attorney's fees and spousal maintenance. I would also note again, when you look at his 2022 taxes, he did gross in 2022 $95,862, which is the best information of his income at that time. And again, we expect that his income will be lower now that he has transitioned to this new wage. We do believe that it is appropriate to impute income to Ms. Wishart. She has previously worked as a CNA, earning $16 per hour in 2019, which was well above the minimum wage at that time. She is, I believe, only several hours away from having a degree. She has provided minimal information about efforts at securing employment, but certainly she could go to work today as a CNA and has chosen not to. In addition, she's currently living with her parents. So when you look at her financial declaration indicates that she has anticipated expenses for rent of $1,300, utilities of $180, daycare at $800, and she also suggests $150 per month in tuition, but she provides absolutely no proof in regards to that. So if you take into consideration those anticipated expenses, that would reduce her need to $650 per month, which can be met by her obtaining full-time employment, even at current minimum wage, without using her CNA certificate. We believe that the court should, at a minimum, set her imputed net income at $2,349 per month. Given the residential schedule that we are requesting, we are asking the court to set child support at $250 per month. The basic support would be $856.96, and that takes into consideration the fact that Mr. Wishart is currently paying health insurance for the family. The cost of that health insurance, and I'm sorry I didn't get that in my notes, he pays $538.71 per month through his employer to cover the family on health insurance. $213.08 of that is to cover Ms. Wishart alone. That has not been included in the calculations for child support. The cost to cover Addison alone is $144.33, and that has been included in the child support calculations. And we've filed the documentation under sealed financial support, under sealed financial source documents supporting those figures. So given the fact that Ms. Wishart currently is voluntarily unemployed, the fact that her expenses are not factually as she claims, the fact that we are again asking the court to provide for substantial residential time with my client, we're asking the court to deny her spousal maintenance request, again, since it is a short-term marriage. We're asking the court to deny the attorney's fees request, and she already helped herself to $11,000. And we're asking that the court proportionally split, based on our calculations, the cost for uninsured healthcare expenses and for the guardian ad litem fee. When you take a look at my client's financial declaration, not only does he have the monthly healthcare expense, he also has a vehicle payment of $526 per month. I also note that there's an issue brought up about the property transfer, the real property transfer. My client purchased 5 acres of land outright prior to these parties, I believe, even dating. The property was logged before, I believe, they were married. My client and his parents have been the one to maintain that property. Quite frankly, this is an issue that is not going to be, shouldn't be dealt with on temporary orders. This is an issue where we need to provide the discovery and preserve those issues, obviously, for the time of trial or settlement conference or wherever this thing ends up. But I don't think that that's properly before the court on a temporary basis. The basic tenets that we're dealing with are, this is a short-term marriage, and the court is inclined to place parties in the position that they were in at the time of the marriage. At the time of the marriage, my client owned property outright, his separate property, and likely the court would place that property or maintain that property with my client. If there is a claim of the community having expended funds in this property, currently there's no proof of that for purposes of this hearing. And again, that's something for purposes of discovery. So we're asking the court to adopt our temporary orders and start my client's visitation today at 2 p.m.
Thank you very much. Ms. Baldwin, whenever you're ready.
Thank you. And again, for the record, I represent Kylie Wishart in this matter. She's the mother of 3-year-old Addison.
Oh, I'm sorry to interrupt. Apparently my client is sitting in your wait room.
I don't have anyone in my waiting room.
I wonder if he's sitting on the presentation docket. If you'll give me just 1 minute so I can tell my staff that and tell him,
Sure.
ask him to go down to the Wishart. Okay, they'll send him the new link. So if you get a chance to keep an eye out for that, I'd appreciate it.
Sure. Do you want us to pause until he's in, or?
I think you're fine.
Okay, I'll just keep an eye out. So go ahead, Ms.
Thank you.
Baldwin.
Thank
All
you.
right, very good. So the first thing I want to address is the parenting plan. In this case, we have Mr. Wishart, who has an admitted addiction problem. The question isn't whether or not he's addicted to substances. The question is potentially how long was he addicted? What were the totality of the substances? And is he still using them right now? The lack of something can be evidence. And in this case, it's a glaring red flag. We know that Mr. Wishart was offered to take a free hair follicle test, and he said, no, thank you. And you only do that.
Yeah, I guess I would interpose an objection. One, because that's for the court's determination, not for Ms. Baldwin's.
That's not a valid objection to an argument.
I think it's implying a conclusion for the court.
Again, that's just interrupting my argument.
Go ahead, Ms. Baldwin. I understand your position, Ms. McLean.
Thank you.
So in this case, again, we have Mr. Wishart who says, yep, I have an addiction history, but provides you with zero evidence he is clean today. He is not clean today. And we know that because if you're clean, you say, here's my clean date. You say, test me, I'm an open book. You say, here's the treatment I did. And he has none of that. He comes today with, I would say, hands that he won't even show you. So it's not unclean hands, it's hands he's hiding because he knows what, if you were to look at those hands, what they would show. And we know that again, because he simply just refuses to provide the information that would tell us point blank what he's using and what the quantities are that he's using. This isn't vilification. My client wants him to get well. She wants him to be clean. He's just not. And that is the key thing here, is that we're dealing with someone who says, just trust me, I'm clean. You know what you don't do? You don't trust an addict. That doesn't make any sense. The reality is what we should do is we should enter an interim parenting plan where we provide some kind of very limited, very supervised situation, have Mr. Wishart comply with the drug test that is still waiting for him to take for free, and then come back and see what that drug test shows, because that is a critical piece of information that's going to have just essentially dictate a lot of where we go from here. It should have been done prior to today. There was ample time to do it prior to today. He didn't because he knows what the result would be. My client indicates he has longstanding problems, not just with the drugs he's referenced, but also with Oxycontin, Suboxone, fentanyl, and alcohol. She states that this addiction has been ongoing from 2019 to now, so a 4-year pattern of addiction. Says it cycles. There were periods where he got a little bit better. There's periods where he definitely got worse. She shows you photos showing some fairly dramatic weight loss. She indicates in 2020, he took her on a drug buy that she wasn't even aware that's what was happening, but he later admitted to her, yeah, sorry, you were in the car when I popped into that house and purchased drugs. We have the indications of him abusing alcohol and directly around the child and when he's transporting the child. And again, deep concerns here. There's no treatment on board whatsoever. It's just, trust me, I got clean on my own. That's very rare. So there's nothing that indicates, again, that he's had any sort of formal evaluations or treatment. This is somebody with a polypharmacy problem. He has a great risk to the child, and he's in active denial. In this case, that makes him unsafe. When you say, I don't have a problem, but don't test me. Domestic violence is a problem in this case. Again, we have significant indications of domestic violence. We have him using a gun to make threats against a neighbor. And my client says, because that is the level of violence he's willing to raise to. So this is a situation where we have a neighbor, and my client says, no, it's part of her declaration. She has firsthand knowledge of this. Even if she wasn't present, you can still have firsthand knowledge in different ways. And so, again, that's the level of violence he's willing to get to, even with just a neighbor. We have him admitting to having a temper in Exhibit D as a sort of deflection of, I've engaged in this domestic violence behavior. It's just a temper. So it's him deflecting, again, that anger. We have him being physically abusive with my client, punching holes in walls, hitting and slamming the counter in anger, pushing her, grabbing her, throwing things. We see him admit those things in Exhibit E. So this isn't he said, she said. This is she said, he said it too, because he's admitting those things in Exhibit E. And again, when we look at those, classically, when you look at Exhibit F, he then blames her. You shouldn't have done this, or I wouldn't have gotten mad. It's your fault that I hit the wall because you did X or Y. And that's classic domestic violence behavior. Then you see at G, the apology. This is absolutely in that cycle of violence. Then G, I'm sorry I made you afraid. I'm sorry you were scared of me. She was, validly so. If you're the kind of person who's going to punch a hole in a wall and threaten a neighbor with a gun, my client had every reason to be afraid of him. And again, when he's pushing her and grabbing her, then again, you see further indications of domestic violence. When it's clear that she's not coming back, what does he do? He financially then tries to handicap her. My client says, I left. I had essentially the small amount of monies that I had in my pocket. I tried to get myself a credit card, got it, and then he closed it so that I wouldn't have further access to funds. Again, a very classic domestic violence move of, let me block you out from being able to access funds and access things that you need. So again, this is domestic violence. This is the cycle of violence. And we have it here in black and white in his own texts to her. These are his own words that prove that he is somebody who is engaging in these behaviors that are classically domestic violence. Given that, the court, given these two very significant concerns, the court should order both a substance use evaluation as well as a domestic violence evaluation. Those both should be by Washington State certified providers who are located in Washington. I'm not going to dictate who, just it needs to be somebody in Washington, so we're not shopping for somebody in Michigan to give them the result he wants. My client does have concerns about other abuse of the child. She indicates some of the history that has happened that she's seen between Mr. and the child directly. Again, concerns. My client indicates in the child's areas, concerning statements from the child, Mr. viewing and using it for gratification. My client says, I don't know. She says, I don't know what's happening here. This could be something, this could be nothing. They are red flags I want the court to be aware of. So my client is very careful as she's not trying to make a specific allegation in that vein, but she also wants to make everyone aware of those red flags, and those can be directly related, frankly, to the substance abuse. Getting into, again, who's primary parent, it's very clear. My client's a stay-at-home parent. Mr. admits to working 60-hour work weeks, so we see that in Exhibit I. Counsel tries valiantly to sort of defray, well, he just started this job January 1, and these were transitional hours. The text that indicates 60-hour work weeks is from the end of March. If it was 2 months of training, that would have long been over by then, by the time that that text message happened. So the timeline that counsel tries to lay out just doesn't line up with the facts of the case. So again, Mr.'s working 60-hour weeks. He's just not home to be caring for the child. He's not part of the caring routines. My client is very clearly primary parent. And when my client says he's really uninvolved, even his texts reflect that. His texts reflect him talking about even when he was home, not being left alone with the child. And again, my client says that occurred because of the concerns, as he wasn't able to manage his anger and outbursts around the child. My client always had to be there to be the person in the middle to sort of protect the child from that. Again, evaluations here are more than appropriate. We also ask that the court should appoint a guardian ad litem. Most assuredly, the guardian ad litem should have the right to order additional evaluations as they see fit as well. The real property transfer in this case, it's referenced not because I anticipate the court doing anything with that today. That really is a trial decision. It's here because it's fraud. And when you have a party who will transfer a significant asset to someone else for $0, it's an indication of somebody who's going to be dishonest, and they're willing to do that, frankly, right up front. And so again, this is really a fraudulent transfer. It hits at the heart of each party's integrity. As far as, again, spousal support, my client's a stay-at-home parent, not denied. She's been a stay-at-home parent for years and years at this point. My client indicates she's returning to school. She's doing everything that we want the court, everything the court would want her to do to become self-sufficient. That doesn't mean she's self-sufficient now. She does not have a Washington State CNA license. We provided that documentation. So again, she's trying to get her degree back on track, but she does need spousal support. Mr.'s year-to-date income. So again, we're not trying to place Mr. in an untenable position, but we have to be real about what his income is. And his year-to-date income through March was over $30,000. Simple math. It takes you to gross monthly income of $12,600 with a net of $9,700. So again, he is trying to get himself a $4,000 discount off of what the documents show his actual income is. Even if you were to take his straight time, it's still more than counsel puts her child support worksheet at. So again, this is just a real bold-faced attempt to reduce his income. Again, Exhibit I, if this claim is he was only working these hours for January, February, that just doesn't comport with Exhibit I, his own statement that he was still working 60-hour weeks, and counsel's statement that it said, counsel kind of went back and forth and said, well, he's still working those 60-hour weeks. That would indicate he's still working those. He still has this level of income. My client's income is zero. She should be imputed. I think it's important. I think it's reasonable to impute her at part-time because again, the expectation is that she go back to school so that she can get a degree so that then she can be reasonably employed. As far as spousal support, my client is asking for $2,000 per month. She has expenses of about $4,000. Again, those expenses do reasonably include housing. It shouldn't be that she has to live with her parents because there is no other option. Not when support could facilitate that. But even at $2,000, that's not really meeting a rental payment and then extra money to live. It's meeting one or the other, not both. So at $2,000, that gives her money to support her and the child, even if she's living at home. So that is a reasonable amount to provide. And it's reasonable even if you use his child support worksheet. Let's use his child support worksheet. Take Mr. down to expenses of, he says his expenses are essentially $4,900. Take out housing expenses because he's living with his parents. That takes him to expenses of $3,500. His income per their own worksheet is a net of $5,600. $5,600 minus $35, he has the money to pay $2,000 essentially without feeling it at all. It's reasonable that my client be awarded spousal support on a short-term basis because again, she's been at home. She has no licenses to be able to go out and reasonably get employed. As far as child support, again, we're asking the court to adopt our child support worksheet. That would put Mr. at a net of $9,724. My client at part-time minimum wage. Whatever the court orders on spousal support should be included in that worksheet. And that would give the ultimate child support number. Again, Mr. admits in the text messages he's been the sole provider, that he's working 60-hour weeks. So again, this is a case where really those facts are undisputed. He just now says, well, I just want you to sort of kick her out and make her go work at Burger King. That's not really in anyone's best interest. They will spend as much as my client will make on daycare. As far as debts, what we're asking the court to do is each party should be responsible for any new debts that they create. Mr. should be responsible for any community debts at this point. He's the only one with income. So he should be responsible for all community debt. There does not appear to be a significant amount of community debt. As far as assets, each party should keep what they have in their possession now, with these specific caveats of my client should have the Toyota, that should remain in her possession. I believe she does have that. And the child's items should be returned to my client as the primary parent. Mr. took a significant amount of them before my client was able to leave the family home. She just wants those items returned. As far as taxes, the parties should file jointly for 2022 and split any of the proceeds equally. Those should just be, both parties should participate. They should file their taxes, equal split. That shouldn't be held. It's not going to be so great a number that we should hold that in trust. Thereafter, beginning for the 2023 tax year, my client should claim in odd number tax years. Mr. should claim in even number tax years. The court should assess attorney fees. There is a broad disparity in income between these two people. At their separation, my client got essentially $10,000. Mr. got essentially $5,000. My client says, yeah, but then I paid a bunch of community bills, which he doesn't dispute. And then it's been March, April, and May. So then the remainder after she paid a bunch of community bills has lasted for 3 months. There's nothing left. So it's reasonable that the court award attorney fees in this matter, especially where one client or one party is well employed and the other party is not employed at all. So we are asking the court to adopt our recommendations in this case, award spousal support. Again, I think the most prudent thing on the parenting plan is order Mr. Wisher to obtain the hair follicle test that is sitting and waiting for him and has been for quite some time now. Order he do that today without any further delay. And then review this essentially in 2 weeks or the next available docket so we can see what Mr. Wisher is actually using. I think that that'll give the court the critical information that it needs.
All right, thank you.
Are you opposed to just some very brief reply?
Brief, go ahead.
So first off, counsel argues that his wage stub suggests he's still working 60 hours. If you look at the wage stub provided under sealed financial source, it shows that he works 60.76 hours. He's paid every 2 weeks. So that's a 2-week time frame. That does not equate to counsel's argument that he's working 60 hours a week. That essentially shows that for that time period, he had 30 hours essentially a week. And if you look at his net was $2,210. If you times that by 26 pay periods a year, that equates to $4,788 a month. In regards to the suggestion that Ms. Wishart has paid community debts, there's absolutely no proof that she's paid any community debts from the $11,000. The only debt that she currently has is her vehicle, which is I think $270 some a month. In regards to the personal property items for the child, my understanding is that those had already been divided. She had taken what she wanted. In regards to the 2022 taxes, we filed that under seal. The parties already filed those. Those monies had already been deposited into their joint account and is part of what they have from the savings account when she took the $11,000 and my client was left with the $6,000. We would ask that you reserve on any future allocation of the child for purposes of taxes, because who knows what's going to come up this year. We still have 7 months to go. In regards to the suggestion that there's some nexus between drug use and child abuse, there's absolutely no record or suggestion that this child has been seen by a physician. There's no verifiable evidence that my client is currently using. Keep in mind, when they did this intervention last year, my client came back from her parents' home and continued to live with my client and was talking about having another child. That's not consistent with somebody who thinks that somebody is abusive and somebody's continuing to use drugs and alcohol. So we would ask that the court not order these intrusive evaluations, not order the intrusive drug testing. Clearly, we don't think that there's evidence that supports these claims. And again, firsthand witness, Sierra Wishard was present, and the police were not called on Mr. Wishard. He did not make threats. It was the neighbor.
All right, thank you. So the notes when I reviewed this the first time, obviously when just reading through everything, short-term marriage, small child, lots of accusations of issues with temper from dad, request for no visitation until treatment. He's requesting 50-50 plan. We need a GAL. I made a lot of notes on this case, and there's a lot of back and forth. I think on one hand, the argument that well, Mrs. never called the police, or Mrs. never did this, and now it's all coming out at a potentially advantageous time. I understand that argument. I also understand the argument that there were attempts to remove herself from the situation, and they were thwarted, and there's some track record of kind of the play within a what could potentially be seen as a classic domestic violence situation. Obviously, there's concerns here. I have concerns with the accusations against dad and some of the information that was provided as part of that. But I also am concerned that there's been no visitation. So I'm in between both of you. So here's what's going to happen. I'm going to order visitation start, but it's going to be a supervised visitation. That if there's a parties can agree on a non-professional supervisor, that's great. If not, and I guess I would give the parties maybe a day or two to figure that out. And if they can't figure that out, then it moved to professional supervision. I don't want delays in visitation because we can't agree on somebody. And
Is there any reason why it can't be my client's parents since he's living there?
My client would sorely object. Her statement is that it wasn't the grandmother that brought drugs to the hospital. It was his parent, his mother. So I'd like an opportunity to see if we can find somebody else that is more neutral between the parties.
So, and I assume there might be some issues there. So that's why I don't expect counsel to work through the weekend. I understand Mr. has 4 days off, essentially starting
Today.
right now. So today's Friday, Saturday, Sunday, Monday. So if there's no agreement by Monday morning, then it should be a professional supervisor. And then that gets scheduled and take place as soon as possible. I am going to have that be for a minimum or up to 4 hours. I am going to order the hair follicle. I think there's sufficient concerns that have been raised. So I'm going to order the hair follicle. Once I get the hair follicle test, essentially I'd like to come back and review moving that visitation to unsupervised. If that hair follicle comes back clean. I'm also going to order the domestic violence evaluation. And I am going to appoint a guardian ad litem. And essentially, once the domestic violence evaluation, and I'm going to request a kind of a quicker turnaround for an interim GAL report on child safety concerns, then I would be looking to increase visitation at that time, assuming there's no issues. So I want to move into this slowly, but I and I recognize the concerns, but I don't have enough concerns to say dad doesn't get visitation until all this is done. Dad needs to get visitation, and that needs to start as soon as possible. So I'm gonna, and I have, just so everybody knows, I have proposed orders from Miss McLean. I'm happy to work off some of those, for, if there's agreement. I don't know if like any of these will apply because I'm sort of going against both of your requests, but, as far as a GAL, I guess, Madam Clerk, if we could have the next 3 names on the list.
The next 3 names are Keith Lawrence, Heather Kale, and Amy Turnbull.
I'm sorry, who was the second one?
Heather Kale.
I'm not familiar with her. Okay,
I think Ms. McLean strikes first.
okay, Keith Lawrence.
I'll strike Ms. Turnbull.
Okay,
All right, so the middle one. Sorry.
Yes.
Yeah, Kale, I think you
Kale.
said the last name. Okay.
Can the clerk spell the last name for us?
Kahl. And she does pronounce it Kale.
Okay,
Okay.
thank you.
All right. I am going to order interim child support, and I am going to give, essentially make it family support, but it's going to be for a short period of time, and that's going to be $2,000 a month. And I'm going to review that essentially at every review we get, we go through to see where we're at. And I'm choosing that amount because I am adopting the, I'm calculating support essentially at 900. So between the 2 worksheets, it was just over 1,000, just over 800. So I'm kind of landing in the middle there because I've seen everybody's financial worksheets. And then I'm including about $1,200 or $1,300 for spousal support in the interim. And as I said, that it's going to be a short term. I'm choosing that number because there are insurance costs, and I am going to order any mutual debt to be paid by the petitioner in the interim as well. So that kind of offsets the request.
so at this point, the only mutual debts that I'm aware of are both of their vehicles. Is there some other debt that I'm not aware of?
I think it's the vehicles and the insurances.
And then each party, it sounds like they've each taken a vehicle, so they should keep the vehicles that they have. Mutual or any debts that they occur moving forward will be their own debts. No disparaging remarks. I know I'm jumping all over here, but my notes are kind of all over. No disparaging remarks about the other parent or family in front of the child. I think it's very clear both parties' families are highly involved in their lives and the children's lives. So I'm kind of expanding that. So they'll be on the parents to sort of monitor. I think it is appropriate that both parents take a parenting class. And if, frankly, I think counsel would be more knowledgeable in that area about which kind of program or class would be best for these folks with their first child, with a young child. And I don't know if most of those are online nowadays or if there's anything local, but I think they both could probably benefit from a parenting class. So I am going to order them to take one if there's a mutually agreed upon class where they can both learn the same tips and tricks, and that would be great. I'm going to order that there's no consuming alcohol or marijuana within 8 hours before or during any visitation by dad or any other illegal or non-prescribed medications. And frankly, again, I would probably defer to counsel if Mr. Wisher were to take the hair follicle today, when we would likely be able to have a result from that.
Probably next week.
It
Mid-next-
realistic. I agree, like sort of, but because the holiday though, like I assume you're ordering it today. So if it's today, I would anticipate we'd get it either Friday of next week or Monday. Not this upcoming holiday Monday, but the Monday thereafter. My thought was to review on June 6th. My thought just being that I know you're going to put a lot of things over on Tuesday to
Yeah,
the 23rd.
The 30th is closed at this point. So, excuse me. So let's review it on the 6th. And if Mr. Wishart can get a DV evaluation done in that time as well, and provide it to everyone for review, I'm willing to consider that on the 6th as well. So let me make sure I didn't miss.
When do you want to set the GAL review, and when do you want to set the preliminary, the 30-day compliance review?
We need a 30-day compliance review. Both of these people are going to comply. So that doesn't give me, I just don't think that's necessary. I think more setting the GAL review when you want an interim report. I think she needs, it'll be, even if we sign that order today, 45 days, I think is still really fast, but realistic.
If we get that GAL order entered either today or by early next week, and the parties are right on top of getting their stuff back, hopefully by the 6th, we may have the GALs being able to confirm that at least she's been in contact and exchanged information with folks. And then how about a review, not July 4th? We could either do the 27th of June or the 11th of July.
Let me just look real fast.
I'm sorry, the 11th of July, is that what you said, or the 27th of June?
Yes.
11th of July works for me.
I can do either. I currently have 6 matters on your June 27th docket.
My preference would be the 11th. I think that gives the GAL just a little bit more time to be more thorough.
Obviously, my client would prefer to be able to have visitation reviewed sooner than that.
But we will on June 6th.
Well, let's go to the 11th. And if the GAL can get prepared sooner, I'm happy to consider moving it up. And hopefully the GAL will be present on the 6th so we can touch base with her.
So I have provided a GAL appointment order to your honor.
I have that. I'm assuming, Ms. Baldwin, you received a copy of that. I can
If you could interlineate her name at paragraph 3.
and Tiffany, did you say her first name is Heather?
Yes.
Okay.
Yes,
And Kahl?
yes.
Okay.
And then in light of the temporary order on spouse or family support, I would ask that the court consider at paragraph 10 that the fees be 50-50.
I think that's your call. He still makes a significant amount more, even if he's paying spousal support.
Well, and paying the community bills and the insurances and.
Before I address that, and I will address that, I am putting a 30-day review for 6/6 just on here. But I'm just going to make a note that, this date was already set by the court, so.
And you're adding the interim.
Yeah. You could add the interim on the top of page 3. I think you could squeeze it in there.
I would just do it with the 30-day compliance review language. since it's all going to be on June 6th.
Yeah, but then you have the July. I was talking
Oh,
about
yeah.
the July. hearing.
Yeah, I'm sorry.
And I set July 11th for interim.
Yes.
At 1 p.m.
And on that hearing, would Your Honor assign yourself just for that hearing? It would be very odd if we had someone else who hasn't had the experience with the file.
For the interim.
Yes.
And again, I think any judge can hear this. It just depends on what the schedules are. I don't want to be in a situation, because I'm going to be out the last 2 weeks of July. I don't want to be in a situation where this is going to have to be continued, another 3 weeks because of my vacation schedule. And
I'd move it
my
up.
denied, we won't know until 3 work days before if whether or not Your Honor would be handling the docket. We don't get interims until the Thursday before.
I should just, go ahead.
I anticipate being here July 11th. I am hoping to not be here one of the weeks Miss McLean isn't here. But I anticipate being here on the 11th, and barring me getting assigned another longer trial or something along those natures. And frankly, I'm happy to special set it again if we really need to, if that's something the parties are requesting.
Very good. Thank you.
Okay, so I made the change. I entered Ms. Cal's name. I just indicated on the 30-day review that we're just hoping to get confirmation that there's been contact with the parties, not a full 30-day review. Added the interim report for July 11th at 1 p.m. As for the GAL, I'm gonna, just for this portion, I'm gonna switch it to 60-40. So 60 petitioner, 40 respondent. And then Ms. Baldwin, in the hopes of getting this started as quickly as possible.
With those changes, I'm happy to sign, or you can write approve via Zoom. I do have a couple of questions about your order when you're ready.
Yes, go ahead.
The first is that we had asked for drug testing. That Mr. Wishart be ordered to go today, which my understanding is you have ordered that, but also forward-looking drug testing, as we provided in our proposed parenting plan. Is the court ordering that, essentially loser pays type drug testing?
I will consider that once we get our results.
And then is the court ordering attorney's fees to my client?
Thank you. I did have that, a note on that. I understand the withdrawal was a little over $11,000 approximately. When Mrs. left a couple months ago, obviously that's a significant portion of their savings, and I saw that in the financial documents. I'll order a one-time attorney fee of $2,500, and we'll give that a 90-day payoff.
At 0%.
Yes.
And then is the court ordering a substance use evaluation, or are you holding until we get the drug test back?
Waiting for that drug test.
Okay. On the domestic violence evaluation, is the court ordering collateral contact from my client?
Yes, sorry, thank you. And if the GAL is on board at that point, and has any information they feel or anything that they feel that they could provide. I understand that there could be a quick turnaround and the GAL may think, I don't have anything to add at this point. But yes, at least Miss Wishard.
Okay, very good.
And I guess my concern as it relates to the determination on supervisors is obviously if they don't agree, then we're forced into about $200 a week for professional supervised visitation expenses, which is what, $800 a month until we get this thing reviewed. I certainly am concerned about that power decision for them potentially not to agree. So I'd like to have, if possible, more of a discussion as far as who potentially the court would deem appropriate as a lay supervisor, so that we don't have to go to professionally supervised visitation.
The court's made your order and she's already tried to change it once. At this point, I think the order is clear, and it's really only 2 weeks before June 6th. So this is for essentially a 2-week period of time.
I don't even know that a professional supervisor can get him in for supervised visitation. We have to look and see what their availability is compared to my client's 4 days off.
And
I understand that. And I guess I am sensitive that my want is for him to be able to see his child as soon as possible. And so I get that concern. And to be very frank, sometimes I'm frustrated when I hear the struggles folks are having getting those visitations set up. And frankly, we've also had the supervisor, well, at least, I don't remember what it's called, the one in town here, essentially dictate how much time they're giving people, even against court order. So I understand those frustrations. I don't know. There wasn't a lot of communication in the, indications in the filings, what expanded family kind of looks like, feels like. Clearly, I'm sure people are sort of feel obligated to take sides. There was a declaration, I believe, from someone that was a mutual friend of both parties. I don't know if, that individual, and I feel like it was a female that was, her and her husband attended the wedding, and it was, and they were friends with both parties. I don't know if someone that outside of the family, like a mutual friend, would be willing to help facilitate.
Or what about my client's sister, Sierra?
and again, we just want time to be able to suss out who they're asking, and we can do that today, who they're asking to use, who my client says, hey, how about these people, instead of just sort of bulldozing through at the moment. I think it's preferable to not use a family member of either party, frankly. Both parties are going to feel like that person is picking a side. And so if we can find just a neutral third party, or again, the last case I had supervised visits on, we were able to get supervised visits started right away. So that's also an option. Neither of us have made the calls to find out how quickly we can get in that situation.
So my client obviously would propose his mom, his dad, since he's living with them, his sister. This is a huge implication on a third party. I don't think that it's appropriate to impose on a third party for, a 4-hour time period. And are we talking that he just gets that one time per his 4 days off, or is the 4 hours on each of his days off?
No, the
It's
court
4
said
hours a week, and
4 hours a week. Okay.
and yes, and I, if it needs to be all at once based on people's schedules, or if it's 2 days, 2 hours a piece. I frankly, we're dealing with adults that chose to get married and have a child. If they can't figure this out, I don't know how much they want the court to dictate every little thing in their life. I am going to be very strongly suggesting to Miss Wishard and Mr. Wishard to not beat around the bush to try to figure this out so visitation can happen. If I find out on the 9th that there was no agreement and no visitation, I'm not going to be happy. So I'm expecting that we can come to mutual agreement. I'm ordering visitation. We need to figure out who can do that.
Okay. When do you want to do presentation? Also on the 6th?
It's fine.
That works for me. Otherwise, the only other, I guess, option would be
I'm not available on the 23rd. We could do the
or the
26th.
second.
If you, we could do the
26th
26th.
or the 2nd.
Either's fine. Let me check. I shouldn't say that before I look.
I am in a jury trial next week, but
I'm in trial on the 26th at 9 a.m.
okay, so we could do the 2nd, or we just wait till the 6th, or if there's an agreement on orders.
We're already here on the 6th. I'd prefer
Fine.
just to do it all at once.
That's
Okay.
fine.
Okay. So, Ms. Baldwin, if you check with your client about his mother, his dad, or his sister.
Okay, and then we will propose I'm sure, a list of names to you as well.
All right, and then I will make sure to file the GAL order with the clerk as soon as
Thank
we're
you.
done this morning to get that at least started. And hopefully she can get reach out to both parties and get some information from them started by the 6th.
Thank
Very
you.
good.
All right, good luck, everyone. Thank you.
Thank you.
Wishard,
Yes. So,
it's 23-3-17408.
So we have several things on today. First is the guardian ad litem compliance, and Ms. Kale submitted an email to all of us, one indicating that she wasn't going to be available for today's date. She acknowledged receipt of completed packets and fees from both parties, and she states that she appears to be on track for our July 11/23 review hearing. So I would just ask that the court recognize that I guess the parties are in compliance and that our next GAL review will be that July 11 at 1 p.m. hearing.
I agree.
Great. And can I just ask when you all received that email from her?
Yeah, it was forwarded to court administration as well. It was either yesterday or Friday, maybe.
I agree.
Okay.
It was yesterday at 12:36 p.m.
All right. We are asking the GALs to include the judicial officer that they are in front of when they aren't going to be present. And so
Okay, so just so you know, I think that's different than instructions that my staff have received, because I had still been going by the old rule as far as including the judicial officer in their JA. And my understanding is that staff have been given instructions, and Ms. Baldwin can correct me if I'm wrong, that we're only supposed to be forwarding to Superior Court Administration website or email.
You are, but the GAL isn't. The GAL is supposed to include. So you guys are doing everything perfectly fine. We're trying to get the GALs to keep us informed. And I know that she's a new GAL and hopefully she was on that email. I was just curious.
Yeah, she forwarded it to court administration.
Perfect. Okay. All right.
Okay.
So everybody is doing what they need to do with the GAL.
Yes.
Perfect.
So then
So
the next
now
is choose presentation.
So on presentation, my biggest issue is how the orders are framed. And so I didn't put in a formal objection because the orders are framed in a temporary order, but from the looks of them, then they're sort of unenforceable in the sense that if they were phrased in a child support order, that would go to the Division of Child Support and then be enforceable through a wage garnishment. And instead they're in a temporary order, which won't go to the Division of Child Support and won't be enforceable. And so it sort of depends on what Your Honor intended. We're also in front of you for a review. That's probably a substantive review. And so given that, if the court could give us direction as to sort of what you really intended, then I'd ask that we just set that presentation over and I can sort of react accordingly to whatever we present for today, based on whatever you order today.
Well, it would have been nice to have heard this prior to today so that counsel and I could have talked about this. Right now, as I understand Your Honor's order, you're reviewing financials at every one of these review orders, and the expectation is that the family support, or at least the spousal maintenance portion, the $1,100 a month of the family support, is going to be going away relatively soon, given the fact that this is a short-term marriage. Your Honor ordered family support. There was no indication that that necessarily was to be enforced through WSSR. The suggestion that this order, if Your Honor signs it and enters it with the court, is not enforceable is not accurate. Obviously, this court has the ability to enforce their own orders. Certainly, if my client hasn't been forwarding payments to Ms. Wishard by the 25th of each month, then that's information that I'm going to be hearing from Ms. Baldwin, and I will be talking to my client. But it's not, I guess, typically family support isn't something that we normally run through WSSR. And I think even on the case that preceded the Kaufman matter, it was Ms. Powers who asked that those payments go through solely because of that person receiving TANF. Ms. Wishard doesn't receive TANF in this case. So you specifically indicated you were not entering a child support order, you were entering a family support obligation. So if you want to add language as far as WSSR enforcement, I suppose that we could do that, but it's going to be so short-lived. I guess if I were Ms. Wishard, why would I want to have to pay, what is it, a $55 fee for WSSR to collect if it's going to be such a short period of time? And if it's obviously enforceable and counsel and I communicate on a daily basis?
So it's not true in the sense that $50 is pretty cheap in comparison to the fees for a contempt. And similarly, having something automatically deducted out of somebody's paycheck is pretty easy compared to spending $300, $400 per hour with Ms. McLean and I sending letters back and forth versus the Division of Child Support just taking it directly out of her check. And it isn't as if child support is going to go away tomorrow or next month. That's going to be an ongoing obligation. So it's not as if that $50 is just to secure, which is cheap, is just to secure a month or 2 or 6 months of obligation. It secures an entire year because, again, it's paying to secure the child support order. The court did give us incomes on what you sort of based your information on and the health insurance credits. So that looks a lot like, to me, like child support worksheet is what the court intended to have happen. So again, that's sort of my inherent concern.
And I guess procedurally, I'm wondering why we're arguing this when there haven't been formal objections filed. And my orders were submitted, 12 days ago?
Because I'm seeking clarification.
I guess I understand the concern. I understand wanting that clarification. And I get both sides' arguments. I think you both do that very well. Make your points, and I see it both ways. I think a lot of times it's a personal preference of attorneys on how they submit the orders or what they request. I just kind of quickly went through, and it's kind of 50-50 on temporary orders if the state registry is involved or if they're not involved. My hope would be that we're not here on contempts for failure to pay. We have a gainfully employed individual that's been ordered support. So if there is no other objections besides that, I'm inclined to enter the order as presented. So I guess I'd want to know if there's any other concerns that you have, Ms. Baldwin, with the proposed temporary family law order.
No, I didn't have any substantive objections other than probably some wordsmithing things that Ms. McLean and I go back and forth on probably every time.
All right. And then I guess the remainder of these orders, I'm assuming, do we want to hold off on the parenting plan, but I can enter the child support and child support worksheets, assuming there's no other issues there.
There is no child support order or worksheet.
It's just the temporary order.
It's just the temporary order. Again, at paragraph 5, you provided
No,
for family support.
They were in my packet, so I was just going through what was in
Oh.
the packet.
No, those would have been my original proposed temporary orders from
Okay.
our hearing a couple of weeks ago.
Oh, well, they clipped them all together, so then they just
So-
faked me out, I guess. So the temporary family law order and the parenting plan are all that we're worried about today.
Yes, and you should
Okay.
have a temporary family law order that I signed as of May 25th of 23.
That is what I have.
Okay.
Okay.
And so at the top of that page, you should have health insurance of $538.71, and then the attorney fees of $2,500 at
Yes.
paragraph 12. Yeah, that's the correct temporary order.
That's what I'm looking at.
Okay. Approved via Zoom for you, Ms. Baldwin, okay?
That's fine.
All right. So I obviously have read the most recent declarations, and I have the parenting plan here, so I'm assuming we want to just kind of discuss those.
As far as the review hearing,
Yes.
sure. So first off, I will tell the court that Mr. Wishard, the day of the hearing, I reached out to Ms. Lovely. The earliest that she could schedule Mr. Wishard for a domestic violence evaluation was June 16 at 10 a.m. He is scheduled for that. Ms. Lovely has been provided the contact information for Ms. Wishard, Ms. Baldwin, and Ms. Kale, the GAL, and she's been instructed to receive collateral information from Ms. Wishard and Ms. Kale. Mr. Wishard, in light of the drug test results, has a drug evaluation scheduled with Awakenings on June 13th of 23 at 2 p.m. He's been instructed to instruct them to contact both Ms. Wishard and Ms. Kale for collateral input. As my client tells you in his reply declaration, he does acknowledge using the drug that he tested positive for. I think it is appropriate to note that he did not test positive for any of the drugs claimed by Ms. Wishard. We propose in regards to the drug testing fee that not be reimbursed. First off, Mr. Wishard, once we can get visitation scheduled, I mean, here we've been another 2 weeks without any contact with his child. Once those are arranged, and we're just waiting for scheduling that with Ms. Fellows's agency that coordinates with my client's time off. He unfortunately in the interim had a mandatory change in his schedule by his supervisor. I can't tell the court as I sit here exactly what that was for, but as soon as I got that notice, I provided that to Ms. Baldwin and to Ms. Fellows. And so the hope is that we're going to have visitation, I believe, arranged for this week. Professionally supervised visits through that agency are $40 an hour, and Your Honor has ordered a supervised visitation 4 hours a week. That means you're looking at $160 a week, or essentially $693 a month for professionally supervised visitation. So as it relates to that visitation, Your Honor,
Didn't I authorize a third party?
yeah, you did, but we weren't able to work that out. Ms. Baldwin sent me a list of 10 individuals. I sent her a list of 13 individuals. We had agreed for my client to have visitation supervised the weekend after so we were in court. I have to look at a calendar, I apologize. We were in court on the 19th. Yes, we had arranged and agreed to Clay, Ms. Wishard's brother, supervising visitation the weekend of May 26th. And then we were told on Monday, the 22nd, because my client wouldn't agree to her visitation demands, that even though he had agreed to Clay, that now since and Because we weren't able to work it out by that Friday, even though he agreed to Clay doing the supervision the next weekend, that because you ordered that if we hadn't worked it out by Monday the 22nd, you were ordering professionally supervised visitation. And so I'd even received an email from Ms. Baldwin that said, my client will pick one of your lay supervisors to supervise, then we'll do a professional supervise, and then you pick one of our lay supervisors to supervise. But all of that was removed and off the board, even though we agreed to all of that. It was removed and off the board because Monday hit. Your Honor said that it had to be professionally supervised if we couldn't agree by that date. And even though we had agreed to Clay for that following weekend, all of a sudden Clay was no longer available to provide supervised visitation. So here we are 18 days later, and my client has had absolutely no contact with his child. I've done the best that I can as far as communicating and trying to coordinate. My client has asked for that visitation. He agreed to Clay. We were then told Clay couldn't do it or wasn't available. And therefore, as of the 22nd, because Your Honor said, if we couldn't work it out with lay supervisors by then, it had to be supervised. That's what they chose. And then we had, obviously, trying to work into a professional facility where my client's 4 on, 4 off. And then we had this unanticipated shift change for a short period of time for my client. And so the facility hasn't been able to get him in. I can go back to my emails, and I'm sorry, I didn't get that in my notes. I know that there is, actually, I think I have it. So the email from Ms. Fellows to us last Wednesday was, so originally my client's first visit was scheduled for the 30th of May. However, his work schedule changed and had to be canceled. He did have availability on Sunday and Monday, but we were closed due to the holiday because that was Memorial Day weekend. His first visits are next week on Tuesday. So he must have had a visit today from 10 a.m. to 12 noon. And then he's supposed to have a visit this Thursday from 11 a.m. to 1 p.m. So we've gone 18 days without visitation. So we have absolutely no objection to the court ordering forward-looking drug testing. We agree to loser pays. We have a limit now on what that drug is. So we know that if he tests positive for that in the future, and if the amount is less, then clearly he's on a decline. I don't know how long that stays in your system as far as hair follicle for metabolizing. You can certainly see that it wasn't in his UA, although I guess maybe I should ratchet that one back. I think that they only tested for kratom, even though the court didn't order a UA, you ordered a hair follicle, but my client participated in it and he was negative for kratom. So I don't recall, I think that's the only drug that they tested on the UA. So I don't have, I'm sure Your Honor knows more than I do as it relates to how long it takes for hair to metastasize or metabolize, not metastasize, metabolize that drug. I don't know the answer as I sit here. Obviously, a UA would show up to 72 hours. And typically that stays in the system for up to 72 hours. I don't know how long it's in your hair. So that's the one issue that I don't know. As it relates to, the financial review, obviously my client's net is $5,698. We've got him paying $2,000 a month in family support, paying her car at $325 a month, her automobile insurance, which she unilaterally, before this case was even filed, removed her automobile from the joint automobile insurance. I haven't seen an automobile insurance bill from counsel. So my client doesn't have anything that he can pay at this point for that, as you ordered him to pay the automobile insurance for her as well. I'm assuming that's going to be around at least $75 a month. He also pays her health insurance, which is $213.08. So that's a benefit. All of those are a total benefit to her of $2,613.08. The court has ordered him to pay his vehicle of $526 a month, his vehicle insurance of $75 a month, Addison's health insurance, as well as his health insurance, which is $325.63 a month. So that total for his benefit and Addison's benefit is $926.63. Assuming that we're continuing down the path of professional supervised visitation, that's going to be $693 a month. He also this month has outlays for the domestic violence evaluation of $550, not including any treatment that might be recommended if that is ordered by the court. The substance evaluation will be approximately $200 if it's not covered by his insurance. And I don't anticipate that it would be covered by his insurance. Plus, there would be costs for treatment if it is determined that treatment is necessary and if this court orders that. So just for those evaluations and the supervised visitation is another $1,443 per month. In the future, it would be the $693 for professionally supervised visits, plus any services that he's ordered to go through. My client is currently scheduled to take the high conflict children in the middle parenting seminar. As soon as he's completed that, that will be filed with the court. So right now, after all of those expenses, that leaves him with $715.29. And we haven't even gotten to his personal expenditures, such as fuel to go back and forth to Kalama for work, food, personal expenses. I mean, none of that has been covered. Self-support reserve, 125% of poverty level, I believe, is $1,415 a month. So he's clearly well below the self-support reserve based on this order. Our position is that if the court is going to maintain this family support, that you again terminate that after at least, I would say at most, 3 months, because this is a short-term marriage. At this juncture, we have absolutely no information or proof of Ms. Wishard's efforts at securing any type of employment, even though she's living with her folks and has the ability to go and do that. She has provided absolutely no information of employment searches, and the court should be imputing at least minimum wage to her in regards to that. And considering that in reference to how long this spousal support portion of this family support should continue. So we're asking that the court provide relief that that the spousal maintenance, the $1,100 a month, would terminate after 3 months. I think we made that effective in the temporary order as of May 19. Yeah, as of May 19. So it should terminate as of August. Let's see, June, July. So terminate after July 19th. So he would be done as of August 18th of 2023. And again, keep in mind that we've got these additional expenses relative to services. One that Ms. Wishard wants him to participate in, and we anticipate that the court the court has already ordered the domestic violence evaluation. So those expenses are to be taken into consideration by the court as well. Keep in mind also that Ms. Wishard again removed the majority of the, I guess it was 2/3 compared to 1/3 of savings that these parties had. And the court has also ordered that my client contribute $2,500 towards her attorney's fees. So he doesn't have a tree that grows money, and he is in a new position that he trained for at the commencement of this year with his job. He's low man on the totem pole, so he would be the last man that would qualify for overtime. And at this point, he's hamstrung as far as his abilities to provide financially for all of these things that the court is ordering.
Quick question.
Yes.
I always think that I'm saying something that's kind of lays out my position. Clearly, it sounds like there at one point anyway was an agreement that Clay Lindbergh would be agreed by both parties. Is that still the case?
I have no idea. They retracted.
So we agreed, they asked over Memorial Day weekend. It was the holiday weekend, so people have plans far in advance. But going forward, that certainly would be an agreement.
And I would ask the court to give me an opportunity to go back and look at emails, because I think that was their offer. And we agreed but I don't want to misspeak. So if you would bear with me for just 1 minute.
Right. And I can explain in my argument additionally.
So it said, so the email from Ms. Baldwin's office was, we've not heard back regarding our proposal yesterday afternoon, which they had. With the change of your client's scheduling changing, our client's person, Clay Lindbergh, is not available to supervise for too long, and Mr. Wishart needs to have visits with the child. So they withdrew that. It says, as such, our client already paid the registration fee with Beth Fellows' office, so she would like to just move forward with the visits with Beth Fellows. And that was on Monday, the 26th.
Okay. And so he's had at least one visit with the child
Today. And I guess if Jonathan, if you could just turn your video on and give us the thumbs up if that's accurate, that you had a visit today. Okay, thank you. So he's had 1 2-hour visit today.
Okay.
Yes, that's correct.
Thanks.
And, but it sounds as though, barring scheduling, unprofessionalized, both parties would agree to Clay Lindbergh. Correct? Okay. Obviously, that's really good to know. I don't know. I'm not going to sit here and dictate when things are going to necessarily happen, but that's obviously a good resource to have if there's a mutual person that's willing and able to do that within their schedule.
And just so the court knows, Ms. Baldwin had a list of 10 people. We had a list of 13 people. No response as it relates to any of the 13 people on our side.
Okay. All right, Ms. Baldwin.
Thank you. So we have to pause here and remember where we were at the time of the court's last order. At the time the court made its last order, Mr. Wishart denied all substance use, denied all problems, said there were no issues, but thus far, at the time that you had last seen him, also refused to take a hair follicle until you ordered it, even though it had been sitting there. And these people are not people who just broke up yesterday. These are people who had been separated since March. So we have March, April, May, when he's doing his drug test, we're about 3 months in. And that would be 3 months where you know you're going to get into litigation. You know you're going to be under the court spotlight. You know, the minute you meet with your attorney is not the minute that your court documents are filed. There's gaps of time there. Mr. Wishart had time to get clean and he could not do it in that amount of time. Then coming to the court and sort of claiming innocence, knowing the entire time that he had used and was not honest with the court about that. It's important to keep that in mind. And especially when we're thinking about the veracity of his statements and the integrity of his statements sort of throughout, is if he's going to lie about one thing, it's going to happen about other things. And so when my client testifies, she says, look, the only things that I am accusing him of having used are the things he told me he used or I saw him use directly. And those were not only the cocaine that we now know he's positive for, but Oxycontin, Suboxone, fentanyl, alcohol, and marijuana. That's a large list that is important that we keep that in mind. And my client says this is not a one-time thing. And even Mr. Wishart admits that his substance abuse goes back at this point several years. He's never received treatment before today, and yet again denied to the court his use and the fact that he'd be dirty. The first thing that's important, the court should order the refund of the testing amount. The only reason we had to do testing is because Mr. Wishart wasn't honest. It's ridiculous to say that that shouldn't be paid for out of his pocket when the only reason it had to be done was the fact that he was dishonest with the court. So the court should order that to be paid. The court should order him to comply because it hasn't yet with completing substance use evaluation. It sounds like that's getting on board, and that's great. But we should make that an affirmative order so that there's no backing away from it later. The court should make findings in a parenting plan under Section 3A regarding domestic violence. In this case, we have photos of holes in walls. We have texts where he admits to his behavior, apologizes for it, blames her for it, sort of apologizes again, that cycle of violence. We see the financial control that is, again, kind of a hallmark of domestic violence. And we have my client talking about the violence that was present in the home that qualifies per statute as domestic violence. We should make that finding in this case. Similarly, you should make a finding at 3B for substance use disorder as to Mr. Wishart. The court should outline the limits and treatment. I'm asking that the court look at my proposed parenting plan filed on May 2nd. In that order, it makes the findings of domestic violence and substance abuse, limits his use further, so essentially that he's not to use substances going forward. I'm fine that there's a joint prohibition on corporal punishment of the child. He shouldn't drive if he doesn't have a valid driver's license. And he should not use any substance, including vapes or cigarettes, whenever he's around the child. Again, it sounds like we have the evaluation started, as I've outlined already. On a temporary basis, the mother should be the one who's making decisions for this child. That's what makes sense. Mother is not only historically the primary parent, it's required if there's a DV finding. And in this case, Mr. Statement is, you noticed in his pleadings, he says, I'm flexible, I'm reducing my work hours, but then he had scheduled supervised visits and then didn't do them because he went to work instead. So again, what we see is that 60-hour work week that he testified to, or I shouldn't say testified to, that are in his stated text messages to my client, which he doesn't deny, 60-hour work weeks continuing. So that means his base salary is not his actual income. We have significantly more income. So then where do we go as far as a parenting plan? The parenting plan where the court had concerns about substance use should not be the same parenting plan that gets entered when we know that there is substance use. One is a concern and one is a very. And so we now have the very. We now have that we know absolutely that he has a substance use problem. And again, from materials and his own text messages, we see the domestic violence problem as well. My client would ask that until he can get clean, at least get 90 days without having used, that we limit visitation to essentially video visits, that we have a set video visit with him. That's not ideal, but the reality is that Mr. Wishart needs to get clean and needs to be motivated to. It shouldn't just be a struggle, oh, you caught me red-handed, and that there's no consequence to that, because there's real consequences to children being involved with folks who aren't clean and sober. So we are asking the court limit his visits to a video visit. Those could be once a week, twice a week, but it should be a reasonable amount for a reasonable duration, given this is a pretty young child. Thereafter, my client's preference is professionally supervised visitation, at least for a period of time, so that we can have a consistent view and that we don't have he said, she said, his family, her family, sort of making statements as far as, visits are going great or visits are going terrible. I think it is helpful to have at least a brief period of professionally supervised visits, since you do get the benefit of having those notes that come along with them. So my client is asking for him to be clean and sober, then move into a brief period of having professionally supervised, and then ideally family supervised visits. But again, there's a relatively short period of time between now and when we're back in court in about a month. So the court can either make a fully fleshed out order, or you can make an order to sort of an additional interim order to get us to the next review, when you'll potentially have evaluations to go off of and have a better idea of sort of where to go forward. Ms. Lovely, I found, is fairly efficient if other people are efficient in providing the requested materials to her. So I find that what delays her evaluation is not her, but really the people who provide the materials to her. And I know my client will be prepared to do that quickly. So we're asking the court to think carefully on the visits, especially where Mr. Wisher has not been honest with the court, isn't clean now, and doesn't have any treatment on board to maintain his sobriety. That's unfortunate, but I think that's where we are. If the court is going to, and I do want to make briefly talk about visits. I think counsel makes a significant effort to sort of blame my client. The reality is here, my client, and she provided you a declaration and text messages where she offered, we had our hearing on the 19th. She offered visits that weekend. He said, no, I want it my way or the highway. She then said, okay, I can get visits going with a supervision place down in Vancouver. He said no. Then offered, okay, fine, we'll get him going with Beth Fellows. But Beth wasn't available to the following week. Those were scheduled. He then unscheduled them because he decided to go to work instead. My client offered a list of 10 people. He said, fine, I'll take that one over the Memorial Day holiday. My client said, well, that is Memorial Day holiday. He's not available. He's already made plans. Again, the supervisors are people too. They're not instantly available if you say, oh, I can't do it then, but now I want to move it to tomorrow. These are humans who have their own work schedules. So it isn't as if these people are available at the drop of the hat. They need to be scheduled. Finally, he scheduled, Beth Fellows was available 1, 2, 3 days. He canceled or wasn't willing to schedule any of those. He finally scheduled for this week. My client basically said anytime, anywhere, any supervisor that was a professional one or with Clay. But again, if he cancels them, my client doesn't have any control over that. And I think that speaks to the fact that he is working those 60-hour work weeks. That is his priority. I appreciate the work ethic, but sometimes kid schedule and supervisor schedule needs to come first. On finances, the court's basically already set Mr.'s income at essentially $5,700 per month. Again, the court's aware that my client's making zero. She was a stay-at-home parent. That is a ship that does not turn on a dime. It takes time. My client left school. She left prior sort of work-based efforts where she was moving forward in a career in the medical field. Again, that does not turn around instantly. The point, even in shorter marriages, and this is not a tiny marriage by any means, it's a shortish marriage, but not a marriage of 6 months. It takes time, and there's supposed to be restorative maintenance to get my client back on track. The idea that we would cap it at this point, I think, isn't reasonable. My client hasn't had a lot of time to get things back going. You'll notice that she's already done her parenting class. She's doing what she's supposed to be doing, looking into the schooling and getting back involved in school so she can get back on track and get her career back on track, which will only have positive benefits for the child and ultimately Mr. Wisher when he pays less child support, because my client is making a decent wage in the future instead of, sort of like, oh, just go get any job. That's not a long-term benefit to the child. A lot of the costs counsel lays out are one-time costs, not recurring costs. Again, at $5,700 per month, he has no expenses. He's living at home with his parents. So he has very minimal outlays for his personal costs. So on a temporary basis, what I asked the court to do is maintain the current temporary order. We can review it again in July. Again, then we'll have more evaluations. You'll have hopefully an actual treatment plan and then real costs to base that on instead of just guessing at what those costs would be. And so then that would be a reasonable place to potentially reevaluate that. But again, the economic circumstances of my client is she has need, he has an ability to pay. And again, we were basically here just a few weeks ago in looking at this order. So financially, I think the court should leave the current temporary order in place. I think it's reasonable. It's puts both parties in a reasonable circumstance going forward. As far as parenting plan, again, we asked the court to adopt our temporary parenting plan that we filed, or adopt a interim order that takes us to July when we can get further input from the guardian ad litem. But it isn't reasonable to trust the person who, when last before the court, wasn't honest with the court.
You're muted.
Thank you, Ms. Baldwin. And thank you, Ms. McLean. Quick housekeeping matter before I forget. I know that when we set this, we set it for July 11th,
Yes.
and I am not here on July 11th, and I realize that that probably wouldn't benefit anyone. So, I know we don't have Miss Kale here, but are the parties available the 18th?
Yes,
may be more likely to have evaluations back.
I am out that week.
I could do the following week, the 25th.
I'm out the last 2 weeks of July.
Oh. And with your honor's permission, we could move it to a Friday with your permission.
I don't have a problem with that. So I guess, Ms. McLean, are you out starting the 17th?
No, starting the 14th,
Oh.
which is Friday. And in the 7th, potentially I'm going to be on jury duty.
Okay.
So
So August 1?
7th doesn't work for me. Okay. So that'll change a little bit what I do. Is August 1? I mean, I'm happy to leave it on the 11th. It won't be me.
Oh, and that's too hard. I just think any other judicial, there's too much history, especially when we're kind of doing orders like we are. I think it's too hard for somebody to come in and be a fresh slate.
I don't know. Judges do it all the time. That's why you have coverage. So, and clearly you've got all of the temporary orders in place.
Well, if the parties are fine, we'll just leave it on the 11th. And if for some reason that doesn't work out, then we'll do our best to schedule it as quickly as we can in front of me.
Okay.
That works for everyone. I just wanted to raise that issue because I know that I probably said it with the intention of me hearing it and not remembering that I'm going to be gone then.
And wait, before we move on from that, I would argue for it to be set over if we appear on the 11th. So are you ordering it just to go forward regardless? And then that's your order. Or are you just setting it? And because I do think it should be, Your Honor, just at this point, I've already got a ream of paper that the next person would have to arguably review.
And again, I mean, judicial officers review dockets, they prepare for these hearings. They'll have feedback from the guardian ad litem. You do this all the time.
And Your Honor's
I'm
discretion.
just thinking about the additional delay.
Yeah.
And I don't want my scheduled 2-week vacation to mean that my client's going to have to incur another, $100 or $300 and some dollars in supervised visitation fees. Of which I will tell the court that my client let me know that it's not $40 an hour, it's $45 an hour with Ms. Fellows' agency. So that's $180 a week or $780 a month. Do you mind if I provide just some additional brief comments?
Well, I think I know what I'm going to do, and that may determine where the parties, that may change your position on whether the 11th is okay, or if the August 1st would be better.
And I guess the only other thing that I would say is that if we set this for August 1st, I don't know if I've not worked with Ms. Kale before, so I don't know if she plans on issuing a written report. I won't actually be back and be able to address that until the 31st. Technically, we've marked me out because I'll be trying to play catch up, having been gone for 18 days. But that's going to be my first day back in the office, which is the day before the hearing. So it's not like I'd be able to get anything substantive entered with the court before that hearing.
If
it were set to August 1st.
I don't want the whole order to be crafted around one of our vacations. Like that's also my concern.
Okay. No, we all have lives outside of this that we try to to work with our clients and with our cases, and I understand that. So here's where I'm at. I'm gonna just have a chat with you folks about what I'm thinking here. Clearly, the drug report was not great news for anybody. I know a fair amount about drugs and what's in your system. Looking at this, to me, just with my history as a practitioner, the numbers, 90 days probably would be my guess for how long cocaine would stay in a hair fall in your hair. Obviously that can change depending on how long your hair is and how often you cut it. Additionally, the results, the numbers results to me look really borderline between occasional use and what I would call is social use. So weekends, daily, potentially daily or a few times a week use. But I'm not going to really base anything on that, but that's concerning. Does that in and of itself show me that there's a history of substance abuse? Not necessarily, but it's concerning, given the type of accusations that have been outlined in the declarations that the courts received. Does that in and of itself make Mr. Wishard incapable of having a safe visit with his child? No, I don't think that it does. Clearly, we want to ensure that the child's safety is first and foremost. I think additionally, it is important to address any substance abuse concerns that exist here. So I am very glad to hear that Awakenings is scheduled for June 13th. I'm very glad that the DV evaluation is scheduled for June 16th. My hope is that we'll get, the Awakenings eval, he'll likely get an oral, report the day of, and usually those don't take more than a few days to actually get back. With collateral input, that may add a few extra days, assuming there's no concerns getting a hold of everyone. DV evaluation, as Ms. Baldwin says, I agree with that. The collateral contact is probably the biggest delay. The financial situation, I'm not really making any changes with that. I do understand the concern with the order kind of saying, well, it's going to just keep being revisited. But at this point, I'm going to leave the whole family support as ordered, with, I guess, the caveat that I don't anticipate that being a long-term situation. But I'm not at this point willing to say that it's just going to be 3 months. So I would like that to be reviewed at our next hearing. As far as the parenting plan, I frankly think that we're in a situation where since we do have this hair follicle that came back the way that it did, I do want to see the evaluation from Awakenings, and I do want to see the domestic violence evaluation before I move beyond what I've ordered. So I am going to order that the visitation be supervised. I'm not ordering that it has to be professional supervision. I understand Ms. Baldwin's position and her client's position of wanting that and wanting like some kind of consistency in reporting, but I'm not going to require it be that. Obviously, it probably would be in Mr. Wishard's best interest to stay on the books at Ms. Fellow's place in case there's no availability for the unprofessional supervisor. But frankly, in the declarations and text messages, it looks as though Ms. Wishard has been trying to get visitation set up and trying to be proactive in that. The offer of meeting in the park with the child, which he declined, trying to get things set up. So I don't think, as long as Mr. Wishard's willing to to work with folks' schedules. It sounds as though Miss Wishart is willing to make that happen. So that's my hope. And if for some reason there are issues with that, then we have the professional supervisor as a backup. I
May I
would,
ask a question?
sure.
So is there any reason why we can't have one person from each side that's chosen so that we aren't burning out a supervisor and we can go back and forth, one with his, one with hers? And the other thing too is that Ms. Baldwin had made a comment about, you'll get the supervised visitation notes from the professional supervisor. I fully expect that the court's going to enter a lay supervision contract and that the lay supervisors are also going to be required to provide visitation notes.
We do have that form now that's signed by the supervisor that's agreed upon. So Mr. Lindbergh would essentially assert that he's going to follow the parameters of the court's order and report any issues along those lines. So I think it's like a 2-page form. So it sounds as though Clay Lindbergh is one approved individual. Frankly, I don't know, Ms. Baldwin, if the 13 folks that were sent to you, if there's any on that list that Ms. Wishart is willing to accept as an alternate individual.
Let me chat with my client about that, and I should have an answer hopefully momentarily.
Do you want a breakout room, or is she in your office, or?
If you could do a breakout room, actually, that would be great.
I can do that. Yeah, sure.
Okay, and my client will be back once she hits the button. But she's okay with Christina Wishart providing supervision.
That's great. So now we have 2 options outside of the professional supervision. Obviously, I would just encourage the parties to have patience with those folks, because their schedules and their lives are separate and distinct from what's going on in this case. And I appreciate that they're willing to help these folks out in this situation. So I don't think there's anything I missed, unless either party has anything
So I
other
guess-
than the date of review.
So if we work off of the parenting plan that you have in front of you,
Mhm.
I do have the provision at paragraph 4B2 as it relates to the, that was your honor's prior ruling in regards to use.
I wouldn't agree to use that parenting plan. The parenting plans is reserving issues. It's reserving all the issues, and clearly that's not where we are anymore. It makes more sense to me that we enter something that actually either is an interim order that reflects what we've actually done, or is a really stripped down parenting plan, since we're going to be back to review in essentially a month or a month-ish.
Well, I understood that we were here, that you at your review would consider the input and make determinations after you get the evaluations. So
That's
did I
No, you didn't
misunderstand that?
no. My thought at this point is that the status quo of supervised visitation is going to continue until our next review.
Okay.
And because I do want, sounds like everybody is engaged with the GAL or started that process. So we have the GAL, the Miss Lovely and Awakenings all on board. Those 3 things I think are going to be very important for the court to really move forward from there. So
Sure.
Parenting plan is essentially Miss Wishart is primary parent, Mr. Wishart, and if I think I said a minimum 4 hours a week.
Yes.
And if there's an agreement and availability for more time than that, and both parties agree, I'm happy with that. I'm not, but a minimum of 4 hours per week. And those evaluations taking place, 2 different supervisors that are available. And then we also have the professional, since he's already engaged with that. My hope would be that it wouldn't be as difficult to utilize them if that becomes an issue, but with 2 different folks available, my hope would be that Mr. Wishart wouldn't have to keep shelling out that money for professional supervision, since we have 2 folks that are willing to help out. So that's where I'm at.
So do you want to make interlineations on the parenting plan that's in front of you, or do you want a new parenting plan proposed? Because if you want to make changes, I'd like to just walk you through those.
And my preference is that we have an order that is an order on hearing.
We're gonna, I think just a quick, dirty order, kind of maintaining what we're at is appropriate. We do have the temporary family law order to cover the other,
You mean as if
other things.
Let me make sure that I understand what you're saying. So you don't want an actual parenting plan entered. You want just an order that says she's custodian. And I guess my only concern is I want to make sure that we've got the relocation statute identified in whatever order is being entered, which is why I prepared the parenting plan.
No, and I understand that. And I'm fine doing just a really pared down parenting plan, but I don't know that, frankly, that this one would be legible by the time I get done with it. So if the parties, if either one of you are willing to take on, because I would adopt the relocation and all the, the language, I guess I'm going to call it the standard language that we see kind of post section 13 and up. I would adopt all of that, and I think that's appropriate.
So
That's
when
fine. I don't mind drafting.
Visitation again.
We can do that. Let's see. I'm fine with either this Friday, if we want to do that quickly, or I think council. When do you
I already
leave?
have I already have a presentation in front of Judge Basher on Friday. I don't know.
I have another one set that I could take first if I don't, and that's the only morning court I have this Friday is presentations. So if we said 8:45, but I knew you guys wouldn't be there until 9, Friday would work for me because I can probably run a little over. If you think you can turn it around that quickly.
That's fine.
So.
I can just make some changes to what I put together.
Okay. But I will, I'll enter the temporary family law order with that.
Okay.
But I will change something, assuming, well, I'm gonna. Let's address the July 11th on Friday.
Okay.
If we can get, if Mr. Wishart's able to get visitation scheduled and, things are looking like he's gonna, then that may change positions, but I'll enter this order with the language that says July 11th is the next review. And then we can take that back up on the 9th.
So in regards, so just to answer your question, I did talk to Ms. Lovely and let her know that our review was scheduled for July 11th and that you were anticipating having evaluations from her. She said, so long as she had timely contact from collaterals, and again, I provided all that contact information. I provided all of the preliminary declarations and opposing declarations to her so that she had that information. And she expected and hoped to provide a report prior to that hearing. I have not contacted Awakenings. My client contacted Awakenings directly. My historical work with them as far as working with opposing or collateral information is that usually they can turn it around within 2 weeks. So my assumption is that we should be able to get something by then.
And I anticipate now that we know it's Ms. Lovely, my client will provide her information probably by the end of the week. We'll reach out to Ms. Lovely today. The only other thing that the court hasn't touched on is if you're ordering reimbursement for the drug test.
Yes.
Okay.
And then
just pen that into that temporary order.
Sure. How much was it?
Say it was 475. Let me confirm.
We can, another thing, just while you're looking that up, the week of, is everyone here the week of July 4th?
I am not here the week of July 4th.
Okay.
I
leave, so I'm out the 7th and then I'm here the 10th in the morning. And then I'm gone the 11th through the 14th.
can be available on the 10th. I
I
could
can be available.
Because I maybe between now and Friday, I can check with admin and see if we can do like a special set, like a 30-minute slot on the 10th, maybe like at 11:30 or something. I'll look into that and see if I can offer that up, because I understand the delay, and if we actually think we'll have reports back, but I also want everybody to have an opportunity to actually discuss those reports.
I'll send an email also to Ms. Kale to see if she's available on the 10th at 11-ish, 11:30-ish.
Okay.
and it was, go ahead.
I have a sentencing at 9 a.m. That morning that they're anticipating taking 1 to 2 hours. So that's, so I would think that 11:30 would work, but okay. Let me just make a note of that. Okay, and then did you find the amount for the
Yes, it's 475.
and do you want that just to your office or?
That's fine.
Okay.
And if the court just put a due date on it, 30 days, 60 days, whatever you think is appropriate.
The attorney's fees is 90 days.
Okay, so I just included that in the section 14. I just said other orders, reimburse 475 to respondent's attorney's office for hair follicle test to be paid by petitioner within 90 days of this order.
Okay.
Sounds good.
All right, and then not 9 o'clock, the 9th, 8:45, knowing that you may be a little bit late, but I have another presentation, so that should work out perfectly.
Okay. I'll get an order out tomorrow.
All
Very
right.
good. Thank you.
Thank you. We can go off the record. All right, we have two different matters here this morning for presentation. This is the presentation docket for Patricia Fassett. So good morning, everyone. I'm going to start with the Wishard and Wishard matter. Good morning.
Morning.
I received the proposed parenting plan. I also received the objections to the order. I've worked my way through some of those and made changes based on my ruling. So I'll walk through that. And then there's some that I want to discuss with everyone. So let's just start page 1, section 3A1. I am reserving that. So I've lined out neither parent and just indicated reserved and initialed that. Page 2, 4B1. The line 19. I indicated 18 and 19, I should say, non-professional supervision shall occur at, and I just lined out the father's home or, and so it shall occur at such location as agreed upon by the father and supervisor. And I initialed that. And line 23, I just included Jonathan Wishard's work schedule and the supervisor's schedule, initialed that. So B2, change from 8 hours prior to 24 hours prior. I think that's reasonable. There's, if we're potentially dealing with an addiction situation, I think there needs to be some flexibility there. 24 hours to me seems appropriate. And then section 3.
So we need to decide if we're going to, were you able to determine if we're moving our review hearing to July 10, Monday, July 10 at 11:30?
We can do July 10th at 11 o'clock if that works for everybody. So I was able to confirm we can special set at that time. So
I'm available.
I'm available. That's fine.
all right.
Is
And
Ms.
I
Gale available?
okay.
So could you just interlineate that then at that open line on 3?
Yes, and what I did on line 3 is I changed visitation for Jonathan Wisher may be reviewed instead of will be reviewed, may be reviewed. And what date did I say? July 10 at 11 o'clock. The only thing that I will just throw out there as a preface is I don't know if I'll have to be at the jail at 9 a.m. on Monday. And then if that special set will be here and how long that hearing will be. So just if I'm not here right away, I'll try to get somebody to let you all know, but as close to 11 o'clock as possible, we'll start that.
Is that for your sentencing?
Yeah, I have a 9 o'clock sentencing. I'm not sure if it's going to be at the jail or at the hall. So
Okay.
if it's at the jail, then I'll likely have to come back over here for the presentation. So there's maybe a little bit of a delay, but I'm going to set it for 11 o'clock a.m. July 10th, 2023. The expectation is that the visitation will move to unsupervised. I struck that. We don't know what the expectation is. So I'm obviously willing to consider anything, but I don't like the definitive language that's listed there. What happens if the petitioner tests positive and his levels increase as written? It would require motion, docket notice, and orders shortening time, significant fees. Ms. McLean, you have any response to that?
So I had simply just provided that it would be a docket notice, that it could be put on the next available docket on just a docket notice. We wouldn't have to file a formal motion or an order shortening time so that the court could immediately address that. And then if you wanted to have more information from the parties in writing, you could make that determination at that time.
I'm okay if it's very clear that that's all that's required and it's on the next available docket. Because again, this order just limps us through really for the next month. And so that's fine so long as that language is clear.
So if you look at line 2 on page 3 of my proposed order, it said failure shall be considered a positive test and all visitation shall be reviewed by the court at the next available docket for all parties on filing service of a docket notice.
And I would just add that no motion required.
I'm fine with that.
All right, I'll put a little asterisks in there and indicate that no motion is required in that instance.
Thank you.
Ms. Baldwin's suggesting that just healthcare is listed at this point in time. Do you have any response to that, Ms. McLean?
Well, I think that parents should be allowed to be involved in those decision-making areas that have been listed.
Inherently, the problem is that we've reserved domestic violence. If the court makes a domestic violence finding, that sparks very specific things as to joint decision-making. In this case, the child is 3, they're not entering the military, they're not going to school, they're not really doing any activities. I think that we should just sort of be more succinct here and limit it to the things that are rationally going to happen in the next month.
And yet you see multiple text message communications between the parties. I think that needs to be encouraged. I think moving forward, the expectation is that both parents are going to be healthy and remain involved with this child. And the earlier that we can establish those requirements as far as being separated and maintaining that communication, the better. I mean, that's one of the reasons why the court required the parties to participate in the parenting seminar.
I don't disagree. I'm gonna strike the driver's license, piercing, tattoos, and military and underage marriage. I think we're well beyond any time frame, or we should resolve this well beyond any time frame where those will factor in. But I'll leave extracurriculars, religious decisions, healthcare, and any estate decisions as joint.
All right, thank you.
And so summer and holiday schedules. So Ms. Baldwin.
So same, I'm just asking that we reserve it. Again, this is an order that really limps us through. And so for about a month. And so it makes more sense to reserve these than it does to sort of say, to sort of try to pin something else in. We're really on an interim order, not a true temporary order. So again, that's why I would reserve these.
And I'm not pinning anything else in, but my concern is the potential argument that, well, the summer schedule is reserved. Summer, if we're looking at a school schedule, starts next week for kids, which means potentially it could be interpreted that the visitation schedule doesn't apply because it's been reserved. So therefore, there could be an argument that my client isn't entitled to visitation. What this language does is it says you follow the school schedule. It's the same as the school schedule. The school schedule says you follow the paragraph 4B as far as his supervised visitation. So I think it is appropriate and will continue for that continuity of visitation for my client as is outlined in paragraph 4B.
And no one here is going to make that argument because this is an interim order. The court's very clear about what the visitation schedule is. So I think given the practitioners involved, that argument falls flat.
And I guess, again, my concern is I don't know how long Ms. Baldwin's going to be involved in this case. I don't know how long I'm going to be involved in this case. We don't know if we're going to be in front of Your Honor consistently throughout this case. So there's a lot of unknowns. I just want to provide consistency for any judicial officer who's going to be reviewing this.
I'm going to leave the language in. I frankly, I don't think it being there or not being there is too much of a difference, but I'm fine just leaving that. So I'll leave 9 and 10 as proposed. Then it looks like the last section is same page 5, section 12. So what I've done, and then I guess Ms. Baldwin, I'll ask if this resolves your concern under A. It says Kylie Wishard, and I included or her designee shall deliver the child to supervised visitation location, and Jonathan Wishard shall transport himself to and from any supervised visitation location.
I think that's fine, given the change that you made back on the other section.
All right. Any other areas of concern or?
No, thank you. We'll circulate a conformed copy to all parties once it hits Odyssey.
All right. And Ms. Baldwin, are you okay with me indicating approved via Zoom?
Yes, that's fine. Thank you.
Thank you. And Ms. Kale, thank you for being here. It's my first time seeing you, Patricia Fassett. Nice to see you.
Meet you, Your Honor. Thank you.
Tells you that he, again, has already completed the high conflict children in between parenting seminar. And we've provided proof of that. So that's giving him additional tools. And then by virtue of having these folks communicate through our family wizard, that's going to hopefully eliminate his need to react to Ms. Wishard. In regards to the substance abuse treatment, my client indicates that he will definitely participate in the substance abuse treatment. The amount that was quoted, and I apologize again because I didn't get that in my notes this morning. My recollection was that it was around $1,500. And he is checking with his medical provider at Kaiser to determine if they can provide for that same treatment and hopefully maybe have it covered by insurance. So he will certainly follow through on that. The suggestion that Mr. Wishard should undergo weekly UAs, that's one of the recommendations from the guardian ad litem. Mr. Wishard is already financially tapped. At this point, none of the supervisors, the professional supervisor or the lay supervisor, have had to intervene in a visit, nor have they reported Mr. Wishart appearing to be under the influence. Obviously, the current parenting plan provides for the supervised visitation rules provide for the supervisors to terminate a visit or to not start a visit if they believe that he's under the influence or if he is acting inappropriately. As well as Ms. Wishart has the ability to request for random UAs and hair follicles, and at this juncture, under this temporary order, she's not done so. The cost for UAs, depending upon how many panels you run, are going to be anywhere from probably $35 on up. But we have a situation where we have a gentleman who does not have the finances to continue to provide for all of these things. So I would ask that the court not adopt the GAL's recommendation on the weekly UAs. That certainly seems overboard, particularly in line with an evaluation that is recommending 1 month of treatment and then a review. So it sounds to me that he's already on a clearer path. And we believe that that should be the substance of what he should do, is to complete the substance abuse evaluation, the treatment that was recommended. And again, if that is through Awakenings, that's going to be roughly $1,500. So we'll need time to be able to provide payment for that. In regards to the financial circumstances, as my client tells you, and he's provided his wage stubs for the last month, and in the month of June, he had to pay $290 for the orientation and for the 2 supervised visits. He paid $200 for the Awakenings evaluation, $150 for the high conflict children in between 8-hour parenting seminar, and $550 for Olivia Lovely's domestic violence evaluation. So from his net for the month of June, he netted $4,871.53. He paid $2,000 to Ms. Wishart, the $900 for child support and $1,100 for spousal maintenance. He's ordered to pay his car payment and her car payment. So his car payment is $526, her car payment is $325. He's ordered to pay the family health insurance of $538.71 per month. And he's also ordered to pay Ms. Wishart's automobile insurance. And at this juncture, all he's gotten is handwritten documentation of her claim of what her automobile insurance is. We need actual documentation from the insurance company as it relates, but regardless, he went ahead and paid the $109. And so for the month of June, that left him a whopping $182.82 to cover his fuel to go back and forth to Kalama for employment, to cover his food, to cover his now app for the Our Family Wizard, to cover treatment classes if the court's going to order those. He is completely tapped. And so we're asking again at this juncture that the court terminate the $1,100 per month spousal maintenance. This is a short-term marriage. While the guardian ad litem report says that there's an inclination that Ms. Wishart wants to either attend a dental hygienist or I think it was nursing assistant, one of those two educational programs. There is no information that she's provided under sworn declaration to this court about any efforts at securing employment or pursuing educational opportunities. My client needs some financial relief so that we can move forward, if anything, with regards to the substance abuse treatment, so that he can pay for that if he has to do that through Awakenings. So that's the relief that we're asking. We are asking that the court consider unsupervising visitation and setting a schedule. Ms. Kale says that suggests that visitations need to be arranged a week in advance. We need a schedule. Normal parenting plans have a schedule that everybody can look at, that the court can easily enforce. So we're asking the court to set a standard schedule and to provide for unsupervised visitation, because again, there's nothing in any of the supervised visitation notes. And quite frankly, there's nothing in the guardian ad litem report that suggests that Mr. Wishart's parenting is negative or inappropriate for his daughter.
All right. Thank you, Ms. McLean. Ms. Baldwin?
Thank you. In this case, we're largely in agreement with the recommendations by the guardian ad litem. But when you look at the guardian ad litem report, I think that that's the best place that you really see a pattern of deceit on the part of the petitioner. Initially, when he came to the court, essentially denied drug use, saying, don't test me, that would be invasive, but trust me, I'm clean. And what do we come to find out? That he's positive for illegal substances. He denies that there's any kind of problem with alcohol, but what do we find out? He's drinking the day of his substance use evaluation. He's drinking the day that he's having a visit with his own child. So we have his positive alcohol test on the same day as both the evaluation as well as the day of his visit. So again, dishonest. We see him denying issues of domestic violence, but yet we have pictures of holes in the walls and him making statements like, I'll allow her to go do this, or, I authorized her to do that. So again, we have these repeated instances, him denying prior use of narcotics, and then when caught in that lie, finally admitting it to the guardian ad litem. That is a pattern of dishonesty with the court and essentially with everybody in this case. When we look at that, I think that that's the place to start, is we have one party who's not being genuine with the court and one party who is. When we think about supervision, the court really has to clarify this. And even the guardian ad litem is sort of a good fences make good neighbors, and we would tend to agree. Again, we have Mr. Wisher drinking or under the influence of alcohol, and we know it because we have that positive alcohol test. And his family right now has been the only one to supervise other than the initial 2 visits, I think, with Ms. Fellows. And do they report anything? Sure don't. And that's the problem, is you need to be able to trust these people. And we have a positive alcohol test that shows he's under the influence at a visit, not a word. These are the very concerns that my client had, is that when only one side is providing the supervision, you get this very skewed result of the, hey, there's no problems, nothing going on. Because unfortunately, parties have a tendency to have their families gloss over those types of issues. And again, ignoring the fact that there's a positive alcohol test the same day as the visit. So the court's really getting a false narrative with sort of everything's delightful, everything's good. But again, we have black and white evidence that that's just not the case. So again, my client, she's not against his family supervising at all. She wants it to sort of be even Steven, in the sense that Mr.'s family supervises, my client's family supervises, and that way there's sort of an evening out of the reports that are involved. What I'd ask the court to do is, there seems to be no problem with Mr. Supervisor and their schedule availability. I'd ask the court to allow my client to choose 3 additional people from her initial list to provide supervision, but that those people not be her direct parents. I understand there's an issue with her parents, that's fine, but that she be allowed to choose 3 additional people, because this looks like this is a long-term issue, and that's reasonable to have a series of 4 total people on my client's side that can provide that supervision. And that supervision should alternate. That's what the expectation is. That's why we discussed it. That's why we discussed that Mr. couldn't dictate where visits were going to occur, because the expectation was that we were going to have my client's family supervised. We talked about having reports from both sides. So again, that's appropriate that it alternate. When we look at that, the guardian ad litem says things need to be arranged a week in advance. We agree. My client's already logged on and has our family wizard. My understanding is the party's already communicating that way, so we're in agreement with that. As far as location, again, court saw from the documents, Mr. basically says my way or the highway. That doesn't work. So we're asking the court to just say my client supervisors provide 3 locations. He has to pick one, because otherwise this idea that he has to agree, then he just won't. And then sort of by veto power gets to dictate the location, which the court already says I'm not going to let him do that. We've already had that discussion. Unfortunately, the way we worded it, Mr. found that he could just veto everything. So that's not appropriate. In this case, the court should at this point make the finding of domestic violence in the parenting plan and make the finding as to Mr.'s substance abuse problem. We do have the domestic violence evaluation. It does find that there's domestic violence. There's a need for treatment. We have the guardian ad litem, who actually did an amazing job for an interim report that was very thorough. But even she says, yeah, things were not appropriate. He was doing things that were not appropriate. There was advantages being taken. He's putting holes in walls. And so with all of those pieces of evidence, the domestic violence finding is appropriate at this time. It is appropriate that he be required to do domestic violence treatment as recommended. Mrs. Lovely is not the only provider. Mr. can certainly find another provider. I'm fine with any Washington state licensed provider. I don't want it to be, some random person from Florida, but so long as they're licensed in Washington, that's fine. So that takes out any sort of these scheduling issue problems that he wants to claim. But again, when you take the photos of the domestic violence, you have photos of holes in the walls, you have the text messages between the parties where he talks about, I lose my temper, and it's your fault. I've allowed her to do this. I've allowed her to be out of the house. All of those are very fundamentally domestic violence issues, and he should be required to attend treatment as recommended. So we have the evaluations. It's because we're not experts. We rely on the expert to say what's needed. She's outlined what's needed. He should be required to comply. As far as substance abuse, again, we have an evaluation. My concern here is a bit that the evaluation sort of glosses over the fact that he showed up with alcohol on board. It says that he wasn't inebriated at the evaluation, but sort of ignores the fact that he had a positive UA. So I think that there's a little bit of a concern there, a concern that he's really not amenable to treatment in the domestic violence realm or the substance abuse realm. Both are sort of like, hey, this isn't really a problem when everyone else says it is a problem. So we are asking that he be required to comply with substance abuse treatment as recommended. Additionally, the court should order that he's required to abstain from all substances, including alcohol, period, full stop, end of story. In this case, that's also what the evaluations and recommendations seem to be, that he not use any substances that should include alcohol. That should not be time limited at this point in this court order. We're asking that he be required to do the UAs as recommended by the GAL. We have certain substances he's been positive for. He doesn't need the most extensive UA possible. I think the standard lower panels are going to catch marijuana, alcohol, and opiates and cocaine. I think that those lower panels are going to be fine. Those are relatively cheap as a once a week type of cost. So again, I think those are appropriate, and they're appropriate to protect the child. The idea of putting the financial burden on my client when she's not the party that sort of offended and been dishonest with the court, that's just not appropriate. He should be required, at least at this point, to provide those up front. As far as mental health, the GAL also recommends my client's in treatment. I think that's reasonable. She's been through a domestic violence situation. She's getting education and knowledge and counseling to help her not end up in that situation again. The report specifically said that Mr. had some issues with mental health, either a potential PTSD diagnosis or an anxiety and depression diagnosis. But again, he didn't have those specific evaluations. Those are just subsets of the evaluations that are done to sort of look for other markers of other problems. He should be required to submit to a mental health evaluation and treatment. I'm not asking for a full psychological evaluation. I'm just asking that he be required to meet with his physician, take the appropriate assessments that are essentially free to him through his insurance, and follow up with any treatment that's recommended. Again, my client's not interested in causing barriers for him. She's interested in him being a healthy and whole parent who can be a benefit to their child. You can't do that if he's not mentally healthy, clean from substances, and has a better understanding of domestic violence and his own entitlement. The next issue that's really addressed is costs. Council lays out cost after cost. It's a one-time cost and is not a continuing cost. It's sort of like take this one-time thing that happened and now overlay that over all the months in the future. That's not appropriate. As of May, if you were to take that wage stub, so that wage stub is essentially pay through May. Its pay date is in the first week of June, but it's pay through May. He had gross income of $7,654. If you were to look at his original financial declaration, he said he had gross pay of $7,989. Not very far different. That's his own words that he said that he was making. So given that, he does have plenty of income to meet his expenses, and he has zero expenses, essentially, other than the court-ordered ones. He's living with his parents. He's not paying any rent. He's not paying any utilities. He's basically making a handful of fairly small payments to maintain health insurance and vehicles for the parties, and then paying court-ordered things. That's appropriate. That's getting him healthy at this time. He has the funds to do it. His statements that he's tapped, they just aren't borne out by the evidence. There's no cost for supervision based on how the court's orchestrated things. So again, not appropriate. He should be required to do the services that the court has ordered. As far as financial, the court should make no changes in the current financial orders and obligations. And the court should cease and terminate further just automatic reviews that it can just be reviewed and thrown on to tacked on to any other argument. That's not appropriate. When you look at Mrs., she was a stay-at-home parent. She had lost her licensing and credentialing to be able to go back to work. And again, when you look at the situation as a whole, when Mr.'s words again ring true, I allowed her to. The expectation that she be a stay-at-home parent, that she let those licenses lapse and not return to work. My client's now saying, okay, here's what it takes for me to get relicensed. Here's the school I'm going to. She does provide that information for you. That's in her declaration under the spousal support section, and she provides exhibits as to those costs. The costs are somewhat modest, but there's time involved in her being able to take those classes, pay those funds. My client's not asking more to be able to pay for that education that's necessary for her to get re-credentialed. But she's also saying it takes time, and I need the support to be able to bridge through this situation to get to a place where I can make a reasonable outcome. And again, that's reasonable in this case. When we think about that, she stopped her education. She was going into a nursing degree, not dental, but she had a CNA, again, lost that credentialing because she was a stay-at-home parent. But at this point, being able to support herself and the child at a livable wage is a long-term benefit to everyone involved. Mr. has the ability, Mrs. has the need. It's reasonable in this case, and there's a long-term benefit for the mother and the child for a short-term spousal support that's being provided now. And again, these are temporary orders. So my client's asking that the financial orders remain the same. And again, Mr. hasn't provided a financial declaration saying he's not able. He's just saying that because that's the easiest way to reduce the support. But he really hasn't provided documentation that would actually financially show that. So given that, my client is asking that the court not make any changes to financial orders. Other than that, I believe that, again, the guardian ad litem has done a wonderful job at an interim order on a very short-term basis. But we do have, at this point, expert reports. We have the report of the guardian ad litem. The court should, again, largely follow the guardian ad litem's recommendations with the small changes that we've requested to provide clarity to everyone.
Right. Ms. McLean, anything briefly?
Just briefly, I would indicate that there is absolutely no proof that he drank the day of the substance abuse evaluation. ETG typically runs for 72 hours, so it'll test up to 72 hours. And I would like to see the expert who would suggest that that test results concludes, as counsel is claiming, that it shows that he was drinking the day of. Had he shown up for the evaluation with alcohol, that would have been noted. Had he shown up for visitation with alcohol in his system, there wouldn't have been a visitation that would have taken place because that would have been in violation of the supervision rules. In regards to the suggestion that, or the language that's attributed to Mr. Wishart of, I'll allow her, or I allowed her to do this, I allowed her to do that. There's absolutely no allegation that he was isolationist. There is, maybe he is a poor speaker, and that certainly was not what his intention was. Again, there's been no allegation that he's been isolationist during their relationship. In regards to the suggestion that there should be a finding of DV, you have a specific declaration from the DV evaluator who states that Mr. Wishart is not the aggressor. Mr. Wishart has not been the aggressor in this instance. He has been reactive. He's been reactive primarily to Ms. Wishart's behavior directed towards him. And if anything, that he could use some counseling as it relates to interpersonal relationships. That does not equate to domestic violence. So we do not believe that this is required for a domestic violence finding. And I would also ask, I'm not aware of any other state certified domestic violence counselors in Cowlitz County. So that's a huge concern. I mean, how do we accomplish this if the court's going to order treatment for an individual who has scored in low profile ranges on everything except for the substance abuse? And we agree that the substance abuse should be addressed and will be addressed. My records show that a 5-panel instant UA is $40. So $40 a week is significant given his current financial circumstances. Again, I remind the court, Ms. Wishart is living at home. She doesn't have a rent payment. She doesn't have a utility payment. She's got her car payment, her health insurance, everything being paid by Mr. Wishart. So she does not have a need. She's already received, I think under the orders now, $3,300 in spousal maintenance that clearly covers whatever she is claiming as far as costs for these certificates. If it's $1,500, I think counsel indicated, she's had more than double the amount to be able to get that started. So our position is, again, very short-term marriage. She has the ability to go out, even getting a minimum wage job to supplement her living expenses. Her parents are at home and can provide care for the child. So she's not done anything to improve her circumstances. She's simply demanding that Mr. Wishart continue to provide for essentially 2 different households and a child as well, and then services and visitation expenses and the like. So we're asking that the court adopt the relief that we've requested.
Right. Thank you. Ms. Kale, anything you would like to add or clarify?
I don't know that I need to offer any clarification. I feel like I said what I needed to say in the report. My biggest concerns that I want to highlight are the inconsistencies that were shared with me in my interview with Mr. Wishart. When I was able to go back and ask direct questions regarding information I received from other people, he would change the information he had given me previously. I was also concerned about consistent substances showing up on tests when he knew he was going to be tested. To me, the reason why I'm asking for that regular testing is because of the dishonesty and inconsistency.
I want to thank you that I would agree with Ms. Baldwin, and I think Ms. McLean noted as well. That's a very thorough interim report. We don't get interim reports that are kind of that extensive. So I appreciate the work that you've done thus far on this case.
Thank you, Your Honor. I find it helps with the final report if the interim's a little more. It helps complete the picture by the end of the process.
I'm sure it does. All right, thank you. All right, so I'm going to address the family support issue first. I don't want to continue having these just sort of be always the financial impact being reviewed on a regular basis. So what I'm going to do is starting September 1st for 4 months, family support will be ordered in the amount of $1,500.
Are you maintaining the $900 as child support?
Yes. And that'll go for 4 months. And then thereafter, it will be used the child support and all the bills and insurance as previously ordered. Obviously, if there's any dramatic change in circumstances, the parties are free to raise that again. But I do consider the circumstances that this is a relatively short-term marriage. Both parties are living at home, so there is some benefit to them. But I don't want to assume that means that everything is just being given to them as far as what is happening at home. So that's that. Our family wizard, I don't remember Ms. Baldwin touching base on that. Frankly, I don't ever see any harm in ordering that. I think it's kind of just a safety net for both parties to be able to communicate through that. There's scheduling functions on that app that can be very helpful to the parties to notify others of upcoming things or block out time. So I will order our family wizard. As far as clarifying the order of the court, I'm a little frustrated because it seems to me to be relatively clear. There is no back and forth. He was ordered the 4 hours a week. If only one side's supervisor can accommodate that, then that's who should do it. If that's uneven, then that's uneven. I would agree. Ideally, there would be an equal opportunity for both parties' supervisors to be involved in that process. And I would hope that they continue to try to move forward in that regard. There doesn't need to be a back and forth. So if it's Mr. Wishart's this week, next week doesn't have to be Miss Wishart's. Every week, Mr. Wishart gets his supervision period. So if the only person available and the timeframes available is someone that's on Mr. Wishart's list, then that's how it is. So I would like to move towards considering unsupervised visitation. And I was, frankly, before I got some of the information for today, was hoping that that would be the court's ruling today. My concern, and one of the things that I specifically wrote down before we got started this morning, was the UAs. In the comments to the GAL, there was a claim of, I've only ever done cocaine once. Well, that's interesting that it just so happened to be right before you got a hair follicle test, such that it showed to the levels that were there. And then going to get, I'm assuming Mr. Wishart set up his own drug and alcohol evaluation and clearly had alcohol at some point surrounding that, enough that it showed up on the UA there. I would agree with Ms. McLean. I can't sit here and say based on those levels that meant that he drank before the evaluation or had drank the same day as that visitation. I think it was the 13th of June that the collection was made at the UA was collected, and he also had a visitation that day. Is it concerning? Yes. Does it definitively say, oh, we know he was drinking on a day of the visitation? No, I'm not going to sit here and make that claim. Retrograde extrapolation could tell us otherwise, but I'm not. It's been a while since I've dabbled in that math, so I'm not going to sit here and say that I know that. Do I understand why Ms. Baldwin's concerned with that? Absolutely, I do, because that clearly seems to be the recurring issue. In reading Ms. Lovely's report, frankly, she put substance abuse as frankly a bigger issue than the domestic violence issue. And what I think we're experiencing is someone that hasn't been held accountable in regards to that and doesn't want to admit that there probably is an issue here. Frankly, I do not think that if it is $40, I know Ms. Baldwin indicated she felt there were potentially options available less than $40 for the UAs. I think Mr. Wishart has the funds to do that. I frankly also think that it's a small price to pay to ensure you're seeing your child. I'd like to see Mr. Wishart get started with substance abuse, and frankly, I'm putting that on the forefront. I'm not convinced that domestic violence isn't an issue, but I'm frankly more concerned at this point with substance abuse and keeping that in check. So at this point, everything's going to remain the same, but I'm going to allow for up to 6 hours a week of visitation that is supervised. I am going to require the parties schedule that as far in advance as they can. If they can do several weeks in a row and plan out far, that's great. I'm not going to sit here and go through Mr. Wishart's calendar and try to dictate those times as much as I'm sure the parties would appreciate it if I could. There's too many factors there and too many other folks that are giving their time up to help supervise that in their schedules. So if it can be an equal share of supervisors from both parties, that's great. If not, then he gets his time. He gets his time. I don't really care who it's with. And I'd like to see this. I'd like to see the substance abuse treatment started, and I'm going to order the weekly UAs as well. So those need to be done prior to the visitation at any point. So, and I'm not going to require that you return to court for a positive UA, but that will suspend that week's visitation. So then he gets another try the next week. I don't want significant delays in the visitation because of a positive UA, but he essentially would forfeit that week's visitation.
Let me ask you a question on that.
Yes.
I'm just thinking logistics. So I know that typically when I send a client over to get a UA, I will get results back either 2 to 3, maybe 5 days later. So if we are, let's say we're coordinating a visit his last day off, and if he does that his first day off, because he's got 4 days off, if he takes it his first day off, or maybe he takes it on the interim between when he transitions from day shift to graveyard shift. He's got like a 24-hour period there, have him do the UA there, and then hope that we've got the results back.
Ms. Baldwin, do you have any? I don't want to hinder, like, I don't want him to miss a week's worth of visitation because the UA doesn't come back.
Right.
And I don't know my experience with instant UAs, and I don't know if there's people that do instant UAs because they can be a little bit wonky, but those are, you generally don't get levels with those, right? You just get a yea or nay. And I don't know if anybody does instance and
So,
what how many panels there are in instance.
So Performance Occupational Health, their fee schedule, it looks like they do, they call them rapid 5-panel drug screens for $70. If you, and then it says, if you want to add a drug screen ETUG, which is for the alcohol, then the cost is $70. So if you're wanting alcohol, then you're looking at $70 a drug screen through Longview's Performance Occupational Health, which is the agency that we typically use. They're over on Hudson Street.
So
Okay.
I don't think he has to use the rapid, so that he's sort of paying to expedite. My thought is that he be required to do it once a week, and ideally the results are back. If for some reason they're not back, the presumption should be the visit will progress as ordered, even if the results are not back. But if it's positive, he would then miss the next visit as sort of like, hey, you were positive, you shouldn't have had that visit. You need to think like sort of an automatic consequence for him. I think that that's a way to manage that without, absent him being overtly under the influence. That's a reasonable way to manage that problem and not require an expedited test result or an insta read, which is sort of not as quality as having an actual eval.
Well, I can't talk today. There is not a delineation in, they either have hair panels or they have these rapid 5-panel drug screen, 10-panel. These are all rapid, 5-panel, 10-panel, 12-panel, or they have a drug screen ETUG urine alcohol.
Right, but if he's doing substance use treatment, he should be getting UAs through that treatment. That treatment's likely to be covered by his insurance because it, I think, is required to be. So I don't think that he'll have to have them done through performance health or occupational health on a long-term basis because he should be doing them with his substance use treatment.
Okay. So what I'm hearing is that it needs to be done once a week.
Well, and usually they'll do once a week, if not more, if you're in treatment. And I know that he's looking at potentially going through Kaiser for treatment. So there may be a gap in starting that process. But I think I like Ms. Baldwin's suggestion. So he should just start doing weeklies. And we're hoping that there was as far away from the scheduled visitation as possible, with the hopes that that returns in time. If it doesn't return, presumption is he still gets his visitation. If we find out after there's a positive, then the next week would be suspended. And then, but we keep going that route.
And do we think that the treatment provider will provide that on a weekly basis? I mean, will they produce the results to us?
I would assume that if he did an ROI with them and asked that they provide it to you,
Okay.
That's, if he can get it through treatment and I'm
Sure.
fine with it just being through that place and used for both services. So we
Okay.
don't have to pay for that.
Okay.
Historically,
great.
if he's doing the treatment with Kaiser, it'll show up in his test results. And so he should be able to print it out himself. If not, do an ROI and have them send it direct.
Okay, great. Thanks.
As for, there's a couple other. So Ms. Baldwin's requesting that the 191 factors for substance abuse and DV are found now. Frankly, I think there's a pretty decent argument for a finding of 191 for substance abuse now. I just always am hesitant to do that prior to trial. So I am clearly putting Mr. Wishart through the paces here, and I'm not, but I'm going to still reserve on the 191 factors, even though frankly, that's the main concern of the court. As far as mental health evaluation by Mr. Wishart and some treatment, I don't think that is a bad idea. There was a reference in Miss Lovely's report to some PTSD, and I think there was potentially reference to some other
Anxiety, I think it was.
Yeah,
okay,
anxiety and depression.
I think it probably would behoove Mr. Wishart to address those issues. I'm not going to specifically order that he must undergo those evaluations, but Mr. Wishart should understand that if he does start attending any kind of mental health treatment and in the court finds about that, that's only going to be benefit him, not only personally, but I think likely in the scenario that we're in here. Is there any other issues that we needed to touch base on? I believe I addressed everyone's concerns. If there's something else, please let me know.
So on the supervision, so this is what will crop up. And if you can clarify, my client says my supervisor is available and willing, and Mr. says, nope, I only want to use my people. So if Mrs.'s supervision providers are available and willing, then does Mr. just get to say, no, I'm going to go with my person, and I'm just always going to go with my person?
Ideally, I think they should both be utilized. Do I want to sit here? And this is a little bit of a frustration and I'm glad that both Mr. Wishart, Miss Wishart are here right now. You are adults with a child. You're going to need to navigate this without the court's intervention eventually. So please, this isn't I'm going to win this fight, you're going to win this fight thing. This is a child that you're talking about. And that clearly, based on everything I've seen, you both care about very much, and your extended families care about them very much. This little girl needs to have all of these people in her life, and it's probably to her benefit that she sees other family members of mom and other family members of dad, especially during this kind of weird transition phase that everybody's in. So my biggest first concern is that he gets his visitation. My second concern is that there is some equality in doing that. Mr. Wishart, if you just say no, that's frustrating. And Miss Wishart, if you say no because you're not using mine, that's frustrating. So I don't want to see that moving forward. I don't want to say, well, it has to be, the odd weeks hers, the even weeks his, because what if that can't happen one week and then the other party decides to say, guess what? You don't get visitation because that's what the judge says. That's the situation I want to avoid. So, to quote a judge, I don't want to split Tupperware and have one party end up with 4 lids and no bowls. There needs to be some give and take here, and neither of you have the upper hand in this situation, because if you're going to make it difficult, then guess what? The court's going to make it difficult, and then you're going to have to follow a very specific thing. So my ideal is that you work this out. If for some reason someone has difficulty doing that, then I will dictate a very specific schedule with very specific supervisors, and that nobody's probably going to be happy with. And I don't want to do that, because I want you to work this out, because like I said, you're going to have to do it yourself eventually. So no. So the answer, long story, no, he can't just say, no, I'm not doing that because my sister's available. Let's have some give and take. That's my hope. If we have to deal with this again, like I said, then we're going to go down a path that I hope nobody wants to go down, and that you're all willing to work a little bit more to avoid.
So is it fair to use language in the order that says the expectation is that it alternate unless the supervisor isn't available, and then it'll default to the other supervisor to ensure a visit happens?
I think that's fair. Does that work for you, Ms. McLean?
Okay, so what's the language?
So the expectation is that supervisors alternate between the parents, but if a supervisor is not available, then the other supervisor may be used to ensure the visit occurs.
That's the court's order.
All right. Anything else for today?
Just looking through the GAL's recommendation. Is the court ordering abstinence from all substances for Mr. Wishart? that he not use alcohol or anything at this point?
He needs to do a substance abuse treatment, and by way of that would be he's not using substances. And I guess as a catch-all as well, I would adopt the other recommendations of the GAL as far as corporal punishment.
I think that's already.
Yeah,
I think the
it is.
current
All
order already
that
has
the standard stuff, no negative disparaging comments. And I think that was in our temporary order, but I just wanted to ensure, since
So
the stick came up a few times in some different comments, so no corporal punishment.
I think that the current language on substance use is 8. I think it's 8 hours or maybe 12 hours prior to. I don't have that sitting right here in front of me, but
24.
oh, is it 24?
Yeah. But again, if the court's, so again, I want to clarify, so it's not, there isn't confusion later. So the court's saying because he's doing substance use treatments, you should abstain from all mind altering substances. And I think that's what the guardian ad litem also recommends.
I will adopt that at this point.
Okay. And I think with that, the other things are already, I agree with some of the other recommendations for the GAL are already in the last order, so that wouldn't be a change.
Okay. So then presentation.
August 1 is open for me as well, so we'll set it to 8/1/23 at 1:00 p.m.
Thank you.
Yes,
You beat me.
someone's on vacation. 23/3/017408. This is a motion.
To
Ms.
suspend.
Baldwin.
Yes. Thank you. For the record, I'm Chelsea Baldwin. I represent Kylie Wisher. This is our motion to suspend visits. The history here is important, and the court is not that far removed from the history of this case, but the court will recall Mr. Wishard was initially dishonest with the court about his drug usage and whether or not he would be clean. Was found to be using cocaine. He was dishonest with the guardian ad litem until essentially he was caught, both with the positive hair follicle, but additionally with other information where he didn't disclose that. And it was only when she came back to him and said, hey, what about all these other instances? And only then did he admit those to her. Similarly, dishonest with the evaluator, not disclosing information until he was caught essentially through the collateral contact. So we have essentially a fairly clear history of Mr. Wishard saying what he wants to say and what's convenient at the time. The underlying order is clear. It's Ms. McLean's order. If you're off work, you have a very limited amount of time to respond to a request to provide a hair follicle and engage in drug testing, which is appropriate given the fact that we have somebody who had a positive test for cocaine. And what we have here now is multiple failures. So this is not realistically brought before the court on just one single failure. The court made its order, that he had to get a UA once a week. Mr. Wishard, that on a Tuesday you made that order. Mr. Wishard doesn't do that. He just says, not going to do it this first week. I'm going to sit on my hands, do nothing. End of that week, my client requests the hair follicle. Doesn't do that
Your
either.
Honor, I guess, Your Honor, if I may I interpose an objection?
Sure.
The argument that counsel just made in regards to my client not participating in a UA the first week was not information that was pled in the initial motion, so we didn't have an opportunity to respond to that. That was new information that was contained in the reply declaration, and I would ask that the court not consider that argument, again, because that's something that should have been raised in the initial motion to allow us to respond.
They filed their clean hair fall or their clean UA single one. I think that's appropriate to reference the timing of that.
Go ahead, Ms. Baldwin.
Mr. Wishard doesn't do his UA. My client goes appropriately through our family wizard, requests the hair follicle at the end of the week. He has essentially 5 hours to get that done. She requests that at effectively noon. She leaves it open for the rest of the day until they close, until business close, even though that's significantly longer than he would have been provided per the court order. Never shows up. And then similarly, he arrives the next week, does an observed UA or unobserved UA on his schedule when he chose to, when he wanted to, and again, unobserved. So we have somebody who is waiting. We have the A, no initial test, B, we have refusal to do the hair follicle, and then C, he waits essentially the requisite period of time to be able to produce a clean UA. and says, well, gee, that's how it is. I'm just not going to do what the court order requires. Again, cocaine was not the only history here. My client disclosed a significant history of drug abuse of several different drugs. Mr. Wishart himself acknowledges prior troubles with illegal substances. To my client's knowledge, there's no treatment's been on board. And this idea that I can just sit on my hands and not do anything, we're all aware there's AA and NA meetings occurring regularly. You don't need a prescription to show up to one of those types of meetings. We don't have any of those. All we have are Mr. Wishart are excuses. First excuses is I'm out of town. That does not appear to be true. Second excuse he uses is I'm sleeping. So even though these are the hours where he should have been up and awake, and my client says she had a history where he was working similar types of hours, as they will say, no, he would have been up. We had a long history of him working this type of shift work. So again, my client says this is not a new situation. He claims, oh, I didn't see it. I was sleeping. Please, excuse it away. And then the last is I didn't see it. Like I just didn't see it at all. And arguably right there, which is it? We already have 3 different stories in a very quick period of time. The idea that he didn't see it, my client completely dispels. She says, look, the reason why the parties are using our family wizard is it provides you multiple ways to be informed. It provides 3 different ways. It sends essentially a text message or pop-up to your phone. It sends you an email, and it has badge and banner notifications on your phone. And my client says he would have had to turn them off because they were automatically on. So the default presentation is that they start on, and you have to say, no, I don't want that notification. And it's very easy for somebody to see that there's a notification and say, well, I'm just going to ignore it because that's bad news. And so it's easier for me to ignore that than comply. And that's what we have with Mr. Wishart. Again, the reality is that addicts lie. We all are aware of that. They will say whatever they can to get out of the trouble that they're in at the moment. And that's really what we see is one excuse after another, neither of which are really backed by anything. And a key when we look at, does this person have a problem? Is it impacting their life? And we do see that. We see Mr. Wishart failing to make visits where he's not granted that much time in this parenting plan. I would argue he's granted 6 hours, and he just doesn't show. If this is a visit with his family and he has a no call, no show, his family is making efforts saying, where are you? What do you get to the visit? Doesn't show up. Again, direct impact on him, but direct impact on child as well. So in this case, we still don't have a observed clean test. From the date where you made the order where you said you need to be doing this, still don't have one. You have nothing. He's not clean. And I would argue the court was incredibly gracious with him. And if I was to use a lay definition of grace or gracious, it's undeserved favor. The court said, hey, you have a dirty hair follicle. I'm going to keep allowing visits. But what does he do with that? And I would argue, if you looked at his SUD evaluation, is that he's ambivalent to change. He took that grace and went, I don't really have to comply. And that's what you see is him not complying. Blows off the first UA, doesn't do the hair follicle, does an unobserved UA, and blows off a visit. No call, no show. These are all indications of somebody who's just ambivalent, and that's not appropriate. It's not fair to the child. Child deserves somebody who's committed to sobriety and who is getting on track. And that is not what is indicated here. My clients followed the correct procedure, but we're here today because this is where we should be. And the court should suspend visits. What I'm asking the court to do is to do that, to suspend visits. Mr. Wishart needs to get serious. The court should order him to complete a hair follicle that's a minimum of 12 panels today. That should be at his cost. Not my clients at this point. We should suspend visits for 2 weeks and come back and look at that hair follicle. If the numbers are going down, then that is what it is. If the numbers are going up, that also is what it is. But we can reevaluate that and him getting engaged in treatment at that time. That is a fairly limited sanction in time, but it allows us to have a better window on what's happening with Mr. Wishart, especially given the posture of where we stand today and sort of his, again, ambivalent nature about how he's going to move forward with his sobriety. And additionally, the court should award fees in this case. It's not reasonable that we're here. And the excuse is essentially I should be able to abide by the court's drug testing whenever I feel like it. That's not fair to my client. There's a significant disparity in income between these two folks.
Thank you, Ms. McLean.
Thank you very much, Your Honor. First off, Ms. Kale had sent an email to all of us sometime this last week. Unfortunately, I'm working off of digital because I don't have the ability to print where I'm at. So I know that there was an email that she sent. I'm assuming that the court has reviewed through that as far as her input because she was not available today. I had requested, she had actually requested that it be set over to August 1 since we're before Your Honor next week for presentation of the order. That was not agreeable since my client was unwilling to voluntarily suspend his visitation. So you can see from Ms. Kale's email that she believes that it would be in Addison's best interest to continue her visitation, that it would not be in her best interest to suspend visitation. I guess my first question in regards to Ms. Kale's email, since the court has considered that, is the court willing to print that off and have that filed in the record, or do you want me to instruct my staff to have that printed off and put a cover sheet on it and have that filed in the court file?
I think it probably should be filed in the court file with a cover sheet. Would you agree, Ms. Baldwin? Yeah.
Okay. I'll ask.
You're going to have your staff do that? Is that what
I can have my staff do that.
Okay. I think that's appropriate.
Okay. So we were in court on July 11th. I'm sorry, on July 10th. That was the last motion that we had before Your Honor. Mr. Wisher did his UA on July 17th. And again, it wasn't raised in the initial motion about timing of that. The court ordered that he was to do that weekly. He did that within the week before his next, I believe before his next visit. My client was not asked about whether or not it was to be observed or not observed. I can, to be quite honest, I don't see on the evaluation or on that actual report where it says that it was unobserved. So I did have my staff check with them to see if it was in fact unobserved. They indicated that in fact it was unobserved. So I will instruct Mr. Wishard that he needs to pay the additional, I think it's either $20 or $25 to make sure that future UAs are observed. I believe he did his weekly UA yesterday. Again, it sounds like maybe that one was also unobserved. We will make sure that future UAs are observed so that we have that issue resolved. I don't know, again, what that looks like in the actual UA report from the facility, because I don't even see a checkbox mark for that. In any event, we don't have any proof that he has done anything to tamper with that UA. The creatinine level is within the objective parameters to support that that's a valid UA. There's this allegation, unsubstantiated allegation by Ms. Wishard that my client would be using shampoos to try and clean his hair. Again, absolutely no fact. Again, when we go through the information from Ms. Kale tells you that he even offered that he hasn't even had a haircut since his last hair follicle test. My client did sign up for the Our Family Wizard. My client tells you, and Ms. Kale acknowledges and believes Mr. Wishard's statements that he was not receiving notifications, that he had to go in and actually sign up for the notifications. And so what happens is, my understanding of the timing is that Ms. Wishard sends a message through the Our Family Wizard on Friday while my client is sleeping, getting ready to go into graveyard shift on Friday night. My client doesn't see that until Sunday morning after his second graveyard shift. He responds to that thinking that she had sent that to him on Sunday and didn't realize until after the fact that she had sent that to him on Friday. We provided verification, and he noted that the facility was not open on Sunday. So there was no way for him to dance on Sunday to be out of town, which he was up at, I believe it was a family gathering up at Swift Reservoir, someplace up in that location. And he told her that he was already scheduled to take his next UA for purposes of the weekly UAs on Monday, and that he would do it at the same time. So he goes in on Monday, he does his UA, and is told by the facility that the hair follicle was time sensitive and he wasn't allowed to do the 5-panel hair follicle. Every effort that Ms. Wishart has to punish Mr. Wishart, she's using that effort. So counsel's argument today is that he needs to do a 12-panel hair follicle, which is, I think, $385, even though she only prepaid for a 5-panel hair follicle. What's the sense in that? It's only to punish him and to increase his costs in this action. I'm anticipating that she's trying to run him out of an attorney. And that's a huge concern. In regards to, so they said he couldn't do the hair follicle. So we don't have hair follicle results for him as it relates to that. Again, Ms. Kale tells you that there is nothing that suggests that Jonathan is a danger to Addison, that all of his visits have been appropriate, that Addison is bonded, that there have been no red flags, and that Addison gets emotional when the visits end. She does not believe that Jonathan would have intentionally missed a visit with Addison. He tells you with the stresses from the case, with the transition and trying, to be quite honest, I don't know how shift workers do their schedules going from 2-day shifts and then transitioning into 2 graveyard shifts. And the next day was supposed to be his visit. He tells you he fell asleep. That's what happened. But Ms. Wishart does not give him the benefit of the doubt. And she immediately goes to, well, he's an addict, of which there's absolutely no finding by this court, or quite frankly, through his addict. Then the recommendation would have probably been for inpatient treatment, followed by outpatient treatment, or at least more than 1 month of recommended treatment. Speaking of which, again, we were in court on July 10th. On July 13th, and he provides you proof of this, he's able to talk with the triage nurse about scheduling an appointment. He had an appointment, I believe his appointment was today or is scheduled for today, with the SUD provider in Kaiser, in hopes of having this be able to be covered by his insurance so that he doesn't have to come up with another $1,500 that he doesn't have for 1 month of treatment. Again, Ms. Wishart is not qualified to do an evaluation. Counsel is not qualified to do an evaluation. And yet the motion, the actual motion, although the substance of the motion does not speak to the request that he now be required to do 3 months of treatment, when the actual professional involved in this case recommended 1 month of treatment to be reevaluated at the end of that month to determine if there should be additional treatment. And the evaluation said that during that period of treatment, there would be, so that 1 month of treatment, there's the AAs and NAs. And now they're trying to fault him and say, well, he's not doing these things. Well, he's not started the treatment because he's trying to see if Kaiser can cover that. So if there's further instruction, if the court is wanting him to start those now outside of the treatment parameters and recommendations, then we will do that. But my client has been complying and is complying with the requirements of the court.
So we, again, just see this as being vindictive, as being an effort to interfere with the child's relationship with her father. And to be quite honest, given the input from the GAL, who said that based on her review, she believes that it would be detrimental to Addison if her visits were terminated at this juncture, and that she does believe that he unfortunately fell asleep and missed a visit, that he has been following through with doing the UAs, and that she does not believe that he has done anything to interfere with that. Quite frankly, we think that this should have been set over to next Tuesday so that everybody would have an opportunity to fully hear and have any questions answered by the GAL, since she wasn't available today. We're asking the court to deny the motion in its entirety. We do not believe that we're here doing the UAs. As I indicated to counsel, they easily could have called my office on Friday morning and said, hey, we've asked your client to participate in this, and we could have then followed up with phone calls or whatever to try and make sure that he was aware that he needed to do this. My office always gives opposing counsel a heads up when there's a request for UA, because the whole goal for this court is to make sure that you have the information. It's not to play games and tricks and then come in on unnecessary motions. We want to provide you that information, and my client has been providing you and has provided the UA. We're waiting for the results from yesterday's UA, and as soon as we receive those, we will get those filed with the court. But we're asking the court to deny this motion, and if anything, we believe that if anybody's entitled to some fees, it would be my client for having to respond to this.
Thank you, Ms. McLean. Briefly, Ms. Baldwin.
Thank you. Requiring people to follow a court order that's their own attorney drafted, it's not vindictive, it's not made to punish, it's made to keep a child safe and to keep somebody, frankly, on track on their treatment. The idea that we would have to handhold Ms. McLean's client to get the treatment and the drug testing that was ordered isn't appropriate. The observed and unobserved has been on every UA I've received from occupational therapy or occupational wellness. It's on the sheet that they issue, not the lab sheet. So what was filed was the lab sheet, not sort of their sheet, because I don't think the lab gets whether or not it was observed or unobserved. That's not sort of their end of things. So that is usually indicated when you receive the correct one. AA and NA are free. Doesn't cost a dime to go to those types of programs. So again, we're in a situation where Mr. Wishart says, I don't have to do it. I'll do it when I want. The court's extended that grace and that favor to him, frankly, and his response is ambivalent. That's not appropriate given this posture. In every other drug testing provision, it's your visits get suspended first and this hearing happens second. In this, the court has switched that and given Mr. Wishart grace and to allow the testing to happen and then the hearing in the fact that he wasn't suspended first. But now we're in this position. The relief that I've requested is reasonable, it's appropriate.
All right, thank you. So this case is really unfortunate because I think the posture of both parties in this case is borderline appalling with how many, because it does seem like gamesmanship. I understand wanting to protect the child. The child is not with Mr. Wishart without a supervisor. Arguably, any of the supervisors are not going to want any ill will to happen to that child. And so that should be their first and foremost protection is to that child. I do very much understand the concerns. I think Mrs. Wishart, I understand her feelings and concerns about how this case has progressed. I don't know that everyone assumed that we would get a hair follicle that showed cocaine. I don't know that everyone assumed we would get UA at his initial SUD evaluation that was positive for alcohol. Those are things that I don't think anyone anticipated. and frankly do hint at a problem being bigger than what anyone's admitting. I do want to ask one clarifying question. When he did his SUD evaluation, we'd already had the hair follicle results, correct?
That's correct.
And those were not shared with that evaluator. Is that also correct?
They were shared by my client with the evaluator.
Okay. So the evaluator knew of that results when making final recommendation? Yes. Okay.
Yes.
And to be very frank, I'm concerned about missing a visit as well. I don't see how that happens. I just don't see how that happens. There's people that crawl through glass to see their kids, especially in when it's limited time. So I'm really kind of concerned as to why that happened. I don't like this case. I don't like the situation because it seems like there's no way these parties are ever going to work together, and that's only to the detriment of the child. That's the feeling I have about this case, and I hope that changes. I am going to order that Mr. Wishart get a hair follicle this week, the same type that was requested by Ms. Wishart at his own expense. That needs to happen by close of business tomorrow.
So that would be I just want it clear on the record. My understanding is that was a 5-panel hair follicle exam.
Ms. Baldwin, is that what your client prepaid for on the 14th? I don't recall it being specifically stated in any of the declarations.
I don't recall offhand. I can double confirm and I can email Ms. McLean after docket.
Okay. So whatever Ms. Wishart ordered or requested on the 14th, Mr. Wishart needs to do by close of business tomorrow at his own expense.
So if you look at the email that's attached, the last Our Family Wizard report, it says her email to him on July 14th, I prepaid for a 5-panel hair follicle drug tested occupational or performance occupational health today.
I do see that. Ms. Baldwin, do you see that? Are you comfortable with it being a 5-panel then based on that information?
That's fine.
Okay. So 5-panel for Mr. Wishart by close of business tomorrow at his own expense. I think the results of the last one were about 8 or 9 days out, so we may not have that for next week, but I want that done. If we can get results, great. If he can do it today, even better. That ups our chances of getting the results of that. There's a request for 2 weeks of suspended visits and the hair follicle. I am going to order the hair follicle, and I'm essentially going to suspend visits until we review next week on the 1st.
Just so the court is aware, I think that Ms. Kale had scheduled to view the visit, which I thought was scheduled maybe for July 28th, but I need to open up my emails. I might be able to look online or on my phone.
Are you aware of that, Ms. Baldwin?
I've seen emails associated with that. I would just ask that be rescheduled. Obviously that's not
my primary concern at this point. So I think if she wants to observe a visitation, I think that's probably beneficial to everybody. But we'll have to just forego that for this week, and that'll need to be rescheduled. So we'll review this on the 1st, and I'm going to reserve fees until the 1st as well.
And then I can just do a cleanup order that just references what you've ordered today, and we can just address that next week as well. Ms. McLean, if you want additional time, but it's going to be very simple.
Yeah, well, my first day back in the I'm hoping to be in there Tuesday morning. So
Okay.
Wasn't planning on, yeah.
I understand that. I appreciate Ms. Baldwin preparing that order. Hopefully we'll be able to enter it next week, but it's pretty short and to the point. So hopefully both parties understand what needs to happen between now and next Tuesday.
So, but you understand that I'm not going to have written objections.
I do, yes.
And I
Okay.
understand.
And we'll deal with that on the fly next week.
Thank you.
All right, thank you. Good luck.
Court will call the court last week suspended visits, ordered Mr. Wisher to participate in the hair follicle test that my client had previously requested essentially 10 days prior to that pursuant to the court order. He did not obtain that hair follicle as ordered, the original one that my client requested on Friday. He did not obtain that. So when we came in front of the court on my motion, the court ordered him to comply. From there, Mr. Wisher did obtain a hair follicle test that has been filed because the court had an opportunity to review that.
Yes.
Okay, very good. So where we stand right now is a continuing concern. That is, at this point, should be a growing concern and a substantial concern. When we look at the drug tests and the history of this case, we see that there is an initial denial as to any sort of drug or alcohol issues. We then see a delay in sort of getting that initial test until the court ordered it expressly. When the court ordered it, it came back positive for cocaine. That happened back in May. From there, he was ordered to do a substance use evaluation. When he did that, that comes along with a UA. His UA showed positive for alcohol at his substance use evaluation. So again, a concern. We then get to the court then expressly ordering him to engage in weekly UAs. He then does them unobserved, doesn't do sort of the first week, then doesn't do my client's request hair follicle, waits 10 days to obtain this most recent test, and only after your express order that you have to go do it today and I'm suspending visits, that comes back once again positive for cocaine at a high level. There's about 60 days between that first hair follicle and this current hair follicle. There is not a substantial change in his cocaine quantitation between those 2 days. Certainly not at 60 days. We're a third of the way to having it not on your hair follicle at all, or 2/3 of the way, and there really isn't any kind of substantial change there. And so again, in this case, the child, I think, is being put at risk unnecessarily and without reason in a way that's not appropriate. Again, when we have someone who's been previously dishonest with the court and dishonest with the guardian ad litem, dishonest with the process, the court really at that initial hearing when he tested positive extended grace. And I define grace as undeserved favor. The court kind of said, I'm going to give you a chance here. And the result of that, unfortunately, is we have somebody who's no indications he's in treatment, no indications he's voluntarily done treatment, such as AA or NA, which are free and readily available. We don't have a single observed clean UA in the file as we stand, and we have 2 hair follicles spaced 60 days apart that don't show a substantial reduction in his use of cocaine. We have him waiting to take tests, sort of not doing what the court ordered, sort of doing what he wants. We see him missing visits with the child, scheduled visits when his family is the person supervising. The indications are that person's reaching out and calling and texting, and there's no response. What we see is a lot of excuses and really no action on the part of Mr. Wisher. So at this point, we have him still positive for cocaine and true negative impacts of the child. I think it is a concern that even though the court said I want to see an even sort of sharing of supervision, we only have one supervision that's happened with my client side. All but one of those have happened with Mr. Wisher's family. And while I hope all supervision would be sort of equal, we all know that there's some sort of leaning in one party's favor or another, depending on who's supervising. And the concern here is sort of the glowing reports maybe sort of dismissed some of the things that another person would have seen or had concerns with. But we're in a place where Mr. Wisher isn't taking this seriously. It's not taking his sobriety seriously. And the court has to recall that my client indicated a long-term history with substance abuse that stretched back several years and which was never addressed adequately. And in addition to that, leading into domestic violence and concerns regarding that. So given and again, the court should recall, this case has been pending since April. So we have had the case pending since April, and that's when it was filed. These parties separated before that. Mr. Wisher still isn't clean, even under the microscope of the court. It isn't reasonable to continue as we are. So at this point, my client's request, and I think it is a reasonable one, is to suspend visits. What we would like to see, we want father to re-engage, but that should be with some serious sort of soul searching and some effort. So we're asking the court to suspend visits. He can resume visits upon 2 things: a clean hair follicle that includes an ETG, so essentially includes an alcohol prong to it, that he has to be clean from both, the sort of standard substances we know he's using, along with alcohol, which we also know he's using, that he needs to be in treatment, and he needs to have compliance reports showing positive compliance for at least 2 months. I think, again, those things should track together. So my client's not trying to set this out forever, but we should not be in a position where Mr. Wisher just continues to use and just shrugs the shoulders at the court or provides what amount to sort of not my pants defenses that aren't reasonable. When visits resume, it should be 2 hours with a professional supervisor to start. We don't think we should have to return to the court and cost either folks funds, attorney fees to return to the court. But I think that we should start with professionally supervised visits again, so then we have some neutral basis. And the court's current orders regarding UAs should continue; those should be observed. And he should have to again provide a clean hair follicle at his own cost to sort of return to those visits. That's reasonable. If he has stopped using, then he will be able to do that within a reasonable amount of time. If he's not stopped using, then he's going to have to make some efforts to get clean and provide proof of those efforts. That's in the best interest of the child. Again, we've been pending now for many months, and he still isn't clean, still isn't in treatment, still isn't being honest with the court.
Thank you. Ms. McLean.
Well, I totally disagree with counsel. My client is being honest with the court. When I received the results yesterday, I contacted the provider. The provider, her own words, is that it is silly to order a hair follicle.
This is not before the court. So counsel stating what the provider told her is not reasonable.
I submitted the email thread because I wanted clarification from a professional, because I'm not the professional in this case. This is the provider who has indicated that it is silly to order a test that's not more than 3 months out from the prior test, because it's going to include the same hair, which already tested positive. She agreed that there's no way to tell if there has been use.
I've objected. I'd like a really, this is pure unadulterated hearsay.
I think I'm okay with listening to the time frame. I think beyond that, I'm not going to consider anything else from the provider at this point. We don't have anything under a penalty of perjury. And frankly, I agree with Ms. McLean. I appreciate her trying to clear it up, but I feel like we're a little bit in no man's land here with knowing exactly what all of this means. But so I appreciate the time frame, but other than that, I'd ask Ms. McLean to move on.
Okay, so just for purposes of the record, obviously yesterday was my first day back from 2 weeks vacation. Even Your Honor questioned whether or not we would get the hair follicle results by today's hearing. I'm simply trying to provide as much information to the court as I can. As I told you last week, my client had an appointment with Kaiser for treatment to determine if they were going to be able to provide that treatment. They did that assessment on the 25th, the day that we were in court. They took UA and blood samples from him. They're waiting for the results of that. They did have him in a treatment class last night, and they've scheduled every Monday for purposes of treatment. But again, they're waiting for the results from their own testing as far as what that treatment plan from their perspective is going to look like. I have instructed after our last hearing last week for Mr. Wisher to start attending the AAs and NAs as recommended from the Awakenings testing. And so I'm waiting for documentation relative to that. Counsel, again, has absolutely nothing under written declaration that supports her conclusions and arguments to the court that the testing from the current hair follicle suggests conclusively that he has used since the last since the last hair follicle in May of 2023. And again, if you test within that time frame, hair grows at different time or different lengths for different time periods, and you're using averages. But the concern is, and even the test results shows that the lab took the full 2 inches of what his hair was. So, and you have Ms. Kale, who has reported at our last hearing, or somewhere along the line, I think it was at our last hearing, that Mr. Wishard, I'm sorry, I think it was in her email to us, that Mr. Wishard volunteered to her that he had not cut his hair since the last testing. So again, you have hair follicle that we already know tested positive. You see levels coming down. You also see metabolite, which suggests again that prior drug use is being metabolized and is coming out of his system. So the conclusion drawn by Ms. Baldwin in her argument is asking this court to conclude that based on those test results, 1, that Mr. Wishart is lying about his use, and that 2, that you need to conclude that he has used since his May test results. And I would argue that there is no factual basis, scientific factual basis to support those conclusions. Mr. Wishart tells you he has not used, he has not used. He's following through with the treatment as he told you he was trying to get this covered by his insurance. So at this point, we think that it is damaging for this child to be removed from a parent with whom she has a very bonded and connected relationship. The argument about the supervisors, Clay Lindbergh, who is Ms. Wishard's younger brother, as I understand it, lives in the same residence with Ms. Wishard and their parents. Mr. Lindbergh will not agree to supervise visitation in any place other than.
Hold on. Unless we have a declaration, I still object. So it can't just be like a free-for-all for whatever information wants to be provided. I'm sure I would like to do the same, but we should be bound to what's in the file, because then my client doesn't get a chance to respond.
My client has previously told you this in his declaration that was filed back on July 20th, that Mr. Lindbergh will only agree to supervised visitation either in his parents' home, which is where Ms. Wishard lives, and his concern, as he outlines in his declaration, is that that causes confusion for the child about the fact that these parties are separated. The child needs to be able to have visitation with Mr. Wishard outside of the confines and environment of her mother's home. In addition, Mr. Lindbergh will only agree otherwise to supervise in public locations. And again, my client tells you that going out in a park for 3 hours or 6 hours and not having a location where you can be in an air-conditioned or covered space consistently is a huge concern. So we need, Mr. Wishard or Mr. Lindbergh needs to be considerate of what he's willing to supervise or not supervise. My client is certainly trying to comply, but I guess we need some further parameters as it relates to, what the demands of this supervisor can be. As the current order reads, the supervised visitation is to coordinate with Mr. Wishard's schedule, and the dates and times of supervised contact is no less than 6 hours a week, coordinated with his work schedule and the supervisor's work schedule. There's nothing in there that indicates that the supervisor gets to dictate exactly where those are going to be. The whole goal is trying to provide an environment where this child can have a successful visit with her father. And she's had successful visits with Christina Wishard, providing that supervision. And as I reminded the court last week, when Mr. Wishard's visit last week was terminated or suspended, the GAL had already arranged to observe that visitation. Obviously, the GAL is going to be able to glean a lot of information about the summary conclusion that Ms. Baldwin makes, that this child is being harmed by these visits. Ms. Kale will have an opportunity to review and observe firsthand, rather than reading on a piece of paper from a supervisor, as to the sufficiency of those visits and the contacts that this child has. So at this point, we do believe that it is appropriate to return to allowing Mr. Wishard to exercise his supervised visitation. He continues to provide UAs. We're waiting for the UA results, I believe, from the last, I think those were from yesterday. So we're waiting UA results from yesterday. I believe he's taking those every Monday now. So we're waiting for those results. As soon as we get those, we will submit them. The question is on those weekly UAs, do those have to be supervised? Or I'm sorry, not supervised, do those have to be observed? And again, this suggestion, there's been no suggestion, at least in the testing documentation, that those have been forged or fraudulent. The creatinine levels are all appropriate. There's no suggestion of any dilution. So Ms. Wishard, again, takes everything to the extreme negative when it comes to Mr. Wishard, because again, she's inclined to try and interfere with that relationship, just as she did at the commencement of this case, when she withheld Addison from Mr. Wishard for 2.5 months. So we want to have some consistency for this child as far as contact with dad, allowing the GAL to provide that supervision. And we are working on getting all of the documentation. The professionals are working on that. So that's where we're at. We're asking the court to provide for that visitation to resume again this week.
All right, we have a bunch of orders as well, and there were objections to those.
I have no objections to Ms. Baldwin's proposed order from last week's hearing.
Okay, and then I have we'll leave the child support, we'll do the parenting plan and temporary order.
And just so the court has an understanding as far as what I did, you had entered a temporary order back on June 6th of 2023. And as this is an amended temporary order, it is confusing, in my opinion, when we have to go back to multiple different orders and figure out where we're at. So my intention was to have one order that we could look at so that everybody's on the same page. And so when counsel has objections that say the court didn't make these findings, those were holdovers from your prior rulings.
I can address that when you're ready.
Okay, and just to confirm, so I have a temporary family law order that was entered June 6th. Is that the one you're referring to?
Yes, that, and technically I believe that there was a temporary parenting plan entered that same day. Let me.
June 9th is
June
right.
9th, yes.
Oh, was it June 9th? Okay.
Okay, so as to amended temporary family law order, Ms. Baldwin.
Okay, so I have filed my objections, but the inherent problem is that the court didn't ever establish the incomes for these parties. The court said it sort of just, I'm just going to set family support because that's all we were doing at that moment. Now, subsequently, there was essentially a motion where the court said, okay, I'm going to end spousal / family support, and then it'll just be child support from here on out. But the court's never set what the incomes of the parties are. Because child support is directly related to spousal support, you can't just drop one off and act like it doesn't impact the other. Child support is reduced when you're shifting sort of above the line income of the parents via spousal support. And so that's where we get to the numbers. I'm saying that's fine that the court can use the family support amounts, but once you drop off family support entirely, then you can't do that anymore. Then at that point, you do need to enter an order of child support. Additionally, there's statutory requirements for Mr. to pay for his percentage share of uninsured medical, his percentage share of daycare. The court has very expressly told my client, you got to get back to work, you've got to get back to school. My client can't do that without the things that are statutorily required for him to participate in financially. So it's appropriate that we set incomes and set child support correctly. So again, I sort of left alone your order on the reductions until the court removes family support entirely, and then we do need to set a child support. We're very clear about how we arrived at the incomes of the parties. They're really straightforward. At this point, they're based on the party's actual incomes or imputed as to my client since she doesn't have income. That is very straightforward. So we're asking the court to make those changes as to the temporary order, but then beginning January 1 of 2024, the child support needs to be based and per statute based on the party's actual incomes. As far as I think that,
and just let me interrupt you. Sorry, Ms. Baldwin. So the family support I had terminating at the end of this year.
correct.
So that's okay. Thank you.
So that's why my child support order is really clear that it begins January 1
Right.
of 2024. Okay. And I put in a bracket below that transfer that the temporary order is going to control up until this point.
Okay.
At section 5B, I don't think it's appropriate to say my client was voluntarily unemployed. That doesn't really match with the facts of this case. It sort of implies that she wasn't doing anything when she was providing, she was a full-time homemaker by the parties' agreement. So at this point, she's back in school and working on employment. So I just asked the court not make that finding. I don't think the court made it then. I don't think it's appropriate that it be in the order. At section 12A, there's these lines at 11 and lines 11 through 13, where the court's recognizing that like Mrs. took this money. I don't think the court ever made that finding. But counsel made that argument, but I don't think you made that finding. And really that's an issue for trial on who had what. I think that's asking the court to make a trial finding on who had what, who paid what, what community bills got paid. So the court shouldn't make that finding as you strike that section. That's it for this order before we get to the parenting plan.
So I guess first off, I would preface this by saying that I feel somewhat at a disadvantage because as the court knows, I have been on vacation the last 2 weeks. So while I was on vacation, counsel serves her objections, which include orders that I've never had an opportunity to timely file objections to. So I guess I will preface it that way that I'm concerned by that. In any event, in regards to the objections outlined by counsel, first off, the court did not enter a child support order previously. The court did not enter calculations previously. However, if you went back and looked at the child support calculations that were filed on behalf of both of our clients, neither one of our calculations included a consideration for spousal maintenance. So the argument about above line and below line incomes was not something that the court had as far as numbers when you were making this order back in June. And so based on the numbers that we both provided to the court at that time, you set out family support, but you specifically outlined that $1,100 of that was going to be spousal maintenance and $900 of that was going to be child support. My child support calculations had set my client's child support obligation at $857 per month. Ms. Baldwin's child support calculations at the time set the child support obligation for my client at $1,089 per month. However, Ms. Baldwin's calculations did not include the $144 per month that my client pays to cover Addison on health insurance, which is an allowable deduction and consideration in the bottom line determination of child support calculation. In addition, Ms. Baldwin's current calculations, as well as her prior calculations, inflated Mr. Wishard's income. And if you'll note, even her objections outline on page 2 that she's using my client's March 17 pay stub when just last month, I believe on July 6th, we filed my client's wages through June of this year. And the reason why that's important is because my client was training for a new position. He was working substantial overtime in training for that new position. And this was all in the initial arguments before the court. He had mandatory overtime relative to that training. And so that arbitrarily inflates his income. So of course, Ms. Wishard wants to use that value. The current wage information still is inflated because we still have those first 2.5 to 3 months where he's working all of this additional overtime due to his training. And when he went from the one position from last year to the new position this year, his hourly wages actually decreased. So all of those things arbitrarily increase his wages. If you look at his last wage stub that was filed, we filed that on July 5th. That reflects 12 pay periods. And at that time, his inflated gross was $58,794 or $10,615 a month. That's $2,000 a month less than Ms. Baldwin's calculations. But go back to what your ruling was originally in June. You indicated that $900 per month was appropriate child support because you were taking into consideration the fact that Mr. Wishard covers not only Addison on his health insurance, but he also covers Ms. Wishard on his health insurance. He currently pays out $538 and 71 cents a month to cover the family on his health insurance, $144.53 for Addison, and $213.08 for Ms. Wishard. You also ordered that my client is to pay her automobile payment as well as her automobile insurance. So you took all of that into consideration at that time. And simply what Ms. Wishard is attempting to do now is to get another chunk of that apple in a vacuum without your remembrance of the fact that you've considered all of these financial circumstances when you set that at $900 per month. So our proposal is, again, that you maintain the temporary order. There's absolutely nothing that prohibits this court from entering a child support amount in this manner when you've got a family support amount. That's certainly within the abilities of this court. Counsel argues at paragraph 5A in my temporary order, 5B, that the court did not make the finding that Ms. Wishard was voluntarily unemployed. That's not accurate. The court did, in fact, make that finding. And if you go back to the temporary order that was entered on June 6th, you will see that exact language, because, again, that's a carryover. And it's not 5B, it's 5A. 5A, your direct order was spousal support should be paid for the short term due to the short-term marriage, Kylie Wishard's voluntary unemployment, the cost of health insurance paid by Jonathan Wishard to cover Kylie and Addison, and the additional financial obligations of Jonathan Wishard. So that was your prior finding. That is appropriate to remain in this order. In regards to the now request for work-related daycare, there has been absolutely no proof of any work-related daycare. There's been no proof that Ms. Wishard is employed. There's been no proof that Ms. Wishard is in school. So at this juncture, that would not be appropriate. As well as we've got an individual, my client, who is responsible for health insurance for the family, automobile insurance, automobile payment, treatment or UA expenses, and quite frankly, child support can be deviated downward when you take into consideration all of those court-ordered obligations. And so we would ask that the court take that into consideration. Right now, he's paying anywhere from $60 to $90 a week for UAs. In regards to paragraph 12A, the court, in fact, did previously make the finding about the monies being removed from the savings account. Again, I would urge the court and obviously Ms. Baldwin to look back at the temporary order that was entered on June 6th. Paragraph 12A specifically said, the court recognizes Kylie Wishart removed approximately $11,000 from the party's savings at the time of separation, which is a significant portion of the community savings. So you've already made those findings. There was no motion for reconsideration or appeal of those prior findings. And those were not brought before the court for purposes of this modification of this or amendment of this order. So I think that those prior findings remain appropriate and the objections to that are not well-founded.
So briefly in response.
Sure.
So I disagree that the court intended to set the parties' incomes, and the court never did. There's never a Mrs. is X dollar and Mr. is Y dollar. If the court will recall the hearing, counsel's like, oh, you mean Mr. This much spousal, this much, and this much child support. And the court was like, sure. Because at that point, we weren't setting child support. The court was just setting family support. So it didn't matter what the division was. So the court, I think, had no understanding that it was trying to make that. But even if you did make that order, counsel's argument is completely contrary to statute. The statute indicates that even if the court set that as this is how much for child support and this is how much spousal, when you eliminate spousal, you cannot leave child support as it was because spousal is a reduction of his income and an increase in hers. So then you're no longer basing it on each party's income. So the argument's contrary to statute, which is wrong. If you look at my child support worksheet, I included the $144, even though I don't believe there's any evidence of the breakdown. We just gave it to him on good faith. So I included that in my proposed child support worksheet. There's a statutory obligation to provide uninsured medical costs and child care. My client has provided proof that she's doing schooling and doing the things she needs to do to get back into the nursing field. So the idea that you would make the parties refile a motion for that is a bit ridiculous, especially when counsel repeatedly sort of brings up the issue of her client not having adequate finances. So I don't think that, again, those just fall flat. The last argument on the temporary finding regarding the $11,000, I looked at that, I'll concede that point. And so, but otherwise, you can't leave child support alone when you've modified or eliminated spousal maintenance. The statute doesn't operate that way. And then we haven't talked about, as far as my rebuttal to parenting plan issues, if and when Your Honor wants to hear that, I'm prepared.
Yes, I will come back to you. I'll let the GAL weigh in at that as well. And I wanted to get these orders out of the way if possible.
Very good.
One moment. All right. As far as, so here's what I'm going to do is in the amended temporary family law order, I reviewed it. It does appear that the finding under 5B and the finding under 12A were both in that original order. So I'm going to leave both of those in here. I think those were the only specific objections to this order apart from the support. And here's what I'm going to do. I do agree that I never set income. I'm going to impute Mrs. full-time minimum wage, which I think both parties agree to within $1 or $2 of each other. I'm going to set Mr. at $10,379 a month.
Gross.
Yes. And that's based off basically just taking pay through June 2023 as provided, divided by the number of months worked, and that's his average income thus far this year.
Can you repeat that number?
10,374.
Oh, I think.
Sorry, 74. I'm using my who knows how old Ford Motor Company calculator. So that's where I'm going to sit with the income. I understand that means that I won't be signing off on the orders, the child support worksheet that's been provided. So I'm going to set that aside.
Is the court allowing the deduction for the 144 and some odd cents for his coverage of Addison?
I don't have an objection if they provide the breakdown. I just don't believe I've ever seen it.
It's already been provided under seal. It was provided with the initial motion.
If you can indicate it, we can include it, and easy enough.
Well, Let me just indicate it. It
That's
is-
for the health insurance. You're
Yes.
correct. Okay.
Yeah. So
I don't think we have to do that here. I just, if you email me what date it was
Okay.
filed, we'll take a look.
Look at the sealed financial source that we filed on April 21st at pages 11 and 12.
All right. So I don't know if you want to run the numbers, I will give the credit for the health insurance, I'm assuming Ms. McLean is forthright in saying that was, she has some pretty specific numbers there. So I'll get the credit. That's how we'll get our numbers for child support starting January 1.
Okay.
So as for your amended temporary order, do you want me to say commencing 1/1/24, spousal maintenance will terminate and a new order will reflect what child support is starting January 1st, 2024?
What I would suggest is at the end of paragraph 5A
Mhm.
is that you add, bear with me, and I'll provide the language that I would ask that you provide. I just need to go back to the form. I would ask that you add the court signed the temporary child support order and worksheets filed separately.
I don't have any objection to that, so long as it's clear that the uninsured medical and the childcare costs begin immediately. The transfer payment is essentially dictated by the temporary order, and then January 1, the child support order.
Well, I guess my concern is at this juncture, I have nothing, to be quite honest, I don't even think I have a declaration relative to work-related daycare expenses. And I think that bear with me just a minute. So the order proposed by council says work or school-related daycare. I don't have verification that she's in school, what her school hours are. I don't know anything about daycare. And again, I think it's on the whole, when we're talking about working in a vacuum, you have a lot of financial obligations for my client already that support Ms. Wishard. So I think that we need to be aware or be able to have some input as to those expenses before they're blindly allocated to my client.
And I would argue council's wrong. In this case, there's a statutory obligation. When there's a statutory obligation that says you shall, there really isn't the ability to then just shrug your shoulder at it.
Where is that language? Which order are we looking at right now?
She's
Ms.
looking at the
Baldwin's proposed child support order at paragraph 22B.
so towards the rear of the document, page 6 of 9. So there's the uninsured medical expenses, and then underneath that is the school and work-related daycare.
And I believe historically, parents or grandparents and others have watched the child when the parents have needed. I don't believe that they've incurred daycare expenses previously.
My client was a stay-at-home parent previously, so they wouldn't have incurred those expenses.
Okay, so the temporary order, what I've done is, so I'm going to go back to that first, and I apologize to the clerk and to council. Under 5A, what I've done is, I'm leaving the language as it is, commencing 1/1/24 on line, it's like 24, 25. Spousal maintenance shall terminate, and Jonathan Wishart shall pay, and I'm just going to strike the 900, and I'm going to say per month child support as filed separately with child support worksheets.
Okay.
So that way it's outlined, but we're still covering it, but we don't know what that number, and that other payments commence 5/19/23 due by the 25th of this month. So I'm going to sign up on that. Okay, with approved via Zoom, Ms. Baldwin?
Yes, ma'am.
And then I want to be optimistic. My husband says I'm not, but I do try. I think I'm cautiously optimistic. That's how I phrase myself. I understand this is a highly contentious case. These are younger folks, a very young child, involved families. There's been a lot of handholding thus far, and that may continue. I want to avoid additional court dates as much as I can. Under the other shared expenses, I just interlineated under 22B, the box there for work and school related daycare. Need must be shown with proof of employment or enrollment in educational program. So if there's a showing that, hey, Mrs. is now employed full-time at X, okay, then it is what it is, and that goes into effect. If she's enrolled in school, proof of that, and it'll take effect. start taking effect. Obviously, it does sound as though there's a lot of familial support on both sides, which is great. And so the more they can utilize that, the better, but understanding that's not always possible. Any other?
But the court's not entering those worksheets or the child support order because the worksheets don't comport with your finding on incomes.
Yes, I just wanted to clarify. So hopefully we'd have an agreed order when we
come
back. But that's how I'm addressing that portion. I'd like that language just to be included.
So would you say that one more time, please?
Sure. The need must be shown with proof of employment or enrollment in an educational program.
Could I just ask, especially, and work or school hours?
So here's where we get into a huge mess. So in a case where domestic violence has been alleged, there are photos of holes in walls. The idea that he's going to be able to demand from her on a weekly basis her schedule is not appropriate. And most kid daycare is not an hourly rate. It is a flat rate. So to me, it's once you're in school or you're employed full-time or part-time, that sparks the obligation. Continuing, we're going to, in a case where we're already sort of getting into minutia, that's going to require a monthly minutia dive that I don't think the court should engage in given the allegations or frankly, given the judicial economy.
Well, if she's going to school, 2 days a week and she's got the child in daycare 5 days a week, my client, there needs to be proof of that.
Yes. And I agree with that. Hold on.
And I would also,
sorry, no, I just need to turn my fan on. That's
okay. I would also remind the court that you already made a finding that this isn't, in your opinion, it doesn't appear to be a domestic violence case, given the evaluation from Ms. Lovely.
I made that comment based on those, but ultimately that's reserved for trial. So, and it's still being alleged. And so I'm not making an official finding on the domestic violence at this point. I understand both parties' concerns here. And I would agree. I don't think there's a request for a schedule, but if she's working part-time, full-time, that could, and if she's enrolled full-time or part-time, I think those things should be, the other party should be notified. If it's part-time school, part-time work, equating to essentially a full-time job between the two of those, but I don't think a schedule of classes or work hours, none of that is appropriate. So, but I think it is appropriate to let them know. If she's taking one class once a week, that's different than if she's on a full load for the next foreseeable future in studying and taking classes is different.
So just because I don't want to come back on presentation and argue about it. So would it suffice to add language that mother will notify or provide proof of full-time or part-time employment and full-time or part-time enrollment in school? So it's very clear, she's going to provide like either a letter from her employer or saying she's employed full-time or a letter from school saying she's enrolled full-time.
I think that is fair. Yes.
Okay.
All right. So I've signed the amended family law order. Then we have the amended parenting plan is the only other order that we have. And I know that there are some additional concerns there, and I allowed both parties to argue. Ms. Baldwin, do you want to rebuttal before I turn to the GAL, or would you like me to stop at the GAL before you?
You can take the GAL and then I'll argue.
All right. Ms. Gal, if you will have any comments regarding visitation and the proposal of Ms. Wishard and proposal of Mr.
Well, Your Honor, as you know, I wasn't able to observe Mr. Wishard for a visit yet. And so I have a hard time. The information I'm bringing to you is based on the observations that I've had of seeing kiddo with mom and then information that I've been given from the visitation supervisors in terms of notes and interviews as well. I am of the opinion that Mr. Wishard should be able to have supervised visitation with kiddo. I feel hesitation to suspend visitation when we have a hair follicle test that is not 90 days old yet. Taking visitation away from a parent, as we all know, is a very, very serious issue. And I don't believe that is the healthiest thing for kiddo at this point in time. She's by all accounts, very emotional when she leaves her father and really enjoys her time with him. All of the reports we're getting not just from Ms. Wishart, Christina Wishart, but also from Beth Fellows, who was a professional supervisor and spent time in the presence of Mr. Wishart and Addison together, and I was able to interview her both on the phone and then also read her notes. She said specifically to me, I see no red flags. I don't have any concerns regarding Mr. Wishart in terms of a supervised visit. I would not advocate for an unsupervised visit in any way at this time until we see quite a period of time of being clean and sober. I don't think that's in dispute at all. I would be very curious to see a hair follicle test post 90 days from the initial May test. I also agree that I think it would be very beneficial to have the UA be observed. We are getting negative tests, except for this one that's within the 90-day window of the first hair follicle. The information I have at this time is that Mr. Wishart during these visits is engaged. He follows the lead of kiddo. He plays with her. He asks her about her interests. He makes sure she's fed, that she's got sunscreen on when they're outside. All things that a parent would be concerned about in the presence of this child seem to be taken care of and taken into consideration when he's with her. After my interview with Christina Wishart, where we were able to kind of discuss him as a parent, having known him for a very long time, as well as knowing Ms. Wishart, Mom Wishart, for many, many years, and had a trusted relationship with her. It sort of set me in the direction of wanting to talk with Mom about why she was concerned regarding Christina as a supervisor. And the concern really is about wanting to be seen in the correct light, and is concerned that that Christina may not offer an unbiased view of Jonathan as a father. But Mr. Wishart, I would also like to say, I can understand why Mr. Wishart is uncomfortable in the Lindbergh home trying to have his visitations with his former brother-in-law. There's a long-standing history of contentious relationships between Mr. Wishart and the Lindbergh family, in terms of they want him to take accountability for things. They want him to offer apologies directly to them. Some of the arguments the mom and dad have gotten into in the past were in regards to input from the Lindbergh family in terms of their marriage. And so I can appreciate why being in the home with Clay Lindbergh, where the Lindbergh parents are, might be deeply uncomfortable for Mr. Wishart for extended periods of time while he's trying to have supervised visitations. I can appreciate why Mom does not trust Mr. Wishart, and I don't think that she owes him that in any way. But I think the separation between the relationship between the parents and the relationship between Mr. Wishart and child is very, very important. And I think that those are two different storylines that we have at play here. And so trying to protect those two different storylines, I think, is very important. So I, for one, would advocate for asking for a fresh hair follicle test post 90 days of that May hair follicle test, so that we can get a clean look at where he's at. I would advocate for him to be able to continue supervised visitation.
All right. I appreciate that. Thank you.
Thank
Ms.
you.
Baldwin.
Thank you. Nowhere has my client said that father's relationship isn't important. She has said his relationship is so important that he needs to be clean and sober. And the reality is that Mr. Wishart is not indicating in any way that he is interested in his sobriety. I'd argue counsel for Mr. Wishart is more invested in his sobriety than he is. When you look at his SUD report of his evaluation, I believe it says he was ambivalent to change. That means he's also been ambivalent to getting into treatment, ambivalent about doing AA and NA, ambivalent about taking drug tests when ordered. And the reality is that he really hasn't. He hasn't done anything except, unless you've held his feet to the fire and say, do it now. He hasn't done it. If anybody else is saying you need to go do it, he just shrugs it off. He's able right now to basically schedule his drug use and his UAs to make them clean, and to be able to get a UA that's clean, because he's able to schedule it on Mondays. That means that he has a couple days that are basically free to do as he likes, and we still have a dirty UA or a dirty hair follicle. Of the UAs that he's provided, none of them are observed, which counsel doesn't deny. So again, a huge red flag there that they're unobserved. We have the court is, I think, well familiar with hair follicles, and so but again, we have a situation where there's really no indications he's getting clean into treatment. That's what my client wants. She wants him to get clean. She wants him to be a good parent. She wants him to be clean and sober. But Mr. Wishart is ambivalent. These are the words used by the experts regarding his SUD history. And this is not a short-term history. This is a years-long history. And it has not been motivating for him so far. We have to figure out what will motivate him, because so far we're not doing it. We have not gotten him clean. This case has been pending again since April, and the parties separated before that. They knew they were getting a divorce before the filing of this case. Counsel sort of throws up her hands and said, my client was wrong in denying him visits. He was using cocaine. That is a correct parental action, to say you're high, you don't get to have unsupervised time with our child. To say my client was wrongfully withholding is ridiculous. She was doing exactly what we would have wanted her to do. When she says, you're still using, go take a hair follicle, just says no. What are you going to do about it, essentially? And my client is forced to bring us back before the court for review. The gamesmanship with visits is a false narrative. We have previously said that my client offered 10 people. The only person he approved was Mr. Lindbergh, was my client's brother. This is the only person they've chosen out of 10 to supervise his visits from my side or from my client's side. Similarly, this idea that they're only doing visits in my client's house, absolutely false. Again, we've provided information previously to the court record and saying it's, in this case, Mr. Wishart who says my way or the highway. And that has been the problem. We have Mr. Wishart missing visits, giving excuses. Even his family is saying, calling him, texting him, and he's missing visits. This isn't good. This isn't going well. The current court orders are not working. They're not working to get Mr. Wishart clean and sober. He's ambivalent. And we need to move him to be motivated and to be clean and sober for this child for the long haul. I don't disagree with the guardian ad litem's recommendation for having Mr. Wishart retest at 90 days. That should be at his dime. But I don't agree that we should continue to have visits pending that because what we don't have is any indication he's getting clean right now. And he should have a real good motivation to get there when we're essentially 4 or 5 months in and he's not clean. And he's still not. So again, my recommendation that we suspend, it shouldn't be a can that we kick down the road repeatedly. We've already done that and that has not worked. So I would recommend that we suspend. If the court wants to suspend and come back essentially with the 90-day hair follicle, I wouldn't find that to be inappropriate. But I think it's appropriate that it include an ETG. So it's clear that whether he's using alcohol or not. So we're not just substituting alcohol for cocaine. And then secondarily, he needs to be in treatment with compliance so that we see that he's actually motivated. And if it's, hey, I couldn't get in, but here's all my AA and NA slips, great. I think that would be reasonable. My client is not unreasonable, but what she wants to see is some effort on Mr. Wishart's part to get clean. And ambivalent is not a choice when you're a parent.
All right, thank you.
May I just respond since I haven't been heard on that issue?
Briefly.
So again, I think even Your Honor commented about optimism. Ms. Wishart continues to be rear-looking. Mr. Wishart is forward-looking. Mr. Wishart is taking responsibility. He's not ambivalent. He is doing what the court has ordered him to do. The other concern is that the suggestion that my client only agreed to one supervisor, the court ordered each party to agree to one supervisor on each party's side. So the suggestion that somehow my client should be assessed some blame is not well-founded because the court ordered each of us to pick one supervisor off of the other's list. So again, we're following through with what the court has ordered. There are concerns as it relates to obviously timing and getting information from professionals. That's not something where I can just snap my fingers and get something overnight. So again, if you go back to his SUD evaluation, they recommended 30 days of treatment to be reviewed at the end of that 30 days. We're not even looking at a 6-month program, a 2-year program. There's been absolutely no finding that he's an addict. So again, they're taking snippets of information and basically making a mountain out of his past transgressions rather than allowing him to work through this process and provide the court the evidence that you need. But again, we have a young child, a 3-year-old child here who does have a bonded relationship with her father and should be allowed to continue that visitation. Does the court want me to discuss my comments in regards to counsel's objections to my proposed parenting plan? Because we haven't been there yet.
No, not yet. Let me make a decision here first.
Okay.
And then we'll jump to the parenting plan and see if that's something I can work through or if we need to have a new filing. Okay, so this case is, I think I've expressed some frustration about this case before, and I don't mean to minimize the concerns that all the parties have in this case of all the different working pieces that we have going on here. What it really comes down to, we had a UA that wasn't done in a timely fashion. It was followed up by an unobserved UA that I believe came back clean. The hair follicle, we see the results of the hair follicle.
No, you do have those. You have those yesterday.
That's,
The hair follicle tests were
yes,
filed yesterday.
we have the hair follicle. Yes, we have those.
Okay.
What I don't know, okay, I did pull up the old hair follicle and this hair follicle, look at the numbers. They are relatively similar. Is that because, and here's where conjecture comes in, because I think as much as Ms. McLean tried to attempt to get some clarification on that, even the email attached doesn't clarify that, other than to say any hair follicle before 90 days may be concerning, because you could see the same thing. So I can't sit here and assume the results are showing continued use, just like I can't sit here and assume that they're not showing continued use. So here's where I'm at. I understand mom's request, and I don't think it's frankly unreasonable, but I guess I'll show what I think is I guess continued grace. I am going to reinstate visitation, but we're going to go back to 4 hours. It will be supervised. And it's going to be supervised by Ms. Wishard's supervisor until we review. We're back on the 15th. So if there is an additional person that Ms. Wishard has put forward as a supervisor that Mr. Wishard is willing to agree to, so Mr. Lindbergh doesn't suffer the repeated requests of this, I'm fine with adding an individual as long as they sign off on the supervised visitation conditions. That does not have to take place in the Lindbergh's home. It can take place in a variety of different places. There's sounds like Ms. Baldwin's indicating that they're not requiring it to be in the home. I understand the concerns there. Ultimately, what we have is I don't think we're talking about an aunt and an uncle that have stepped in and supervised for this young girl. Neither of them are going to want anything to happen to this child. So I trust that as much as there's concerns for, well, I want my sister or I want my brother to come out on the better end of this, I don't think, and I would frankly hope that want isn't greater than the safety and well-being of this little child that this family is trying to care for and raise. So, but for the time being, Mr. Wishard's, I'm going to reduce it to 4 hours supervised, and we're going to use Ms. Wishard's supervisor. We're coming back on the 12th of September. My calculations are that we should not do another hair follicle before August 19th, 2023. So I want to, if there's any request for a UA from Mrs. to Mr., it shouldn't be a hair follicle before that date.
I'm sorry, before which date?
I have August 19th, 2023.
Yeah, okay.
That sounds right.
And in looking at the calendar, since we're here on the 12th, and that's currently set as a review hearing for a final GAL report, I frankly don't know if we'll have it by then, given kind of what's been going on, but we're keeping that review date. So I'm thinking that the hair follicle should be done on the 4th of September.
Is that at his cost?
At his cost. That should put us outside of the 90-day window. He should not cut his hair in the meantime. And
Sorry
yes.
to interrupt, just to note that September 4th is Labor Day, so I'm not sure if he'll be able.
So the average return date has been about 6 days. I don't want to say the 5th, and for fear that we wouldn't get it back by the 12th.
You can do
So
it.
how about must be taken? I don't want it any earlier than September 1st and no later than September 4th. So between the 1st and the 4th of September, hair follicle. I don't know if they're open on weekends. I feel like one of you indicated they were not.
They are if you pay an additional fee, which I think is $100.
Okay, well then Friday the 1st would be.
Yeah, that's fine.
So, and any requests for a UA before then, I don't want it to be a hair follicle. If UAs moving forward should be observed. Frankly, as far as the 4 hours, if that needs to be split 2 hours based on supervisors or all in one, I defer to the parties.
And I guess my other question or concern is, I think it took us 6 weeks to get documentation signed by Mr. Lindbergh the last time. So can you set some parameters on these supervisors? I want my client to have a visitation this week.
So that was due to confusion on my part. I didn't realize that council had included her own form of the order. We created a very similar form. Council rejected that form. Then we redid her form. So that was sort of a rigmarole that I think was a somewhat created problem in the context of the reality of the supervisions. If he approves somebody else, we're going to get him signed up immediately. We now have council's form of the supervision contract in our system.
So he is ordered to have 4 hours a week. So if they don't provide it, then I'm assuming there's action that can be taken. I would hope that that Ms. Wishard and her folks would continue to try to make efforts as much as I know that they're concerned about this. Hopefully the concerns will be quelled a little bit by the fact that it's her own supervisor monitoring these visitations until we come back on the 12th of September.
That's fine. The court sort of gave two different dates. You said no new hair follicle, at least requested by my client before August 19th, and then said September 1st.
I'm going to say because I'm ordering September 1st as the hair follicle, so I don't think she can, of course, request a UA, but let's not no hair follicles until we come back on the 12th, other than the one I've ordered on the 1st.
That's certainly agreeable. I just want to confirm. And then second, is the court requiring the hair follicle to include an ETG, which is the alcohol portion?
Yes, and I apologize. I'm gonna add that in as well. So
we do still have some objections. I think you could use the form of the order that's there. If the court wants to give us rulings and come back, that's fine too. I'm fine with whatever your honor wants to do.
I think I could potentially use this, Ms. McLean. Would you agree that you're proposed here? The first, let's walk through it and see. I have the first objection on page 2, section B, subsection 1, adding the language that the supervisors have signed the visitation supervision rules. Any response to that, Ms. McLean?
I'm sorry, you mean 4B1?
Yes, sorry, 4B1 on page 2.
Yes, I agree that Christina Wishard and Clay Lindbergh have signed the supervision rules now.
That's fine. I'm fine if the court calls them out by name.
But that doesn't take into consideration. So my understanding is that your ruling is that Christina no longer supervises.
For the time being, until we review on the 12th.
Okay. So, I mean, okay.
So how about if what if I just add all supervisors must have signed the visitation supervision rules?
Timely signed the visitation rules.
Well, that's true. I mean, you've signed before you do it.
All supervisors must have timely signed the visitation supervision rules before supervision.
Right, but isn't that already there at line 1920? So each non-professional supervisor and all parties shall sign attached visit supervision rules. So it's really there already.
I'm just going off your objection, saying adding the language that the supervisors have signed.
Right.
So,
I don't know that it's necessary. We both have copies of those.
That's fine. I'll leave that one just so that we can.
All right. And then I'm going to change from no less than 6 hours to will be as follows, commencing at 7/10/23, 4 hours a week.
Okay.
Then the next objection. Oh, there were some Scrivener's errors in 2A, Ms. McLean, that Ms. Baldwin pointed out on page 3. There was on line 4 or 5.
You mean, I'm sorry, what page are you on?
Page 3.
Top of page 3.
B2A or 4B, sorry, 4B2A.
Okay.
The father's next visit shall be forfeited if the father submits. So there was a period and a new sentence started there, and it was suggested that should be one sentence.
So, okay, so the first one is if he fails to provide the first part of that language is if he fails to provide the testing, or if he fails to provide, then it's considered a positive, then his visitation would be forfeited. If he submits to the testing and it shows positive, or there's validity concerns, then it would be reviewed and his next visit would be forfeited.
Right, so on the line after docket notice, it says the father's next visit shall be forfeited. And then I just made, if the father submits to testing and said testing shows positive for illegal or non-prescribed drugs, including marijuana or alcohol, or has validity concerns.
Okay,
So that's one sentence.
okay,
And then period and capital T, the father's visitation shall be immediately reviewed.
okay,
And then I just add under B on page 3 on line 12. I just added the word observed, even though it's in subsection A, I just add Jonathan Wisher shall participate in weekly observed urinalysis.
okay,
It made no other changes there. And then under section D, there was an objection to section D under 4 for that entire portion to be eliminated. So if you want to respond to that, Ms. McLean.
well, again, I believe that that was the court's finding from the hearing. And you did not make any 191 findings specifically to domestic violence.
And the court just recently said, that's really reserved for trial. So I just don't think the court intended to make any finding either way.
I mean, I am going to strike this, that 191 is reserved for trial. And the request is to just add in that our family wizard is the only, is the method of communication barring any medical emergencies.
And my understanding is they're already doing it. And so I just want to make that clear that that's how they're to communicate.
So, and I would suggest, well, first off, this was a recommendation that came in from the guardian ad litem's email to us for our last hearing that hasn't been ordered by the court. I anticipate that the court would likely provide for that. I think that it should be added under paragraph 4A as another paragraph 4. The party shall communicate through the Our Family Wizard app.
Sure, it can go anywhere.
So under 4A on page 2.
Add 4.
Okay, I can do that.
And that would be at their own expense.
I agree.
I mean, we need to remove Christina at this point and indicate Clay Lindbergh or
Other agreed.
other approved respondent supervisors.
I think other agreed is the same, but easier to fit in that space.
Well, I want it to reflect the court's requirement that it be Ms. Wishard's supervisor.
Is this going to require if I change that on the 12th of September, are we going to need another new order then?
I'm assuming we would need a new order no matter what.
Okay. So I will just, or I'm going to strike the Christina Wishard for now, put in a little asterisk, put down here, other approved supervisor.
And then I'm assuming then we don't need the language as it regards to the expectation that they alternate. I mean, because the reality is if we can find one of her supervisors who can be consistent, that's probably going to be helpful in clearing up a whole bunch of continuing conflict.
That's fine. So eliminating sort of the sentence right after Christina Wishard, expectation that they alternate. I'm fine to eliminate that sentence for clarity, or at least for this kind of upcoming month and a half.
Okay. Any other concerns with this order?
So we still need to include the obligation that he obtain a hair follicle at his expense, essentially on September 1, which includes an ETG UA. You can put that, I think the court can put that anywhere it chooses. It fits probably on this page, or you could put it at the bottom of mid page 3, right below the B where you added the observed UAs. You could kind of push a C in right there.
Same date.
And then if you go back to page 2, at the bottom there for B2A, remove the hair follicle and quite frankly, I think the nail test, because that would produce the same result.
I'm sorry, what page again?
2.
Very bottom, last 2 sentences, or last 2 lines, excuse me.
I could, well, because the court said the mother can still request an observed UA. Yeah,
correct.
So
Just the hair follicle and nail.
Hold on, let me just, because then that's nowhere. So my concern, okay, this is where counsel puts her. So my concern is it implies that the court's in the future eliminating that ability. I prefer to leave it as is, add a paren, sort of right, there's sort of a line that strikes all the way across for pleading. Just add a little star to hair follicle and nail test and write a star below that line that says may not be ordered until after 9/1. And then that makes it clear that she can order them after 9/1 if she wants.
Or alternatively, strike the 2 that I've suggested and say reserved for review hearing on 9/12/23.
But that's not what the court did. The court said she couldn't order them until 9/1. not that you were eliminating her ability to do that in the future.
Okay, so what I did is I just put an asterisk after hair follicle and nail tests, indicating these shall not be requested until after the hearing on 9/12/23. So there's a clerk's action required already noted on here. Let me, I will get that sorted with Miss Wade. If, it sounds like Miss McLean, you don't object to that.
No.
Any other concerns with this order?
I believe that does it.
All right, and Ms. Baldwin, approved via Zoom?
Yes, ma'am.
And Ms. Kale, is that okay if I indicate that on your signature line as well?
Yes, Your Honor. Thank you.
Thank you. All right, I will get these taken care of with the clerk. And as frustrated and pessimistic as I can be, and I know I can be, I really do wish these parties the best of luck. I hope I don't see anyone before the 12th of September on this case, and hopefully we can make some good progress between now and then.
Thank you.
All right, thank you, counsel. Wishart and Wishart 23300174008. I'm sorry, I always call you last. The W's are at the bottom, and that probably I should do the reverse one day. I was an A in school, so it wasn't always to my benefit. I apologize. All right,
So
we're here for review of a GAL report.
Yes. So the GAL has emailed both Ms. McLean and I that she's still working to finalize her report. I find that to be reasonable. She's waiting on drug testing that just came in yesterday, and potentially some additional information based on arguments today. And she asked for additional time. I was fine with that. I think Ms. McLean was also on board with that. She didn't believe she needed a whole lot of additional time. I don't know that I need a review to ensure compliance, essentially to ensure that she issues her report. If the court wants to set one, I would just ask that we set it towards the end of October, within lines of Ms. McLean's availability in mind, which I'm not sure where the confluence of those things comes in October.
So we had proposed that Ms. Kale's report be submitted to the parties no later than October 13, which I think she indicated was agreeable to her calendar, but she can let us know otherwise. And then on my calendar, I'd looked at setting the final review hearing for October 24, which I think would still be appropriate for the court to consider if you are going to adopt any interim report or any interim recommendations pending maybe setting it out for additional hearing and the like.
I'm fine with it.
And of course, parties can always agree to strike that if we want to submit full declarations and the like to the court.
Does that October 13 date work for you, Ms. Kale?
Yeah, absolutely. In fact, the two things that I was waiting on, which were the drug test results that we just got in, I believe came in yesterday, as well as I wanted the opportunity to observe a visit with Mr. Wishart, which I was actually able to do this weekend. So this report really, I'll have this report done probably within the week and filed. And so whenever we're available for these attorneys to be there, I'm ready to roll. There were just a couple of pieces I wanted in place first before we made some final recommendations.
Does that change the suggested timeline of anybody? I mean, do you want to bump those dates up? Or I know that Ms. McLean, you indicated you were going to be gone some first part of October, and
Yeah,
I know how
the
Ms. Baldwin is as well.
I'm gone the first week of October, and then I'm in a 2-day trial. I don't know when that's going to fall, the third week of October. So that's why I had suggested October 24.
That the 24th is sort of my first availability for dockets.
Okay.
Okay. Well, then I will adopt the report due date. We'll just make it noon on the 13th of October, and then a review Tuesday, the 24th, 1 p.m.
Okay.
Very good. So that takes us to our review. The court should have, I believe Ms. McLean and her staff sent around the hair follicle tests as well as the UAs that have come in. And we were set to review visitation as well as what the result of that of the hair follicle was. Hair follicle at this point shows that Mr. Wishart is clean from cocaine, but not clean from alcohol. And that continues our concerns. It's not uncommon where we have somebody with an issue with substance use disorder sort of have multiple issues, and then they can sort of get clean off of one substance, but not off of another. And we do see that. And at this point, we have persistent substance abuse over a fairly lengthy period of time that this case has been pending. In the materials that they filed within the last week or so, they also included an updated substance disorder evaluation from Kaiser that is dated July 25th, finding that he has a moderate risk of alcohol. But it's key to also understand that that is before this latest round of testing and evaluations. And there's no indication that that evaluation considered any collateral input. And there's no indication that that evaluation considered the awakenings evaluation that was done back in June. So essentially, it's just a cold evaluation without any collateral input. And it still finds that he is a moderate risk. So again, for alcohol. And interestingly, and again, that's not considering the most recent hair follicle that finds he's still using alcohol. That latest substance disorder evaluation says he needs treatment twice a week for 12 weeks. Then they filed some additional progress reports talking about his treatment. And those are actually quite interesting. When you look at them, the report date of that saying essentially the compliance report date is dated September 1st. And it says these are the days he's attended. So essentially has this evaluation sort of week 1, and then you start seeing him attending groups week 2. And what it shows is the very first week that he started attending these groups. And he's supposed to, again, twice a week. You see the very first week, he only attends 1. So arguably partial compliance. The next 2 weeks, so this is the week of August 7th. So he attends two groups there, so compliance. The following week, August 15th, 2 groups there, compliance. But the next 2 weeks, which is August 21st and the week of August 28th, no compliance. He didn't attend any groups those weeks. And we know that because the letter is issued September 1. So we know he had partial compliance for a week, compliance for 2 weeks, non-compliance for 2 weeks with this. And it's relevant because when we think about whether or not Mr. Wishart is safe, whether or not he's doing what he needs to do treatment-wise, this gives us the impression that he'll do it for a little bit, but then immediately falls off. And it's notable that in that original Awakenings SUD evaluation, it said he was ambivalent about the need to change. And that's sort of denoted here by his willingness to attend these groups. Also, very interestingly, the Kaiser evaluation says it's not just the groups that he's supposed to do. He's also required under that treatment plan to engage in random UAs. And you don't see any of those in the file whatsoever. It's not clear if he's just not doing them or if he's done them and he's just not providing those results. But we don't see any of them in the file. What you do see are the UAs that are self-directed by him, self-timed by him. So he's able to essentially clear his system, at least as to his UA, and then provide those results saying, look, I'm doing so well. But the hair follicle then undermines that, saying, well, actually, you're not. You're still continuing to use far past your clean date. And again, it's a concern that we don't have any of those random UAs that Kaiser indicates he should be doing. Either they're poor results for him or he's just saying, I'm not going to do them. And because there's no indication that they have any cost whatsoever when he's doing them with Kaiser. So this really throws in a lot of issues with this. We have Mr. Wishart, who at this point has a long history of not being honest with the court. And we see back in April and May and June where Mr. Wishart is denying all substance use, and he's getting caught with cocaine not once, but we have 2 hair follicles with cocaine. We have we've got UAs with alcohol. Even his Awakenings UA that was part of his substance as SUD evaluation has alcohol in it. This most recent hair follicle indicates continued use of alcohol. And we have to remember, it wasn't just the court that Mr. Wishart was dishonest with. It was the guardian ad litem. It's the providers, where the provider in Awakenings is like, yeah, these stories don't line up. And when I'm getting a positive UA, his story really doesn't line up on his, ability to change, desire to change in his statements about use. So that takes us to what do we do? This is a very young child. This is a child who is not, as a practical matter, able to self-advocate and to make herself safe. She would not be safe in sort of even a general household setting on her own. This again is a sort of toddler age child. My client, based on these most latest results and sort of some of the things that should exist and don't, is asking the court to maintain the current parenting plan, or maintain the current plan, I should say. It's not really a parenting plan, so I call it an interim plan. And that's Mr. Wishard's receiving a couple hours a week, supervised by my client's family. That needs to continue until Mr. Wishard is clean, until he's maintaining his sobriety, until you see compliance with the SUD evaluations, including the most recent sort of one that's cold without collateral input. Even that says he's in moderate risk, and there's no indications that he's in full compliance. We have some partial compliance and then just weeks with straight no compliance. And that does not indicate a strong pathway to sobriety that would result in regular unsupervised time. So the current plan for visits should remain. It's notable that Mr. Wishard never says that any of the supervisors who are currently supervising are anything but gracious and kind and welcoming and available. Visits by everyone's account are going well in the current system. And so again, there's no indications that anything's going poorly. This is a safe, quality environment that the child's doing well in. And this decision isn't based on Mr. Wishard's comfort or Mr. Wishard's desires. The focus instead is on the child's needs. And when you look at the hierarchy of need, safety is that base level. Child has a right to be safe and deserves to be safe. And the current plan is in the best interest of the child. And we hope that Mr. Wishard does become sober, but we don't have those indications yet. We have the indications that he's not going to the treatment that's provided for him, that he's just choosing not to do that. So again, in this case, we're asking to maintain the current order. We're set to review now out into October. That essentially gives Mr. Wishard about 6 more weeks or so. And I think at that point, then we can look at his compliance and his sobriety and see if he's maintained that. And he should be required to provide those random UAs and compliance reports. And those should be part of the guardian ad litem report. If these random UAs are out there, guardian ad litem should have them and he should be required to provide them. If he has not done them and just declined to do them, he should also have to disclose that as well. Because I think that that's indicative of whether or not he's has a true intention for sobriety or a intention to continue doing what he's doing and sort of just covering it up and taking the UAs when he knows he can get clean for a couple days, but then partying when he wants to. So the current plan is working for the child. It's working for Mr. Wishard. He doesn't like it, but it's working. So we ask the court to maintain it. It's safe, it's practical, and it works.
Thank you. Ms. McLean.
Thank you very much, Your Honor. So first off, one of the difficulties as far as sort of doing this as a short notice shotgun with declarations that have just recently come in and now arguments by counsel that are sort of beyond her client's declaration is in regards to the arguments as far as the UAs from Kaiser. So first off, had I known that that was an issue, I would have directed my client to try and obtain those. I'm not aware of when or what UAs Kaiser has had him do on a random basis, and those certainly aren't outlined in the progress notes. But again, doesn't indicate that he's not in compliance with that. Counsel goes through specific dates in regards to that progress note from Kaiser that outlines when he did, when he attended groups. And I apologize, had I known that that would have been an issue, I probably would have attached another copy of my client's work schedule to his reply declaration so that that would have been a little easier for the court to follow. But if you could go back to his declaration that was filed with the court on July 20th of 2023, I had attached to that declaration his work schedule. And if the court recalls, he works 4 on, 4 off. When he works, his first 2 days, which are identified as ones on those schedules, are day shift. So he works from 6 a.m. to 6 p.m. And the classes with Kaiser are from 5 p.m. to 6:30 p.m. So he is at work, and he, as he tells you, he's been trying to work with his employer to get FMLA approval so that he can take time off work early or come in late when he works graveyard shift. And graveyard shift is identified as a 2 on his work schedule. And when he works graveyard shift, it's 6:30 p.m. to 6:30 a.m. And he works in Kalama, and so he has to leave here basically 30 minutes in advance in order to get there and then to get into his workstation, wherever that is within the facility. So that's why you see on the progress report, it indicates that he has the partial treatment groups of 60 minutes of a 90-minute group, because when he works day shift, he's not able to attend. He's at work until 6:30 p.m. When he works graveyard shift, he has to leave by 6 p.m. So he's leaving 30 minutes early. That's why they say it's 60 minutes of a 90-minute. When he has his rotation of days that fall off, when he's off, then he's able to attend the full session. So if you go back to that work schedule and look at Wishard, and if we start with July 31st, and let me just align myself here. So July 31st was a Monday and he was off. I'm not certain why they're saying that that was only a 60-minute visit. My understanding is that he would have had a full 90-minute visit. And he also had August 1 off, and I'm not certain why that's not referenced here. So, I mean, that's stuff that I guess I should follow up with Kaiser, because I'm unaware of that. If you go, so his classes are Mondays and Tuesdays from 5 to 6:30 p.m. So again, if you go to every Monday and Tuesday, on August 7th, he was working graveyard shift, so he was able to go to the 60 minutes, which is referenced. On August 8th, he was off. So my understanding is that he attended the full 90 minutes on August 8th. On August 14th, he worked graveyard shift, and it identifies that he was there. And the assumption is that that was a 60-minute session, and same with August 15th. I can't speak as to, so August 21st was a day shift. He wouldn't have been able to attend because work gets off at 6:30. On August 22nd, my assumption is that he would have attended, so I'm not sure why that's not marked. I don't know what records. Obviously, this was prepared as of September 1, so I'm not certain as to why it doesn't address those. I can certainly reach out to the counselor now that I'm aware that those are concerns. To be quite honest, I didn't compare those with my client's schedule at the time. What I discussed with him was why is it saying 60 minutes of a 90-minute session? And that was the explanation given work. So he's still trying to work with his employment to work on getting FMLA so that he can attend those. In regards to the drug testing, we did receive those after my office closed last night. And so we processed those out immediately this morning. In my discussions with my client, he did acknowledge having 2 shots of alcohol at his sister's wedding, which I think was 2 weekends ago, or would have been the weekend before September 1. And so he does acknowledge that he did have those. I was aware of that today for the first time in reviewing his test results. As the court knows, it's not uncommon for individuals to have relapses as they're going through the treatment process. And that's why it's important to have a treatment plan in place so that he's got counselors that can help him deal with those setbacks. Even Ms. Wishard in her own declaration acknowledges that she expects that there's going to be setbacks, and relapse and recovery are part of the program. It's a learning process for Mr. Wishard as well as every other individual who goes through sobriety and treatment and trying to navigate through the process, coupled with the fact as far as trying to navigate through court hearings and financial demands and the like.
I'm pleased, and Mr. Wishart should be celebrated that he does not show positive for drugs, which his previously had tested positive for. I think that that's an accomplishment, and again, goes to the fact that the second hair follicle that Ms. Baldwin is relying upon, again, was part and parcel with the concerns that were raised by the testing agency as to why were we doing a second hair follicle with before a 90-day lapse in time frame. And so now we can see that for the last 90-day period from the time of his first hair follicle to the current hair follicle, he has not used any illicit substances or any marijuana, which again, I think should be celebrated. Every step through sobriety should be celebrated. In regards to the alcohol, yes, he still needs to work on that. He needs to recognize what those triggers are. And that's part of going through counseling and the treatment and learning how to navigate social experiences like a sister's first wedding. And that while you want to be able to celebrate in having a shot of alcohol or two, in this circumstance, you're not allowed to, and that this is going to be the impact. My client obviously wants to continue to have a relationship with his child. When you go back and look at all of the visitation notes are positive. He has a very bonded relationship with his child. The child is happy to see him. The child is sad when the visit is over. The child expresses missing him, which again talks to his bonded relationship. So quite frankly, there has been no evidence that during any of the visits that he has been intoxicated or under the influence. There has been no supervisor that has stopped or terminated a visit. All of those have progressed, and the child's relationship with her father should progress. So we are asking that the court consider unsupervised visits. If you're not going to consider unsupervised visits, we're asking that you expand those supervised visits, because, you know, a couple of hours, a couple of times a week is really not sufficient for the relationship that this child has, and she's still outwardly expressing missing her father. I understand counsel's arguments about safety first, and obviously the supervisors have been there, and there have been no safety concerns that have been outlined by either of them. Obviously, if the court is inclined to have him provide, you know, it could be that I know that one of the things that we talked about at the family law brown bag was the sober link. Maybe this is a case where prior to his visit, he submits to that, and to determine whether or not he has consumed prior to the visit. Maybe you do it before the visit and after the visit, so that he can have that unsupervised visit and not having to rely upon third parties, because that does take a lot of time for third parties. And again, there hasn't been a showing that there is a safety risk for this child. Ultimately, my client has asked that you consider unsupervised visits, and he's proposing for the next 4 weeks that he have on his second and third days off from work, that he have from noon to 6 p.m. And then 4 weeks after that so 4 weeks of the 6-hour visits twice a week or on his days off. And then the next 4 weeks, do an overnight visit from his second day off at 12 noon to his third day off at 6 p.m. And again, that would give Ms. Kale another opportunity to, you know, unannounced observe those if she so chooses and the like. But again, it's going to allow the child to recognize that dad does have a home, that dad does have a place where she can acclimate to, so that they're not always being in public. Because again, there's a comfort to having a home, having that security of a home cooked meal, having that security of, well, this is my room and I can roam and play and do these things within my household. I would also remind the court that my client continues to live with his parents. And so his parents are also adults that are available immediately within the household during those times as well.
I would note that the 4 weeks of day visits and then the 4 weeks of overnight visits, about 6 weeks into that schedule, we would be back here on that October 24th date for the visitation review. And so we would ask that the court consider providing for that. In regards, although counsel didn't argue this, it was certainly in her client's declaration in regards to financials. My client has been struggling financially with all of his requirements. He has paid the $2,000 family support for August. That was taken care of last week. He has not been able to pay the $2,500 attorney fee or the $475 UA hair follicle tests that were ordered on reimbursement at the very start of this case. Those accrue 12% interest. He would have had the benefit of no interest had he been able to pay those within 90 days. The hope and expectation is with the court's more recent temporary ruling of reducing his his family support to $1,500 per month, that may allow him some additional funds to be able to float towards those. But keep in mind that he is living on a shoestring. He's having a hard time keeping fuel in his vehicle, which is necessary for him to get back and forth to Kalama for employment, to provide transportation for himself to and from supervised visitation locations and the like. And as far as paying for the ongoing weekly UAs, which are very expensive. I mean, overall, those are a significant amount each week out of his pay. In addition, there's no information that suggests that Ms. Wishart isn't able to be employed, even part-time, as well as she has indicated that she's applied for school, but we've received no information as it relates to her financial aid package that she may have received and any additional funds that she may have received to supplement her and her child's living expenses through financial aid. So none of that's been forthcoming, and I would question whether or not those are financial resources available to her. So we would ask that the court deny any further financial relief. Mr. Wishart is certainly strapped. He needs to continue clearly to focus on his sobriety and moving forward. I'm certainly happy to work on trying to obtain copies of UAs from Kaiser. I had simply focused on the ones that had been required through the court order that he's been taking weekly, that I can't even remember the agency, not performance. That Lower Columbia Occupational Health has been forwarding to me by email. So those are the ones that we've been filing. And I guess I would apologize to Mr. Wishart in the court if I failed in following up on those. I was just, I guess, tunnel vision on the ones that the court had ordered.
All right. Thank you, Ms. McLean. Anything else, Ms. Baldwin?
Thank you. Ms. McLean tries to have it both ways. She says, gee, my client has to work all the time, so he can't go to treatment. And then she, out of the same side of her mouth, says, gee, he doesn't have any money. But if he's working the same hours and his excuse for not going to treatment is he's working, he does have the money to pay. And concerningly, we have dates where there isn't an explanation. He's not working and he's also not going to treatment. So again, we have these concerns. We have Mr. Wishart openly admitting he's had alcohol within the last 2 weeks. And the concern here is I don't see that on the UA. So again, that sort of raises a concern because weekends are usually, or weddings are usually on a weekend, and we don't see that pop up. And so again, that sort of leads to some integrity concerns. I appreciate counsel sort of trying to take the blame for not having the Kaiser UAs, but the reality is that those are completely within Mr. Wishart's control. Either he's just not doing them, and so the results don't exist, or he has done them and they're bad. And so, because I doubt if they were good, he'd be hiding or not providing them here. It's notable that there's no evidence he's asked for FMLA leave from his employer. And again, that notes again back to that Awakenings SUD evaluation that says he's ambivalent to change. And again, these UAs are so expensive, but there's no indication that the ones from Kaiser are expensive at all. And if he had free or very low cost random UAs, we're not saying he has to do multiple ones. No one has ordered that. It's only that he has to complete UAs. So I don't think anybody would have said, oh, gee, if you did one for Kaiser, it's no good. So again, concerns there was sort of, but the ones that are at occupational wellness, he can control, and he can control the timing. So again, that goes into an integrity question. As far as safety risks, somebody being inebriated during a visit is an obvious safety risk. The reality is the supervisors provide a protective environment for the child. We have to remember that within the summer, Mr. Wisher no called, no showed, and no valid explanation, in my opinion, a visit. So that's certainly an impression that it would or could impact visits with child. And it's a very bizarre position to take where Mr. Wishart says, yeah, I violated your order, Judge, give me more time. That's a bizarre position to take. Mr. Wishart has relapsed. He has not followed the evaluations that we had as of June from Awakenings. We don't see him complying in treatment. We don't see him going to all of the other AA or NA groups that are available in town. So the same, well, gee, I couldn't go to Monday, Tuesday. Guess what? I'm pretty sure in town there's a group of 7 days a week, multiple times a day for these types of issues that he could have attended. And while maybe that might not have been perfect compliance, it's certainly better than doing nothing at all. So again, Mr. Wishart is just ambivalent to his treatment. We want him to take his sobriety seriously. But the child doesn't suffer in the midst of that. My client is saying maintain this order for the next 6 weeks, which is certainly not forever. And let's see where Mr. Wishart's sobriety is then. But that is a reasonable outcome for the child, is to maintain a system that's working, that's safe for the child, that Mr. Wishart himself can't really complain about. He just doesn't like it, but he has no actual complaint about the current visitation system. And for that reason, along with all of the others, we should maintain the current order. It is in the best interest of the child.
All right, thank you.
We're going to hear from Ms. Kale.
Ms. Kale, did you have something that you wanted to comment on?
Yes, just in my observations of Addison and Mr. Wishart together, as well as all the notes coming in from the visitation supervisors, her relationship to Mr. Wishart is very strong, and she repeatedly asks for more time with her dad. She has a very hard time leaving him. She has been in some counseling and has expressed missing her dad while in counseling. There is no question that there's an issue with substance abuse here. I am not in favor of Mr. Wishart having any kind of overnight visit without a sustained period of sobriety. But as Ms. McLean pointed out, Mr. Wishart does in fact live with his parents. And so I'm wondering if there's a way in which we can offer visitation that takes place at Grandma and Grandpa's house with dad, that doesn't require necessarily a supervised visit, but does offer a safe place. We don't have any evidence that Mr. Wishart is inebriated during his supervised visits. And that's not to, I don't say that to try to take from the fact that there's a substance abuse issue here. I fully acknowledge that. But in looking at best case situations for Addison herself and her needs and her desires and her wishes, I'm wondering if there's a situation that we can create for Addison that would allow her to be at Grandma and Grandpa's house. Also, she states missing her grandparents on Mr. Wishart's side of the family, where she can have visitation with Mr. Wishart in Grandma and Grandpa's house, where she has access to all of those things that Ms. McLean pointed out, the room that they've set up for her, the toys she has there, and to have an experience with her dad that is more comfortable and in a less formal setting. But those are my thoughts at this time.
Thank you very much. I appreciate that. Actually, I was considering going there. So I appreciate that was brought up. I know that there initially were some accusations of these family members, drawing a line in the sand between these two young folks. And to some extent, I suppose that's reasonable. But to assume that the parties would not have the best interests of this little child in mind is unreasonable. If that hopefully that came out correct. I would assume that the paternal grandparents would supervise sufficiently visitation. There's been no contact with them that I'm aware of since this started. And I know there was some concerns about, I don't think any of the parents were suggested initially as being the supervisors, I guess, in this case. Here's what I'm gonna do. We're currently 4 hours a week, 2 different visits. Okay. I'm going to keep 1 2-hour visit supervised by Miss Wishard's family a week. And I'm going to allow 1 4-hour visit essentially supervised by Mr. Wishard's parents. So that would allow a visitation in the home. She can see her grandparents, see a room, play with toys, not be in a park. I would require paternal grandparents to do a brief report, just like every other supervisor has been required to do.
I'll have them sign the supervision the supervisor oath. Yeah, perfect.
And obviously that we don't need paragraphs, but a summary of how the visit went, things go on. If Miss Kale's able to check in on one of those visits, that would be great. And so he's only getting 2 extra hours a week, but 4 of those hours are now supervised by his parents, so that can be in the home.
So is there any way that we can schedule like a consistent 2-hour visit and a consistent 4-hour visit that align with his work schedule? Because having to negotiate these has really been difficult, and most parents have on his second day off, he's going to have from 4 p.m. to 6 p.m. And on his third day off, he's going to have from, 4 p.m. to 8 p.m. or whatever. I'd like to have some consistency because eventually we're going to get there, but that way everybody knows what to expect when, and to have somebody prepared for that.
And so the reverse of that is, it is not reasonable that everything is dictated by Mr. Wishard's schedule. Again, we're in this position due to Mr. Wishard's choices. And my client, there is not, it's very clear that my client and her supervisors have been very consistent, that they've provided visits. Again, there's really no complaints within the materials that like somebody didn't schedule a visit. And so to say, oh, this has been a problem, nothing indicates that. So it isn't reasonable to say Mr. Wishard can dictate how this happens. The parties should continue to have to negotiate as they have done, and as they've done successfully for the last couple, since the court's last order. So it isn't reasonable to say, again, that Mr. Wishard gets to dictate this, and that my client and her supervisors have to then bend to his desires. I think this is a collaborative process. And both parties need to have input, not just Mr. Wishard and his schedule. My client and her supervisors have schedules too.
Yeah, but the child thrives.
Okay, here we are. I know the child's not in school, and I know there's issues. I'm not gonna, it's almost 5 o'clock. I'm not gonna sit here and try to go through the schedule that to me looks like Morse code and figure out what works for all the parties. I do think that is appropriate to try to get some kind of a regular schedule set up that works for everyone, not just one side. And I guess, Ms. Kale, I'm gonna task you with seeing if you can either determine a days of the week or a cycle that may work around Miss Wishart and Mr. Wishard's calendars and the family activities that are kind of reoccurring. But at this point, I think until we come back on the 24th, we're going to status quo as far as scheduling those. But I am expanding the visit, and so instead of just 4 hours a week, we're up to 6 hours, and 4 of those hours can be supervised by Mr. Wishart's family. Obviously, he needs to work out the time of that with Miss Wishart.
Are we continuing the weekly UAs?
Yes, I mean, I think it's appropriate, and I think I'm not going to suggest that anybody is being nefarious. I understand the concerns of Ms. Baldwin because, I mean, as she stated, we're kind of here where we are for a reason. So if I guess I would want an update from Kaiser. How many UAs is he taking at Kaiser?
Sure.
Is it once a week? Is it twice
Sure.
a week? Are they random? Are they?
I'll follow up on that.
And then I'd want
Your
all
Honor.
that information, and I'd want Ms. Kale to have that information as well.
Okay.
And I will state that I am happy about the hair follicle in generally speaking. I do. I am glad that it doesn't show illicit drugs in his system. And my hope is that, I think alcohol is a difficult drug to deal with, and because it's frankly just prevalent and so easily available, and there could be ongoing struggles with that, but I think given the history, we need to just be as prudent and thorough as we can be. Ms. Kale, I'm sorry I interrupted you.
No, Your Honor, I think I actually interrupted you, but thank you. Yeah, I was just going to request from Ms. McLean, and I can reach out to Mr. Wishart about being included in those to find out about the Kaiser UAs, because I'm also very curious. I was also, I know this is a touchy subject to bring up here at this point, but I've almost exhausted the hours that have been allotted to me for this case. And so I know that it's getting tight for both parties. And so I just want to cautiously request maybe 3 more hours to work on this visitation and wrap up the report.
Any objection?
So my only issue is the additional work is basically solely based on Mr. Wishart's choices. And so my client is sort of financially along for the ride when she has substantially less income. So I'm fine with the extra time, but I do think it should be at Mr. Wishart's time.
Well, again, he's been providing substantial income to her, paying substantial expenses for her, as well as having his own expenses dealing with his substance abuse issue. So I think that they are both in the same situation, and I would ask that the court order the continued percentage split.
Anybody know what that percentage is off the top of their head?
60-40, Your Honor.
I think 60-40 was the last JL order.
All right. Here's what I'm going to do. I'm going to authorize your additional 3 hours. I think that's important. And if you could just submit your bill, and then we're going to review that on the 24th of October?
Yes.
And I will determine on the 24th, essentially allocate that those additional 3 hours
Okay.
on that date and time.
You want a presentation from today's hearing?
So Ms. McLean, when are you out? You're out the first week of October?
Yeah.
Okay.
And
I don't have any. I could do the 29th, the Friday presentation. Does that work for the court and Ms. McLean?
I believe I'm out of the office on the 29th.
Okay, because the 22nd is conference week, correct? Okay.
Yes, but Thursday and Friday that week, I think, are regular schedule.
Oh.
Miss Wade, let me bother you. Sorry, it's been a long afternoon and I appreciate you. I think Friday the 22nd, we could do a presentation, couldn't we?
As far as I know, the Thursday and Friday dockets are still open.
Okay,
So we
that's
could do
my
Friday the
preference, just because
22nd?
then,
That's
because then
fine.
otherwise we're gonna go way out.
The 22nd.
So the 22nd at, so that's next Friday, the 22nd at 8:45.
Okay, and who's tasked with preparing?
So I would ask that Ms. McLean be tasked with preparing. Again, so there's a substantial disparity in income, even with transfer payment. And then I would like the court to address fees. Again, we've had multiple hearings now that weren't contemplated initially in any sort of award of support or fees. And again, there are choices that were made, and certainly not on my client's behalf or not on her part.
Well, and I guess the only issue that I would
I already
think-
have Ms. McLean will prepare, and I'm not imposing any fees at this point. Those can be reserved if you want to raise them at trial. Great, but I'm at this point, I'm not imposing any fees.
Okay, thank you. All
All
right,
right.
thank you very much, Your Honor.
Thank you all. We can
So
go
wait,
on.
before, I just want to clarify, because the GAL asked for the Kaiser UAs, that those will be included, that sort of the results, either they happened or didn't happen, or what the results were, would be included in her report.
Yes.
I asked that those be provided, so.
Yeah, I'll work on getting them.
All right,
Thank you.
thank you all. Good luck.
Your Honor.
Good morning. I apologize for my voice. I do have a order presented by Ms. McLean. And just so everybody knows what I'm looking at, it's the one that Ms. McLean dated 9/18/23. And I did not see, when I looked yesterday, any written objections.
Oh, we did file them on the 19th, so they should be there.
They're
That's
there
fine.
now. They weren't there
Oh.
yesterday.
Okay.
I see it. So item 5, lines 23 through 24.
And there's only a few, so I can just run through them really quickly.
So reserved, is that
Yep.
the first one?
Yep. So at section 5, the way it's written implies that you specifically and intentionally denied fees for the hearing. And my understanding is what you did was reserved fees for the hearings that had happened, and said, that's reserved for trial. This specifically would say no and preclude a judge at trial from awarding fees. And so I think more accurately reflective of what you ordered is just simply fees are reserved for trial. On item 6, line just below that.
I have no objection to changing the word review to report.
Okay, great. That was, I think, what it should have been, likely. And then the last one is just reflecting that the guardian ad litem's report will consider those additional UAs from Kaiser.
So if the court takes a look at, if you're on page 2, paragraph B1B, it has him providing the ongoing UAs and following up with providing the Kaiser documentation for the treatment as well as UAs. And so obviously we've been providing those to everybody. And my concern with counsel's language is that she's asking that the guardian ad litem consider Kaiser. My problem is the words lack thereof. We have absolutely no control over how often Kaiser decides that they're going to randomly UA Mr. Wishard. And I don't want that to reflect negatively on him if they're making a decision that they don't want to randomly UA him, or how often they decide to do that.
And so the counter to that is, if they are ordering random UAs, which is what's indicated in the medical records that they provided, and Mr. Wishard isn't doing them and only doing the pre-scheduled, pre-planned ones that he can control, that should be considered. And we specifically addressed that the essentially the very last thing that we talked about in our hearing on this. I said, and we should the guardian ad litem report will consider these. And the court said yes. And so similarly, the lack of evidence is also evidence. And so it's appropriate that it would be considered if he's being ordered to do random UAs and is refusing or declining.
So I guess I've never, unless there's a non-compliance report, I've not had an individual be allowed to continue with treatment if they're not complying with UAs. So I don't know if council's seen something that I've not seen in the years of my practice, but I've never seen a treatment continue with ongoing treatment with somebody if they're not compliant with UA requests. So, and the language I think could be interpreted the way that I have interpreted it is that the suggestion that Kaiser isn't randomly testing enough to Ms. Baldwin's client's content. And that's not what the court ordered. And I think obviously that the results are what the results are.
I'm not concerned about it being insufficient. Kaiser's going to do what they're going to do. It's whatever Kaiser's doing. If Mr. Wishart is non-compliant with Kaiser, that should be a consideration.
All right, so here's what I've done on 5. The second sentence I just changed slightly. The court awards no fees, but reserves the issues of fees for trial. So I made that change. On 6A, I changed final review to final report. And then at the end of 6A on the top of page 2, I just included the GAL shall consider the drug testing performed as part of treatment with Kaiser Permanente.
Very good.
Thank you.
And approved via Zoom is okay, Ms. Baldwin, on your signature line?
That's just fine.
All right. All right. I will get this entered as soon as I'm done this morning. Thank you.
All right, Wishart and Wishart, 2330017408. We're on for GAL review and child support.
Yes.
And I just received a big stack of stuff during the docket here that very well could have been emailed to me, but none of it looks familiar. I'm just going to be honest with you here. So
here's my proposal on this. So the presentation is pretty straightforward. Objections have been filed, orders were filed a long time ago. Guardian ad litem filed her report, I believe October 12th or 13th. I was out during that period. I didn't see it till I got back in the office on the 18th. So I've only had it in my hands less than a week. As far as the guardian ad litem review, to me, yes, she's filed her report and I appreciate that. Mr. then filed a declaration yesterday. So what I'd ask that we do today is just do the presentation, but not, if the court's going to make any kind of changes to the parenting plan, that we set that over. My client should have an opportunity to respond. I should have an opportunity to chat with her and have more than essentially less than a week to review the guardian ad litem's report.
Thank you, Ms. Baldwin. I will tell you that the declaration affidavit that I do see was filed yesterday was not in Odyssey yesterday. It is in Odyssey today. I have been in court all day, have not been able to review. Looks like it's 8 pages, but I think that's including
The visitation notes.
yes, and just some Dropbox information, so that it may be less than that. I have not reviewed that. It popped up on in Odyssey this afternoon when I was able to look up this case. So I have not seen that, have not been able to review that. Ms. McLean, where are you as far as the GAL report?
Well, it's I received it the day that Ms. Kale filed it. I forwarded that to my client, and with his work schedule, he got back to me mid last week. And with my schedule, I wasn't able to turn his information around until I think it was Friday. But he wasn't able to sign his declaration until over the weekend. And then I have filed with the court the documentation that we finally received from the Cowlitz Indian tribe that has the 3 UAs that they have performed. They're on a color system. So my client has to call in every day. And then if his color is called, then he goes in for a random UA. So we've provided all 3 of those results, which were negative. We've also provided their assessment as far as what they're recommending for treatment and following through with. which is once a week for, I think, the next 3 months. And for him to continue with the AANA, which we've also filed with the court. And then this last week, Ms. Wishard asked my client to participate in a hair follicle test. Counsel's assistant forwarded me those results yesterday, so I went ahead and filed them since apparently they weren't going to do that. And clearly those showed a negative as well. So just like you had indicated in the prior case, you know, my client's been doing supervised visitation for the last 6 months. He has had, at least since he started treatment, at the time of his initial treatment, he had a positive UA for alcohol. We also had that hair follicle for the cocaine use in the early part of April, the last part of March. There's been no other substances other than you had the one UA for alcohol the end of the end of August, I think it was, when he had the 2 shots of alcohol during his sister's wedding. So again, I mean, he's done what he's doing what he's supposed to be doing. There has been nothing negative as it relates to any of the visitation notes, the supervised or the lay visitation. None of the visitation supervisors have had to intercede or step in to stop a visitation. None of the supervisors have suggested that Mr. Wishard was intoxicated or affected by any substances during his visitations with the child. So at this point, our position is that we need to progress forward. And I can appreciate counsel indicating that they want an opportunity to respond, but even Ms. Kale gives a path moving forward as far as unsupervised visitation. He is in treatment. He is doing the random UAs. He is looking into, albeit Ms. Lovely's report and recommendation, the court had not ordered my client to participate in services. We've had that report, I think, if I recall correctly, since the middle of June. And it was determined that he was not the aggressor in the, according to Ms. Lovely. So you haven't ordered treatment at this juncture. And your at least prior pronouncements were that you felt that his issues were the substance abuse, and that is also what came out in Ms. Lovely's report and recommendation, and that you wanted to see him progress there. I think he has progressed there. The visitation notes and Ms. Kale's report also indicate that Ms. Wishard is now having to bribe the child with candy at the end of visitations with my client so that she isn't crying because she doesn't want to leave the visits. It's emotionally difficult for the child to have these short visits and not to be able to spend more time with her dad and to spend time, you know, overnight in her room and things like that. So ultimately, we are asking that the court advance this forward to unsupervised visitation so that my client can have a normalized relationship with his child. And ultimately, we are asking for overnight visitation. He works a 4-on, 4-off visitation schedule. I don't know how long counsel's looking at having this matter set out. To be quite honest, I haven't looked at what the availability of court hearings are over the next couple of weeks. Oh, it looks like the next couple of weeks are open. So, but in any event, I mean, as you indicated in the case right prior to this, is you wanted to make sure that people were making changes. And I think you have evidence to suggest not only that my client has made changes, but that the limited visitation schedule has been difficult and emotionally difficult for this child, given her relationship with her father.
Ms. Baldwin, anything in response?
So it's up to your honor as far as I can just respond to the issue of whether or not we should deal with this issue today. Counsel sort of launched into her entire argument. But the reality is this is not an emergency. This is not a case where there's some impending doom if we don't make a decision today. And in fact, the guardian ad litem's recommendation is that he not have unsupervised time right now, and that he not have it for 2 to 3 months. So the idea that we would force a decision today when you don't have the information that you could have before you, instead of put it out 1 to 2 weeks, that doesn't make a lot of sense. It doesn't make, court it always wants to make the decisions that the best decision it can, the decision that's in the best interest of the child. There just isn't a reason to rush it today. And so again, I think we should set it out 1 to 2 weeks. Those dockets are open. I think that's an easy call. So I'd ask the court to just set this issue over, again, 1 to 2 weeks. If the court's not going to do that, just let me know, and then I can launch into a substantive argument.
So I don't have any closed dockets upcoming. I do have availability the 31st. I have availability I think it's the 7th. And I would agree with Ms. Baldwin. This is not a case where there's not visitation happening, that there's not communication, there's not, contact is still happening on a regular basis between these parties. I did review the GAL report. I do think it's appropriate for everybody to have sufficient time. And I, again, have not read the declaration that was filed by Mr. yesterday. So if Ms. McLean wants me to consider anything in that, I would need to set it over.
Okay.
So, but I can do it just 1 week if that works for all the parties. I agree. I don't want to delay this, but I also agree that we are in a situation where the parties, there is visitation happening, so it's not, but I mean, we can set it to 1 week. We could set it to 2 weeks. Both of those are open at this time.
I'm fine with either.
I think my client would prefer to have it heard sooner rather than later.
Oh, go ahead.
I just want to confirm, Ms. Wade, I know we've set a couple over from today. Are we still good for next Tuesday, correct?
Yes.
We are, yes, we're at 17 and 20.
Okay. So 1 week, we can set the GAL review 1 week, and then I'll have an opportunity to review Mr. Wishard's declaration. I'm sure it sounds like he would prefer that I be able to review that. As to okay, I have two. Let me
So the only thing that you should have from me should be a child support worksheet with a cover sheet with my footer on it. And then I also filed objections that included those worksheets back on October 10.
Yes, I have that. And then I have from Ms. Baldwin, the child support order, as well as one child support worksheet. And I do see the objections and have those in front of me that were filed on the 10th. And I guess, Ms. Baldwin, was anything changed from your proposed orders based on those objections?
No, what I can do though is I can go through them pretty straightforwardly. So the first objection is the request to add Washington paid family leave. I did note that I left those $63 out. I can add that back in. The balance of the objections are tax strategy and payment strategy. So when the court set the incomes, the court didn't say, and put him at, a single payer for taxes, put him at head of household, put him at married. And when the court doesn't do that, and the court doesn't commonly, to be honest, do that, then I think what you see is some gamesmanship on how the taxes are run. And how the taxes are run impacts sort of the bottom line of how much income a person has for their child support worksheet. I ran, my client's income is all imputed. I ran her at single. I believe I ran Mr. at single or something close to single. And so that's how I ran my numbers. Ms. McLean ran her numbers at her client single, sort of trying to maximize his taxes to drive down his income, and running my client at head of household, inflating her income, which again is all imputed. It's not real income that she actually has. So when you look at it that way, that's really the balance of, those are the substantive objections. The practical effect of all of that is that Ms. McLean's bottom line is about $200 different than my bottom line as far as what the actual transfer payment is. So I have a transfer payment of $1,244. Ms. McLean has a transfer payment of $1,041. So again, almost exactly a $200 difference between these two parties. So the court just
could I interrupt for a moment, because that's different than the calculations that I have under your proposed orders.
when I looked at the proposed orders,
Your calculations show 1,088,
hold on.
and that's what your child support order shows.
Yeah, on lines, or excuse me, I guess part 17 of page 3. I have $1,088.74.
Okay, let me just confirm.
I just wanted to make sure I've got the same thing.
Yeah, sorry, I must have updated it at some point. I might be looking at an older one that we had filed. That was an older proposed one. So again, if it's 188, the numbers between the two are we're only $40 different, which is a very modest difference. The other objections that are raised in the Ms. McLean's objection, to be done in equal installments consistent with this pay period, that's fine. I usually write it to be done on specific dates, but essentially we all bow to the Division of Child Support and how they take it. So you can write that in. I have no objection either way. The reality is it's going to be done per how the Division of Child Support takes it from his wages. On paragraph 17 on when child support will terminate, council has selected essentially the final language, and I've selected the temporary language. The current supports to be paid is because this is a temporary order until another order is entered. That is what the correct selection is. Council's proposed language is really for a final order. As far as the health insurance language, I believe I've selected the correct health insurance language. I believe it's more correct than what council's proposed. I think that's a distinction without a difference, to be honest.
So just briefly in regards to the child support calculations, to be quite honest, I'm not certain how council ran taxes for purposes of her calculations. She suggests that if you look at her line 2A in the calculations, she suggests that she ran her client as single with 0 child credits. She doesn't indicate how she ran my client. I ran my client as single and not claiming the child. I ran Ms. Wishard as head of household and not claiming the child because the court hasn't made those determinations. But clearly she's head of household. She's going to qualify as head of household. So that's where I arrived at the tax withholding from my client of $1,662.76 and her withholding of $99.28. It is accurate that my client does pay Washington Family Leave. His employer has enough employees that he doesn't have to pay for the long-term health care, from what I understand. So I have not included that. So that's the difference in the calculations. I agree that the bottom line is about $45 difference, which is a class and part of a potential UA for my client, which is significant considering he has ongoing at least $150 per month for the substance abuse classes, and he will have probably another $150 per month if you end up ordering him to do counseling recommended by Olivia Lovely. In regards to the child support order, the primary difference between our proposed language is the fact that I'm using the July 2022 updated forms. Council's order is still under the old 2021 forms. And so the Pattern Forms Committee updated language after input from all of the involved participants, particularly Washington State Support Registry, to make sure that they're able to enforce certain provisions. So my proposed changes to her order are at paragraph 5 to change their respective incomes. My proposal was that his income be changed to my calculation, which is the $73.50 hers changed to $24.1834. Paragraph 8 to change Ms. Wishard's basic child support obligation to $391.06 and my client's basic obligation to the 1,040.94. At paragraph 11, it appears it's agreed as far as the equal installments consistent with my client's pay period. At paragraph 17, the new language under 22 provides for there is no more temporary language option in the child support order. It's simply the paid by until the child turns 18. And my assumption, I can make some assumptions about that. I think that there were too many orders where that wasn't getting changed on final orders, and WSSR was having to go back and have people change that because it still had temporary language in it. So the pattern committee did away with that language. As it relates to paragraph 20, again, the pattern language that was adopted by WSR, and technically Ms. Baldwin's order has the first two sentences, or actually the first, so the bolded language, and then she has the one that starts Jonathan Wishard, and the court has considered. What needs to be added is the parents must enroll the child in accessible health insurance coverage through their employer or union up to 25% of their basic support obligation. DCS or any parent may enforce this requirement. And again, that's language that was promulgated at the, I believe, at the request of WSSR, because all parents are obligated to provide health insurance unless it's specifically waived by the court. And the court hasn't waived that requirement for Ms. Wishart at this juncture.
Thank you. Anything further, Ms. Baldwin?
If that explanation had been provided a little more succinctly in the objection, I would have just snagged a new form. I didn't realize that I was using one that was a couple months out of date. So that's fine. We can make those changes. The court can pen and ink it. I think that they are largely distinctions without differences, other than the court choosing between the $40 or so on the transfer payment.
So as for the paragraph 11, 17, and 20, I think I would agree with Ms. McLean, and it sounds like Ms. Baldwin doesn't have significant concern with 11, 17, and 20. If we're on for next week, can those changes be made in a new order so this one isn't totally gummed up on the new form? Is that?
Yes, that's fine.
Okay. And then as far as paragraph 5 and paragraph 8, I guess with the addition of the 6341, which again, in the worksheet, Ms. Baldwin agrees was left out and would be added in. I don't know how much impact that would have on the total numbers. If we would then, both parties would land at the numbers that Ms. McLean is proposing in the child support order, or if we'd still be a few dollars apart. But frankly, I have to say this is probably one of the closest numbers that I've come across. It's usually there's much larger disparities. So just want to acknowledge that because we don't see that all the time. Hold on one second. So I've reviewed the worksheets that were provided by Ms. McLean and the worksheets provided by Ms. Baldwin. And we, as I stated, we're very, very close. I don't, given the 6341, I'm going to assume that, I'm not going to assume. I'm going to ask that the changes in paragraph 5 and 8 be reflected to show Ms. McLean's numbers there. I think it's nominal difference, but if we could have a new order for next week, I will sign off on that. And as we stated, it's, I think in one area, it's $18, in another area, it's around 40. So
is the court just going to sign off on my worksheets then?
I can sign off on the worksheet, and if we want to have a new order Tuesday,
sure.
then I can
The only thing that I would note is that it appears that, and just saw this when I was flipping through them, it appears that I forgot to remove language from our original proposed worksheets at paragraph 26 as far as residential credit. Would you mind just striking the language in paragraph or in box 26 on page 4?
In its entirety?
Sure.
It should be.
Okay, I'll just line through. And initialed.
Yeah, that's great. Thank you.
And assuming that next week works, unless there's an agreed order, if it doesn't get done by then, hopefully we can have an agreed order at some time in the near future. Yep. Okay, thank you very much. We'll see you next week.
Thanks.
And I also received from Ms. McLean and Ms. Baldwin an agreement to set over the Wishard matter, which is 23-30017-408. Is that also just 1 week?
Yes, Your Honor.
All right. And I don't see, is this Ms. McLean here? She was on the email. I don't doubt it.
I don't imagine.
Okay.
Sorry,
So
Judge.
Wishard and Wishard will set over 1 week to the 7th of November at 1 p.m. as well. All right, Wishard and Wishard 23-30017-408. My apologies, Ms. McLean.
That's okay. Thank you very much. It's the mom doctor appointment day.
Yes, and I understand that, and we'll do our best here.
Thank you. I appreciate it.
We are on.
I did sign the child support order and sent that over to Ms. Baldwin. I don't know if that's been sent up to the court for signature now.
We got it. I believe I signed off, but it might just be routing its way.
I have a temporary child support order that doesn't have your signature on it yet, but it sounds like if there's
So
one coming.
There is, yes. So I would just junk that one just in an abundance of caution. The one that's signed by both of us is on its way.
Perfect.
Okay. Thank you.
So, the other thing that we were reviewing today is the GAL report.
Yes.
Correct.
Did
All right.
the court have an opportunity to review through, technically, I guess, both of our clients' declarations?
I believe so. Let me, I have a declaration from it was filed on the 26th of October, from the respondent, and
my clients should have been filed on October 23rd.
sorry, yes, the declaration regarding final GAL review, October 23rd. Yes, I've reviewed those.
Okay, great. Who do you want to hear from first?
I have no preference. Either one. Go ahead, Ms. McLean, since you asked.
Okay. So as you can see from my client's declaration, he did have some feedback and input as to some of the factual information that has been presented by Ms. Wishard that was provided in the guardian ad litem's report and recommendation and relied upon to some extent. I would simply note that obviously I think this case was filed in April or so of this year, starting with the fact that my client had not been allowed contact with Addison for some time. We're now 6 months removed, and my client has been under supervised visitation. He has, at least during those supervised visitations, all of the comments have been positive and glowing about his relationship and involvement with Addison. None of the visitations have had to be terminated by a supervisor. None of the supervisors have had to intervene for Mr. Wishard being inappropriate in any way. And in addition, none of the supervised visitations, none of the supervisors have suggested that Mr. Wishard has been under the influence. As you know, we've been providing ongoing documentation from treatment providers. And while I understand Ms. Wishard has a concern about the continuity of care, obviously, in order to have sufficient care, you need to be able to make full meeting times. And while Mr. Wishart was attending meeting times that somewhat conflicted with his work schedule, he was still there for an hour of an hour and a half meeting on those times when they did interfere with his work schedule. And he made an effort to secure an additional provider to follow through with the treatment recommendations and ensure that he was able to and continues to be able to attend meetings that are managed around his work schedule. We did provide with the court, and I will tell you, to no fault of my client, the tribe has been somewhat challenging as far as getting documentation from, despite repeated requests. I don't know if this is something that maybe they're just not normally used to doing, or if they do them on a less consistent basis. But we did file on October 20th. I had finally received the correspondence from them, as well as proof of the UAs that had been submitted. My client, as I indicated last time we were here, since he's been with the tribe, he's now on the color system. And so they randomly call him, and he's been participating in 2 UAs per week on a random basis. All of those have been negative. It's my understanding that the counselor is going to be providing us updated UAs from this last submission to date. And the hope is that they'll continue to provide those to me so that I can get them filed with the court on a permanent basis or consistent basis. But at this point, he has been progressing well in treatment. And as you had indicated, I think it was during our meeting was the last part of August or maybe first part of September, where he had the one, I guess what I would call a relapse with him having the shot or 2 of alcohol during his sister's wedding. You had commented at that time, obviously, that relapses are part and parcel and that alcohol is prevalent. And he provided that information to the court. I would also note that he, again, is under continuing UAs, which have been negative. And even from the guardian ad litem's report and recommendation, Addison is struggling. She wants to have more time with her father. She wants to be able to stay in her room. She wants to be able to do more things. You saw from my client's declaration that the end of the visits are a struggle because Addison wants to stay, and mom's now apparently been having to bribe her with candy in order to get her to come without being fussy. Mr. Wishart is supportive of Addison and encouraging her to go home, and that reassuring her that he's going to see her. But obviously, she's wanting some more time with her father because of that strong connection that they've had. He is in treatment. We've provided proof of his NA and AA attendance as well. And we believe that it is appropriate to move this forward. We are asking ultimately that the court provide for unsupervised visitation and transition into overnight visitation that's consistent with his work schedule. He does work a 4-on, 4-off work schedule. Obviously, Addison's not currently in school, and so there isn't anything that would necessarily interfere with her ability of having or exercising visitation during the week overnight, consistent with my client's time off from work. And keep in mind, even when you lift the supervised visitation requirement, my client's living with his folks. He lives with his parents. And his sister and brother-in-law, they all live in the spacious family home. So it's not as if he is going to be isolated with Addison. And that's going to help support her bond that she has with her father. In regards to the guardian ad litem recommendation about this phase issue, I guess if we had somebody who was in the normal, what I consider normal individuals who have significant relapses, and I'm talking about when you have individuals who are on hard drugs and they relapse, that is extremely concerning and significant. You don't have that. You have not had him relapse on anything other than arguably the alcohol during the wedding. And we have provisions and parameters in place to provide for, right, currently you would terminate his visitation for the next week. We unfortunately had to do that once because we weren't able to get the sufficient records to provide to the court at that time from the provider. So what we're asking is that the court not take sort of this draconian, onerous, stepped up visitation plan when we already have a father who has been exercising, I think currently it's 6 hours of visitation, supervised visitation, when again, you have glowing reports from the professional supervisor, from Ms. Wishard's supervisors, and from my client's supervisors, and the child who, according to the guardian ad litem, who has a clearly bonded relationship with her father. In regards to services, obviously there's a cost for all of these things. And as it relates to the recommendation that he participate in the 6 months of treatment that was recommended from Ms. Lovely, and that's basically an informational class about domestic violence. First off, I would note again that Ms. Lovely did not find that there was a pattern of behavior exhibited by Mr. Wishard, and that if anything, he is reactive to what was engaging him, and that essentially was Ms. Wishard. Since we've been here, there has not been one incident or set of information that has suggested that he has been controlling, that he has been inappropriate as it relates to the child or during these visitation circumstances. And again, I think that given the costs and all that's involved with this, and the fact that he has not been determined to be domestically violent, that the court not order that. If you do order that, there are, again, my client's got costs affiliated with every time he does a UA, every time he does the treatment with the tribe. And then I think it's $150 a month if he's doing, I think it's 2 classes a month through Olivia's proposed informational class. So I guess our position is that he should not be required to do that. We do agree to the ongoing requirement for sobriety, and he'll continue to follow through with that. We are asking for some holiday visitation time. I mean, obviously the holidays are right around the corner. We've got Thanksgiving in 2 weeks. We've got Christmas in 6 weeks. And he would like to be able to spend some holiday time with his child. We have provided to the court a proposed plan for purposes of moving this forward, and we are asking the court to adopt that and to transition into those unsupervised visits now. So essentially on his 4 days off, we're asking that as they fall within the month, the 1st, 3rd, and 5th sets of 4 days off, from the 1st day off at 4 p.m. to the 3rd day off at 4 p.m. And on the 2nd and the 4th sets of 4 days off that he had from the 1st day off at 4 p.m. to the 2nd day off at 4 p.m. So that would provide him essentially 1 midweek overnight, and then 3 weekends that are consistent with his days off. If there is a 5th weekend, if there's not a 5th weekend, obviously it'd be essentially 2 weekends, but again, consistent with his days off from work. So that's our request to the court. And we think that it's appropriate in light of what's been happening with the case and Addison's relationship with his father.
Is that, I know that I read that somewhere. Is that, I don't see it in his declaration. Was that?
Don't see what?
The time frame that he's, or the essentially the parenting time that he's requesting laid out.
in
Was
his
that in his,
declaration.
was it in his declaration or was it somewhere else?
I'm pretty sure that we have, so if you look at the bottom of page 3, he says on the first, third, and fifth
Okay.
sets of my 4 days off each month.
Perfect.
From the first day. Okay.
That's all. I just, I
Okay.
knew that it was somewhere. I just couldn't find it. Thank you for
Okay.
pointing that out. All right.
That's fine.
Ms. Baldwin.
Thank you. So first of all, the court does have the guardian ad litem report. Guardian ad litem spent a lot of time in this case, and there's a lot of detail in her report. And I think that's important. This is not a case where the guardian ad litem sort of just glazed over a couple things, chatted with 2 people, and called it a day. There's a lot of witnesses, a lot of input, and a lot of recommendations that were part of that ultimate recommendation. But there are a lot of concerns. And I think when we look at counsel for Mr. Wishart sort of just glazes over, hey, the last 6 months have been great. No, they haven't. The last 6 months are Mr. denying he has ever used drugs and then getting caught using cocaine. Mr. saying he doesn't have an alcohol problem, but then going to a substance use evaluation with alcohol in his system. It's him within the very recent past failing his sobriety and drinking at a party surrounded by his family, who is supposedly his support system. So the last 6 months have not been, sort of all wonderful. I think that counsel tries to sort of paint this rosy primrose path that everything's fine. That's not how things have gone. And when you look at what's happened over the last 6 months, these have all been problems of Mr. Wishart's making. My client has done nothing wrong. She's, been, hey, this is what the court orders are, trying to be accommodating. But nonetheless, it's Mr. Wishart that has repeatedly sort of not been forthright, not been honest with this court, or the guardian ad litem gets caught, and then says, "Oh, oopsie, but you should just ignore that because I want what I want, and I should just have it." And that really goes into some of his ultimate behaviors. One of the first things we need to talk about is just, again, this denial that he has a problem with substances. It's very concerning that we have the 3rd evaluation, and we don't even have a full evaluation from the tribe. I'm fine that the tribe does an evaluation, but if the court recall, he did an initial private evaluation with collateral contacts, where that person said, "Oh, I have some concerns. If he's positive again or something happens, we need to come back." But he never goes back to that person. Then apparently we have a new one done with Kaiser, and I'm not even sure if collateral contact was given there. And then it's, well, I don't really like that result either, so let me go get one with the tribe that's completely blind to everything that's happened. We have no idea what he disclosed whatsoever. All he provides is sort of the face sheet for the evaluation saying, hey, 3 months, I'm done. I don't have any problems. We don't know if he disclosed the cocaine use, the long-term historical issues with substances, the other substances he's used, the positive tests, talked to the guardian ad litem, didn't talk to my client, none of that. So this, hey, all I got to do is check some boxes with the tribe for 3 months and I'm done. That doesn't match the behavior that we've lived in this case for the last 6 months and really longer than that, really since this case started. So in this case, what we really need to see is a actual evaluation with collateral contacts completed, and then to follow those recommendations. You can't have those evaluations be blind. And that's really what we have now, is Mr. Wishart's just shopping for an evaluation that works for him, and one where by the 3rd time he says, oh, well, now I can just ignore that collateral contact. That's not reasonable. It's not safe, and it's not going to get him the help he needs. He is not going to succeed in treatment unless he gets the treatment he needs. He's only going to get the treatment that he needs if he's honest with the providers. The second issue, guardian ad litem recommends domestic violence treatment, and that's appropriate. What we have here is a young child, a young girl, who should not be subjected to his behaviors. These are not just, hey, he's only going to have those behaviors against Ms. Wishart, against his wife. That's not true. When we look at even the statements that his family, just look at what his family told the guardian ad litem. They talked about him having a short fuse. They talked about at points they were afraid to leave him alone. They talked about how he was expressive, and he doesn't really hide his feelings much, and talked about him storming out when he was angry, like bowling over a gate. These are things his family said about him. That's domestic violence. It's, I'm angry And it doesn't matter how you feel. It only matters how I feel, and I'm going to react and react explosively. And I think it's very tragic that we have Mr. Wishart engaging in victim blaming. It's her fault I got angry. It's her fault I punched a hole in the wall, which he doesn't deny. It's her fault. I'm just reacting. No, that is not what Ms. Lovely's report says. Ms. Lovely's report basically says that he is immature in his ability to be able to manage his emotions and manage his behavior. And so it then spills out. So the reality is that you can get mad from your wife, from your child, from your sister, from your brother, but that's all domestic violence. And the reality is that Mr. Wishart is not in a place where he even acknowledges he has an issue. And that's, again, where the Guardian Ad litem talks about that entitlement piece of, hey, I allowed Kylie to do this. You know, I authorized her to be able to leave the house, kind of things. He doesn't even see that those comments are inappropriate. This is where domestic violence and treatment is appropriate with Ms. Lovely. 6 months of a program is not an informational program. That is you have some things that you need to work on and get well to be a better human and to be a good father to your child. When we talk about costs, it's important to recognize Mr. Wishart lives with his parents. He makes a very good income. He has no expenses. Now is frankly the best time for him to engage in these types of treatments because he has, again, low expenses, essentially no overhead. Every dollar he's bringing in is just cash in his pocket. That's not child support to my client. And my client's spousal support ends, I think, end of December. So he's not even going to be paying that. It's his only obligation is really child support. So now is frankly the time. When we look at that, I think it's important to think about my clients, all of my client supervisors have been very honest and forthright. His fears that they would sort of tank him never came to fruition. But what we do for a parenting plan for a very young child is not based on what that toddler says they like. It's based on our adult understanding of what that child needs and what's appropriate. And so in this case, child is getting to see father, consistently. We want to grow that as Guardian Ad litem recommends with a step plan, but that step plan rewards him meeting treatment goals and being able to move forward in a healthy way. These statements that my client has to bribe the child, the client is frustrated. And she's like, I literally brought the kid like a dumb sucker once because I got it at the coffee shop on the way. And suddenly that gets blown up into this huge thing of she's bribing the child, literally a single sucker over 6 months. And again, so there's that frustration of sort of Mr. tries to paint everything in the light most favorable to him. And my client's just trying to give the court sort of the real deal on here's what's happening. But she hasn't thrown him under the bus. She's acknowledged where he's done well, but also said, hey, he slipped up a whole bunch in the last 6 months. He really needs some help to be a better parent. When you look at that, Mr's still in treatment. He needs to remain in treatment. What we're asking the court to do is to adopt phases 1 and 2 of the Guardian Ad litem's recommendations for both treatment and for the schedule. I think you should be required to have an updated substance use evaluation with collateral contact with both my client, the Guardian Ad litem, and copies of all the positive drug and alcohol tests that have happened to date, along with the other evaluations that have happened to date. The court should order the domestic violence treatment. The court should not enter phase 3. That's really a trial decision. We don't know where we're going yet. And it's not reasonable to say that my client's schedule should completely bend to Mr's, that his is the only schedule that matters. And that, hey, because kid isn't in school, mom's schedule should just be thrown out the window. And we put child on one of those awful rotating sort of warehouser type schedules. That's not reasonable nor consistent for child either. So that ultimate schedule should wait. But that doesn't mean that Mr's not getting increases in time. Again, my client says, yeah, adopt phase 1 and phase 2 of Guardian Ad litem's recommendation. She's not really withholding anything there. She's just saying, yep, let's do it. That is healthy for the child, healthy for everyone. Mr's demands that we just go straight from now to unsupervised visits. Don't make me do treatment. Don't make me acknowledge things that I have to work on. Again, I think that's just a symptom of him being immature in his ability to understand where he's at and what he needs to do. Again, sort of a symptom of that entitlement that the Guardian Ad litem talks about. It doesn't make sense for the child. It certainly doesn't make sense in a case where we're not that far away from his positive cocaine test. We're not that far away at all from his alcohol that he had this fall after the court said you can't do that anymore. So we're really not that far into this case where Mister's been towing the line. He's really just been repeatedly saying, well, I'm going to keep dipping over onto the wrong side of the fence and just seeing what I can get away with. He really needs to put himself off the fence and fully in compliance and be there for a while before moving forward. And again, that's what Garden Lightem recommends. My client says we should adopt those recommendations. They make sense. But again, wait on phase 3. That's really a trial determination that we should see when we get there and what everybody's schedules look when we get there. That's reasonable. So that's what my client's asking for. I think that's reasonable and appropriate given the facts of the case.
Miss Kale's here. I don't know if there's anything you want to weigh in on before I loop back around, and I obviously would allow either counsel to ask questions if they have any. If you want to just stand on your report, that's fine. If you have any comments, by all means.
Well, first of all, I offer my apologies because at this very moment, of course, they're doing some kind of landscaping right outside my office window. So it's going to be loud. I apologize. I'm trying to use a headset to help. I think, Your Honor, as is true in a lot of things in life, the answer about this is somewhere in the middle. I think we have two parties who adore their child and are legitimately interested in doing the best thing for her. I believe entirely that Mr. Wishart is doing the things that he can do under the idea that I'm not convinced that he believes he has a problem that needs to be addressed. I believe that he's doing what he can do to receive the treatment that has been recommended to him. In this particular case, I found that the most important thing to do was to rely on the professional experts that have become involved, who were Olivia Lovely and now the tribal health treatment plan. I think that to ignore those recommendations may leave room for Mr. Wishart to fall back on habits that have not necessarily been healthy for him or for his family. My particular concern around Ms. Lovely's recommendation is that in my conversations with Ms. Wishart, she expressed very serious and very concerning experiences with Mr. Wishart in their relationship. And I share the concern that those things can impact a person as a parent, those kinds of behaviors, those kinds of reactions. It's important to me that as the person who got to engage with these people on all these levels, that those recommendations be taken as seriously as possible. I do not believe that Mr. Wishart is a direct threat to his child, but I do believe he needs a lot of help with anger management and with knowing how to deal with extraordinary emotion that comes out at him unexpectedly and where that goes. And like I said, these are recommendations that are coming from professionals that I believe have a clear understanding of who these people are. I'm also struck that given all of Mr. Wishart's attempts, and while it is true we've had a relapse and dishonesty along the way, I don't deny that. I am struck that with the number of negative tests we have, that there's very little acknowledgement of that from the other party. A constant lack of belief that he's doing these things and demanding more evidence and more evidence and more evidence. And again, I understand the lack of trust given their marital history and given the level of dishonesty. But I think to discredit the amount of work that is being done towards trying to improve is disappointing. Other than that, I stand on my report, and I would recommend that we listen to the experts who got involved with this case.
I appreciate that. I do have one follow-up question. Do you know, were you contacted at all by anyone regarding the Cowlitz tribal evaluation for Mr. Wishart?
No, Your Honor. And in fact, I received that documentation at the same time that everybody else did. I have not had contact with anybody there.
Okay. Ms. McLean, any questions for Ms. Kale?
No.
Ms. Baldwin?
No, Your Honor.
Okay. Thank you very much. Ms. McLean, any other comments?
The only thing that I would come back with is if you go to Olivia Lovely's evaluation, she is recommending that he participate in a domestic violence intervention with Washington State Certified Program. And I misspoke. It is 26 weekly groups, individual sessions for 6 months. My client is
attempting to see if the tribe could accommodate that, perhaps at a lesser expense. I'm still waiting to hear back from that. But here's the bottom or the last sentence of her recommendation on page, I think this is, page 1. This program is recommended for individuals who have met the criteria for a level 1 program, which is considered a low risk program. It's a low risk program. And that's because when you read through her evaluation, she specifically found, and this is in this paragraph above that, the information obtained through this evaluation indicate that Mr. Wishart is not a primary aggressor, but counsel wants to hang a DV tag on him. Obviously, individuals can always benefit by additional classes, by, kids don't come with manuals, behavioral interchanges with other individuals don't come with manuals. So everybody can always gain by having some more tools in their toolbox through outside education. The same could be said of Ms. Wishart, because she was the other partner that was involved in this. So is Ms. Wishart that primary aggressor? Ms. Lovely, who evaluated Mr. Wishart, found specifically that he is not a primary aggressor. So he does not qualify for that DV tag, and she has not recommended domestic violence treatment. She's recommended an intervention program, which is for a low risk individual. The other thing is, counsel argued that my client has no expenses. My client is paying her vehicle payment, his vehicle payment, their joint automobile insurances, the family health insurances. He's paid the attorney's fees that this court has ordered to her. He's paid copious amounts of spousal maintenance on a short-term marriage. He is covering treatment expenses, UA expenses, his own attorney's fees, guardian ad litem fees. To suggest that my client has a money tree in the backyard is complete fiction. My client is struggling financially. And the more we load on him, and if he's not able to meet those financial components that go with whatever we load on him, we're potentially setting him up for failure. I totally agree with Ms. Kale. Opposing side completely has blinders on as it relates to the good things that he's doing. And I think that that's part and parcel with her attitude coming into this, that she does not want this child to have a relationship with her father. And she withheld this child for a protracted period of time. So we're asking the court to move this forward and provide for the visitation schedule that we've asked.
Right. Anything further, Ms. Baldwin?
Only in the sense of Ms. Love's report. Ms. Lovely is a domestic violence it's a domestic violence evaluation that recommends 26 weeks, 6 months of treatment. That is domestic violence treatment. That's the reality of it. I think you can't parse around that as much as we may try to wordsmith it that way. And my client does acknowledge and the things that he's done. And that's why she says, yeah, guardian ad litem's right as to phase 1 and phase 2. Let's move along. That is my client's acknowledgement. I don't think my client should have to be in a position of sort of congratulating him. What she's saying is, yeah, you've done good work. You have work to do. And that's why we should move towards the guardian ad litem's recommendation. So again, my client isn't sort of saying, no, don't adopt any of this. Don't move forward. My client is saying, yeah, guardian ad litem's right. Let's move along. I think that she should, this sort of idea that she hasn't acknowledged, I don't think quite matches with her declaration that says that the guardian ad litem's right.
All right. I thank you, everyone. I appreciate that everybody's comments. I appreciate the report is very thorough, covers a lot of issues, different concerns that everybody has. I've reviewed it a couple different times, and to be very frank, the notes that I made when I reviewed everything that was submitted were adopt phases 1 and 2 of GAL report, allow GAL and respondent to communicate with Cowlitz tribe to see if it changes anything with the recommendation, enter the support order. So those are the notes that I made for myself. I don't normally just share those outright, but that's kind of where I landed. I did review again Miss Lovely's report based on the comments in Mr. Wishard's submission, and after reviewing the GAL report, because I did recall what Miss McLean pointed out, that that there was that he doesn't appear to be the primary aggressor. And that may very well be the case. I'm not going to assume that he's, I'm not going to assume anything, frankly. What it does say is that their treatment is needed. So I think treatment is needed. Does it have to be the specific treatment through Miss Lovely? I don't think that it does. I think if there's other options for him to take, because to me, it appears to be kind of a anger management, domestic violence sort of hybrid situation that needs to be addressed. And so I do think that is appropriate. I am going to ask that there be an ROI for Cowlitz Tribe to the GAL and Miss Wishard for any collateral input, because we are on his third evaluation at this point. All of these evaluations should have been with collateral contact. And frankly, I don't recall if the second one at Kaiser was, and it doesn't matter anymore because he moved on from there. So there is a little bit of concern that the court has, and I could be completely off base, but it does sort of hint at I'm shopping around to get an evaluation that works best with my schedule and what I think I want to do. If that's incorrect, then, please tell me I'm wrong. But at this point, I don't have anything to show otherwise. And now all of a sudden we've landed at an evaluation that is drastically truncated the type of treatment that is needed. And we have no indication that collateral contact was allowed for that. So I would like that to happen. And if it doesn't change anything, great. Then he's already working on his treatment. If it does change something, great, we'll deal with that. I do think that there are other programs for domestic violence. I know that there's online programs that are available. I had another case where someone did a 52-week online program. It was much more cost effective and frankly had a lot of really good information. We're not looking at a 52-week program here.
Do you know who that was with? Could you provide that information or tell me?
I can try to look for it. It was,
okay.
I'm trying to think of the attorney who worked with their client to get that set up so I'll think about that. And if I remember, I'll email both the parties and Miss Kale. But it ended up being a program that was approved by the Washington State healthcare provider, like it was something that was an approved program through our state. And they were able to do it online and it was measured. So it wasn't like you could go on and do 52 weeks of sessions in a month. It was, I think you could maybe get it done a little quicker than a full year, but it was still sort of a progressive thing. So I'll try to recall who exactly that was. And there was not I think it was a one-time cost and it wasn't substantial. So that may be a better option. And I'm assuming that they have other programs other than just a 52-week program. So I'm not super concerned that it has to be with Miss Lovely at $35 a pop. I think, if we can find some other program, even if it is virtual, that would be appropriate. So I will adopt 1 and 2, phases 1 and 2. I do want to indicate that as far as phase 2 goes, so there's the 1 4-hour visit for that week, and that would be essentially the start of unsupervised visits, and the 1 overnight that would be on the first day and end on the second day. what I'd like to look at is making that a 2 overnight. So with the change that phase 2, you get a 1 4-hour visit and 1 2 overnight visit. All the other requirements, so maintaining UA, testing, demonstrating sobriety as far as any UAs that are requested or any concerns, all that would remain in place.
Can we provide for some holiday time?
I do see that there was some suggested holiday schedules outlined in the GAL. So, Father's Day with dad, Mother's Day with mom, and then suggested timeframes. It says Thanksgiving with dad even, mom odd, Christmas Eve, mom even, dad odd, Christmas Day even odd. I don't know if
So my recommendation is what I do when somebody's on a phased plan is basically say you adopt sort of the guardian ad litem's broad strokes, and then Mr. gets a time period that's equal to whatever his phased program is. So if he's currently at 4 hours, he gets a 4-hour visit. If it's his year for Thanksgiving, if he's at an overnight, he gets an overnight, whatever it is, it just sort of matches on an even odd sort of alternating basis as the guardian ad litem recommended.
So what is the visitation for the phase 1?
So phase 1 is my understanding is phase 1 is basically to continue what the current status is. And I guess guardian ad litem can confirm.
That was my
I
understanding.
mean, it doesn't, so what are we at, a 6-hour visit, 4-hour visit?
I thought we were at 6-hour visits at this
We're
point.
at 6. I can confirm.
They're 6-hour supervised by family.
Yeah, that's correct.
All right.
So because Thanksgiving is right around the corner, and I don't know, I guess, Ms. McLean, do you know that your client's work schedule for Thanksgiving?
I don't know that.
And we can try to work some of those details out. If Ms. McLean, if you want to rush the order, and if your honor has time on this Friday, because I know we're super time limited before Thanksgiving. And I'm unfortunately not available next week. So if you want to do it that way, or we could even do it via email if you want to get his work schedule and we can discuss.
So when do we want to do presentation?
I have the 10th, the 14th, or the 28th are the next available dates for me. The 21st, I'm not here, and that's 2 days before Thanksgiving. I don't know if you want to sort it out prior to that.
So the 14th?
I have a funeral on the 14th, unfortunately. I can do the 10th or the 17th.
The 10th is a holiday. We're closed.
Oh, right. 17th?
I'm not here on the 17th.
Recognized Veterans Day on the 10th?
Veterans Day is the 10th, yes. So this Friday isn't available. I noted, I said the 10th, but unfortunately, yes, we're not open.
And I'm sorry, are you available the 17th?
No, we can, if you want to hold one moment, I can see if we can find a special set time for next week that's not the 14th. Is there any other unavailability next week for anyone besides the 14th and me the 17th?
I can't do the 16th. So that's a Thursday. So I can't do the 16th. But otherwise I'm available at the 16th and the 14th.
Okay. So
and I've got a personal appointment the afternoon of the 15th.
So maybe Monday afternoon, if maybe.
The 13th.
Let me just pause you for 1 second. We have Monday the 13th at 1 p.m. for half an hour available. Does that work for everybody?
The 13th at 1.
That works for me.
That is Monday, right? Yes, Monday the 13th at 1 o'clock. Okay. Perfect. Thank you very much. Thank you. Bye-bye.
Thank you.
All right. So Monday the 13th at 1 p.m. for presentation.
All right.
And that'll be there'll be as I'm assuming a Zoom link created, and that'll just be a special set. I just spoke with Miss Paul, and she's going to contact the clerk's office to ensure we can have a clerk available, and barring any issues, 13th at 1 p.m. for presentation.
Okay, thank you.
And then, so I would just ask that along, because so much of schedule phase 2 is associated with his calendaring, that he have to provide for my client with a work
I've got
schedule.
them coming, counsel.
Okay, great.
I've got them coming through January. I'm just put my
Perfect.
fingers on them right this minute, but I'll get them to you for presentation.
Perfect. And then I think, and then I would just ask to make it clear that the domestic violence treatment is either through the outfit that the court referenced, whenever we can get that information, if you can find it, or through another Washington State certified provider. I agree it shouldn't have to be through Ms. Lovely, but I do think sort of apples to apples, it should be a Washington State certified person.
I will, it may have been Miss Winkle's client, but I could be wrong about that, but I will work on that, and hopefully we can have some leeway in the order that it doesn't hold up anything, because I don't, if we can progress to phase 2 sooner than later, I think that's probably best for everybody.
Thank you.
All right, thank you.
Thank you.
Second amended parenting plan from Miss McLean. And it was signed 11/9/23. Just want to make sure. Okay. I got 2 of them and I didn't know, but one of them was a proposed with a work schedule. And there's one with, the one I have has 2 pages of visitation rules as well, attached to it.
Yes.
Okay. Ms. Baldwin, we'll start
Thank
with you.
So if the court would turn to page 3 of the parenting plan, lines 12 and 13, it's talking about essentially having the evaluation from the tribe include collateral contact. And I'd ask the court remove, I think it's the start of the second sentence, the intent is for, and then capitalize the, so it would read the tribe, and then it said shall submit. The idea being that it's not sort of a nice goal to have, that the court did order him to have the evaluation with collateral contact. He can do it with the tribe, but it isn't sort of just a nicety. This is the order.
Any response?
Yeah, no, I guess that's, I don't have any problem with that.
Okay.
So it'll say the Cowlitz tribe shall submit an update after receiving the collateral.
That's what
take out the word to.
I just lined out intent is for the, so it says the Cowlitz tribe lined out to, and then interlineated shall. So the Cowlitz tribe shall submit an update after receiving that collateral information.
That's fine. And then up at C, just so it's clear, because under C1 is essentially the substance abuse portion, and C1 is substance abuse, C2 is domestic violence. So I would ask that the court just interlineate in up at C, right? That second line, it says substance abuse treatment, and if you just interlineated next to it, DV plus substance abuse. So it's sort of clear that we're talking about obligations for both, and then the subcategories are just the clarifications of what he has to do within those realms.
Any issue there?
I guess I would just suggest that it's a domestic or DV information treatment, since that's what was recommended.
I don't think that's what I disagree. That's what the report says.
Okay, so what I've done is I've just put an asterisk after abuse treatment, and I've added and domestic violence treatment as, and then recommended in his, and then added an S to evaluations.
Okay. And so looking at phase 2, I don't disagree with how council laid it out. It's just we're dealing with one of these just truly awful schedules that I don't want there to be confusion on either side. And so I'm asking that the court pen in language that it's based off of his regular schedule and not any other type of holidays or time off. So sometimes what happens is these folks will then take time off and they're like, oh, that creates an additional visitation. It's like, no, that wasn't the intention. The intention is just it's 4 on, 4 off. And that's the schedule we're using to create the visit schedule.
So in general, I would agree with counsel, although there are times when individuals will get a shift change and they'll put them on a completely different shift. And if he provides notice that here's the new shift calendar that I have, then they should be required to do that. I agree that he shouldn't be allowed to unilaterally change his schedule. That would be his choice to work around what his current visitation schedule is. But if his employer says you're now going to be on shift C instead of shift A, he has no control over that. And so long as he provides that updated shift schedule, then the party should be able to continue to work within those parameters.
And I don't disagree. That was essentially my second point. My second point is just that he have an obligation. Council's provided his schedule. I'm asking that he provide it on a monthly basis because to try to catch any changes. And to specifically pen in, sort of like you penned in the holidays below, that he would pen in, and these are the visits for this month, just so that everybody's clear. That, you know, if there's any dispute, we address it up front and not like, oh, now you're not here and the visit's not happening. That provides both people clarity. And then you can add in, and if it changes otherwise, certainly a different shift schedule that should be accommodated. So I guess it would just, you could pen in father's visits are based on the regularly occurring shift schedule. I'd ask that he provide it monthly along with the planned visit schedule. And that if there's a change, he then also has to update it. So I think that that captures everything. And counsel, you can correct me, that kind of both of us said.
So we've already provided his work schedule through the first part of May of 2024. Why do we have to now provide it on a monthly basis? That just seems to me to be abusive and as an attempt to try and create an issue. If there's a question as far as what the visitation is, so what I did was I tried to lay out in paragraph 8 to A that it would be determined by where the father's first day lands. And then up above that, I indicated his first day off work shall be considered the day he comes off of graveyard shift. So it's clear. And if there's any question about that, I mean, right now, she can ask him or verify that those are the visitation days. And they're communicating through our family wizard. So I just think that the suggestion that we need additional language is a little bit of overkill. I do agree as far as him providing updates when there's changes.
Or it looks like it's writing, so I'm not going to add anything.
This is, I think the schedule's been provided. So assuming no changes, I think he doesn't need to worry about providing a schedule until he gets the next, I don't know how many months in advance he gets it, but barring any changes. So what I've added to the end of the phase 2 paragraph before A is visitation is based on father's regularly occurring shift schedule. Any change to his schedule shall be relayed as soon as possible to the mother.
Okay. And then next is down below at section 10, dealing with Thanksgiving break and Christmas. This is not what I propose. I appreciate that I didn't clarify it maybe sufficiently. It's still even odd. Somebody gets Thanksgiving, somebody doesn't this year. Next year, the other person gets Thanksgiving. Sort of when you try to split the baby in this sense, no one ends up with the holiday, and that isn't reasonable. So I'd ask that this year my client be awarded Thanksgiving. Mr. will get it in even numbered years. On the Christmas holiday, I don't have any huge objection to the 2023 noon to 6. I'd ask the court eliminate New Year's Day. New Year's Day is not a child's holiday; it's a party day, and so that doesn't make it doesn't make any sense. I think that puts the child at more risk. And again, it's not a child's day. So Christmas is a reasonable holiday. New Year's Day isn't.
Well, I guess going backwards, I would disagree with counsel. There's a lot of child-focused events on New Year's Day. I believe that there's a walk around the lake that day. That's something that certainly that they could participate in. There's all sorts of different ways that you can celebrate New Year's. So if he has it off, he should be allowed to exercise that time. Normally, as we transition into a full holiday schedule, then it would be one parent would have the front half and the other parent would have the back half, which would include that New Year's Day, New Year's Eve schedule. In regards to Thanksgiving, he has that time off. We're asking that he be allowed to have Thanksgiving Day this year from noon to 6 p.m. She's going to have the balance of the break. And I would note that the court had only ordered as it related to 2023. The court did not make a determination of a holiday schedule moving forward. We've only talked specifically about these 2 vacations. I mean, if we're going to talk about holidays, there's Mother's Day, Father's Day, July 4th, Easter, a number of different things that should be considered. But you indicated we've got holidays coming up. We've got our settlement conference, I think, set in March. So you were addressing just these for 2023. Alternatively, if you're not going to give him Thanksgiving Day per se, then, and just bear with me because I'm working off of the fly since I didn't have this information ahead of time. So Thanksgiving Day, is that the 23rd? Yeah, that's the 23rd. He also has, well, he works day shift on the 24th. So that's why we had asked for Thanksgiving Day, because he works day shift on the 24th. And it looks like, let me find here just one moment, please. So it looks like he works the 24th, 25th, 26th, and 27th.
But he would have already had under this schedule the 20th, 21st, and 22nd. So it's literally then my client gets, so he has those days off. He's getting from the 20th to the 20th or 6-hour visit, because that's where we're at currently. So again, it's like multiple visits within the same week. And again, noon to 6 is the holiday. That's when you're having dinner. So one person's getting it and one person isn't. But if you're doing that, then it's reasonable that it's clear, hey, he got it this year, the other person gets it next year.
Well, the court can decide, assuming you give it to him this year, since he has had such limited time anyway, the court can take that into consideration in determining what the future holiday schedule should look like. But the suggestion that she doesn't have the ability to exercise the rest of that weekend. I mean, families who are separated often schedule on different days for holidays. My client doesn't have the availability to do that, which brings up another question. And that is, so the court has allowed for those holidays, and typically those are family events. Is my client's family available, or can they be present for those holiday times with the child?
We've never said no to that. That was included in the restricted visitation schedule that council drafted. That's an easy fix.
That's not accurate, because currently my client had requested that his sister and brother-in-law be able to attend current visits since they live within the household, and that was a hard no by Ms. Wishart.
To not violate the order.
She has the ability to agree, and it was a hard no by Ms. Wishart. So then
I disagree. We forced these folks to sign something that said, I shall abide. That's actually probably a little bit more strong than a court order, because the parties have said, I'm promising that these are the rules I'm going to abide by, and I'm not going to deviate. So it's like, it's really boxing people in. Again, my client's not trying to be unreasonable here, and I'm happy that the court includes, hey, family on holidays. You bet. That makes sense.
So I'm keeping the proposal as presented by Ms. McLean, a limited period of time on Thanksgiving this year. And I agree, we have not nailed down all holidays. We discussed these because, well, I think we're all aware that things just take time, and it's probably good to address the 3 next big ones at this point. I'm going to leave it as is. I am perfectly fine, though, adding in a little notation that Mr. Wishart's family is can be present at all of those holiday visits, if that's
fine. Disagreed. Never has been a disagreement.
So then the question, well, I guess I'll move on. So then the other question is now that we've moved to 6-hour visits as all one visit, The question is whether the current order provides for sort of this rotation between Ms. Wishard's supervisor, which is Clay, her brother Clay, and then my client's parents. Clay will not agree to visits other than in a public location. And 6 hours and the weather changing makes it really difficult to do a visit in the park or to spend 6 hours in a mall or in a library, especially when we've got a young, busy child. So I guess the question is whether or not the court would consider providing for my client's family to provide the supervision moving forward. And then again, the question is with the aunt and or my client's sister and brother-in-law who also live within the household, are they still required to be absent during those family visits or during his regular visitation?
So one, this is a direct reconsideration. The court made its ruling. It adopted phase 1 and phase 2, and we clarified with the guardian ad litem. Phase 1 is what they're doing now. Yes, was the answer. So we shouldn't be making modifications. Everybody needs to be reasonable with the visit locations, but that includes Mr. Wishart. If Mr. Wishart says my way or the highway, it's only at my location, that doesn't work either. So he has to be flexible that the indoor locations are not necessarily exactly where he wants it to be. Both parties have to be flexible. And again, that's just a direct reconsideration. On the aunt and uncle remaining in the home, I don't have any big issues with that, frankly. I think it's just how the visit supervision rules that are attached to this have been written. If the court wants to add a star to that and say, the aunt and uncle, it's somebody's home, they can be present. It's fine. I think that's reasonable. Again, these were not something that we really discussed. The visit rules were not something we've ever discussed directly. Something that I think council had created previous to this case, and so it's more of a boilerplate type thing. So I'm fine with family who owns the home can be present. That's not unreasonable. The idea that we're not that far from Mr. Wishart's last relapse, it's reasonable that both families still have some eyes on the situation until we get further into treatment and he graduates to phase 2.
Well, there hasn't been any negative comments about the sufficiency of the supervised visitation that my client's parents are performing. And clearly, they're still both providing supervised visitation notes for us. Obviously, in counsel's comment that she has no objection to homeowners being present, my client's sister and brother-in-law don't own his parents' home. And so just, I guess, if the intention is that normal residents within the residence can remain in the household during the visitation, we think that would be appropriate. For whatever reason, Clay is unwilling to come into my client's home to supervise visits. The child has her bed, her toys, her clothing, things to do in that comfortable environment. He's been doing this since March of this year, I think. Where he's having to go out into the community, and 6 hours is a long time, even for an adult within the community. So I guess as we're moving forward, and I agree that this is stuff that we didn't talk about at the time. We've still got a lot of moving parts when we're talking about what we're adopting and what we're not adopting. And so I mean, if I had to file a motion for reconsideration so the court can discuss or consider these real world working issues, then I'll do that. But it just seems to me that it's something that you could probably provide some way in at this juncture, given the number of times that you've seen this case.
And same, I mean, like the order is how council wrote it, and her own request is to change what we both understand what was ordered, without the ability for me to provide my client's input on, hey, that's not what's happening. We offer him X, Y, and Z locations, and he also says no, and sort of puts his foot down and is stubborn. So again, where we are, as the GAL said, keep doing what you're doing. That's what we should be doing. And that's what the order is as written.
Well, I guess the only comment that I'd say as far as the order is written is that the court had given us specific information. I tried to make those changes relative to your order so that I wasn't adding additional language for counsel to make the contrary argument, suggesting that I was adding things that weren't ordered. I chose to bring those to the court's attention now during the presentation.
We have Miss Kale here. Miss Kale, was your, if you don't mind weighing in, and I agree with Miss Baldwin's rendition. What we're currently doing is what you're saying should happen. And I recall you saying yes. Was there any contemplation to expanding the visitors back to including Mr. Wishard's family during phase 1?
I see no issue with Mr. Wishard's family acting as supervisors. I understand the desire to have a fair situation where we have a supervisor from both sides of the family. I think I actually agreed with Ms. McLean stating that he's been doing this since March. He's done a really pretty great job, actually, of honoring all the requirements that have been put on him, so that he can demonstrate he's taking this seriously and that he wants to do well. I don't have any specific reason to say it has to be Clay and it has to be in a public setting and it has to be. I think that Mr. Wishard's family has done a pretty good job of paying attention to what's going on and honoring the rules and taking notes and trying to communicate the best that they can. The fairness issue, you know, that's something to take seriously, but I don't have any direct concerns about Mr. Wishard's family playing that role.
Thank you. Any questions for? Okay. Any other comments then?
If you were going to make those changes, it would be at, I've got to find it, paragraph, page 4, paragraph 8B1.
All right, the one concern I do have, I don't know in my recall offhand of the GAL report if these parties are in a better spot as far as communicating, but there was some, well, no, you need to use my person this time. You can't use your person. There was a lot of that back and forth and disagreements. To avoid that, I don't know if every other visit, it's Mr. Wishard's supervisor, Miss Wishard's supervisor. Is that something that we can agree to?
I haven't seen any issues with that for a while now. There were some initially, but that really died off when Your Honor was kind of like, no, it's okay. Supposed to have some evenness to it. So that seems to have worked itself out.
Your Honor, I can speak to that a little bit based on seeing the communication on Our Family Wizard. They've actually done a really good job. There have been some slight moments of contention, but they've worked through that and handled it pretty well, actually.
Good. I'm glad to hear that. So under AB1, it says, or another approved supervisor. I'm just going to asterisk that and include previously approved supervisors from Mr. Wishard's family. Okay.
I don't know what that means.
Yeah. Are you ordering us to keep doing what we're doing, or are you changing
it? There was already a group of people that were approved from Mr. Wishard's side of the family. So I'm going to reinstate those people. So the previously approved supervisors from Mr. Wishard's side of the family are included in the approved supervisors.
Okay. The only one that I can recall is Sierra.
Is she the only one that was willing from his side? Okay, so
she was the only one that was approved from his side.
Okay, well then I'll just include her name. So what I've done.
There's a gentleman by the name of Jack Slate. I want to say Slate or Slate. I believe he's from Mr. Wishard's list as well.
That's Ms. Wishard's father, I think.
Okay.
Or grandfather or something.
Okay, so I've just asterisked after or another approved supervisor and just written Christina Wishard.
Okay.
So what's the court's intention with that?
I agree. I don't quite understand. I'm sorry.
Just pick from the 3, or are you still
They're working
Right.
together. You just told me they work together to set up, so whomever's available, and hopefully it's relatively equal on both sides. So
Okay, thank
you
you.
were complaining that there wasn't an allowed supervisor for Mr. Wishard family. I'm giving you that request right now. So I don't know why there's confusion.
Sorry. Thank you. That clarifies it for both of us, and that answers every question. All right.
Was there
next-
something else, Ms. McLean?
So my client's parents already are approved supervisors.
I agree.
So, okay.
So if it's more than just Christina Wishard, that's why I wanted to say all previous. So if they're already included in your order, it only says, it only lists Lindbergh. Oh, it does list Jonathan Wishard's parents or another approved. So I added Christina Wishard. So
Okay.
that's everybody. Is that correct? That's willing and agreed upon.
Well, we had two others,
But they weren't agreed upon, right? At this point.
no, they were. I think Mr. Slate and I think there was one other, wasn't, but that's on her side. But
Okay.
But that's okay. That should all other approved. That should work.
Yeah, if they were previously approved, then that's fine. I just added her in because I thought there was just one other. So
is it
I have another
mentioned-
hearing here in 4 minutes. So
My last one's short and should be agreed. Page
Sure.
6.
Okay.
12B. Picking up parent and then dash the parent and just carry it in or designate.
I'm sorry, what?
the picking up parent who's about to start time or their designee, is that what you?
Yes, and any which way you want to put it in there. Around about
And
nine and 10.
after the dash where it says the parent who's about to start.
Yeah, so just making it clear that designees, it doesn't have to be the parents doing the exchange. You did that up at phase 1, just not at phase 2.
Okay.
So the picking up parent or their designee.
That's fine.
All right. Anything else?
Just going back to that last one. So anybody who's residing in my client's household may remain in the household during the visitation.
I think if they live there, I don't have any objection.
I don't have any problem with that either. I know on your visitation supervisor rules, it says, I understand third parties should generally not be present during visitation to ensure my attention is not diverted. No third party is allowed to observe, witness, or evaluate the child and the parent I am supervising unless arranged in advance and by agreement. That's only one that kind of concerned me with that, because I think if grandparents or aunt and uncle want to interact during visitations, I don't know that anybody has a problem with that. And I don't know that we necessarily strike that language under section 9, but I don't think there's any problem with the child interacting with other family members in the home.
Okay, so we can just rely on the clerk's notes to indicate that they may remain present during the visitation.
Yeah, I don't think the house needs to be evacuated before any visitation.
Okay, that's what's been happening. So,
well, that doesn't have to happen anymore. Yes.
Okay.
I'm going to sign this, and Ms. Baldwin, are you okay to indicate approve via Zoom on your signature line?
Yes, Your Honor. Thank you.
All right, I will. And Ms. Kell, are you good with that as well?
Yes, Your Honor. Thank you.
Okay, I will get this to the clerk, and I wish all the parties good luck and happy holidays. I don't know that we're on for anything before then.
4 months later, in March of 2024, they had a mandatory settlement conference, where I'm sure it comes as no surprise that they did not reach an agreement. Then the case is quiet through the spring and summer with no hearings. But Dad is sending in proof of treatment each month, like he was ordered. I'm also assuming that Dad has worked his way up to phase 2 by this point and is having overnight visits with his daughter. Then at the end of October 2024, the parties agreed to a stipulated order over their unresolved trial issues, which is a huge surprise because this means that they come to an agreement without the need for a trial, and I thought that was going to be impossible in this case. It takes over 4 months to finalize the paperwork, but Judge Bashor signs off on the divorce and a final parenting plan. I'm pleased that they didn't try to drag things out with new issues once the original ones started to resolve. I have to assume that things continue to go well as both of the lawyers have withdrawn from the case, and that's the end of things. I wish Dad all the best in his continued recovery, and I hope he continues to take it seriously. It's obvious that both parents love their daughter, so hopefully they can continue to stay out of court. Thank you for watching.